A2 has been rejected, my lord. Friday, first matter. Threat of alienation, please.
Threat of alienation. Entry ಮಾಡ್ರಿ ಇತ್ತ earlier.
Trial court ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ, but please, my lord, before the trial court, please, my lord, a registered document of the year 1950.
My lord, for declaration, appellant has passed away, my lords. So bringing it to the notice of the court, my lords, RFA Friday.
Court notice. ಅದಕ್ಕೆ ಯಾಕೆ ಮೆಮೊ ಕೊಡ್ತೀರಲ್ಲ? ಮೆಮೊ ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು.
I'll file, my.
Not here.
My lord, RFA of
File it in
2008,
registry.
my lord, may be taken up for final hearing. Matter is of 2008. We are for respondent.
ಕೊಡಿ.
Please, next week, any day.
RFA ಗಳು ಯಾವ್ದು ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ. ಕೊಡಿ.
Next week, please.
ಕೊಡಿ, ಹಾಕಿ. ರೀಚ್ ಆದ್ರೆ ತಗೊಳ್ಳೋಣ.
2012 year, my lordship. I have already
2012 ಯಾವ್ದು?
RFA, my lord.
RFA ಕೊಡಿ.
I have already filed early hearing application. It was allowed.
ಆಯ್ತು ಕೊಡ್ರಿ, ಎಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಒಂದು ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ. ಬರೀ MFS ಅವ್ರದೇ ದಿನ ಒಂದೊಂದ್ ಗಂಟೆ ಆಗ್ತಾ ಇದೆ. ಆರ್ಗ್ಯುಮೆಂಟ್.
May make a request.
Page number 11, 29 and 30.
29 and 30.
My lord, serial number 27, my lord.
27 ಅಲ್ಲ, ಇಲ್ಲ ಮೆನ್ಷನಿಂಗ್ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್
But serial number 27 may make a request. My lord.
27 ಮೆನ್ಷನಿಂಗ್ ಇಲ್ಲ. Only for admission and final hearing.
Once it is posted for admission only, my lords. Last occasion, it appears the counsel on record was not taken before the
27
coordinate
ಇಲ್ಲ.
bench.
27 admission ಅಲ್ಲಿ ಇಲ್ಲ.
ಅಲ್ಲ, ಅದು dismissal ಅಂತ post ಮಾಡಿದ್ದಾರೆ, admission ಅಲ್ಲಿ
Dismissal ಅಲ್ಲಿ ಇಟ್ಟಿದೆ, no mentioning. Next.
Lords, I am unable to appear before the court today. Lords.
ಒಂದ್ಸಲ
I have an
ಗೊತ್ತಿಲ್ಲ,
injury in
matter
the
ಇದೆ.
leg.
ಈಗಿಲ್ಲ, ಪರ್ಮಿಷನ್ ಇಲ್ಲ, ಅಡ್ಮಿಷನ್
Very
ನಿಮಗೆ
well.
ಸ್ಪೆಷಲ್ ಏನಿಲ್ಲ.
Very well, my lords. When the
ಅರ್ಥ
matter reaches, I'll make a mention when the matter reaches.
ಅಡ್ಮಿಷನ್ ಅಂಡ್ ಫೈನಲ್ ಲಿಂಗ್ ಇದ್ರೆ ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ.
Lordships, I get it, my lords.
ಆಯ್ತು.
31 to 35.
ಸ್ಪೆಷಲ್ ಕನ್ಸಿಡರೇಷನ್.
32 and 33, my lord. 1 week. 32 and 33 connected, my lord.
ಹೇಳಿ ಏನಾಗಬೇಕು?
1 week, my lord.
23 ಅದರ್ ಸೈಡ್ ಇದಾರ ಇಲ್ವೋ?
ಇಲ್ಲ. ಇನ್ನು
ಆಯ್ತು ನೋಡಿ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಅಲ್ಲ ರೀ, ಅದೇನ ಪಾರ್ಟ್ಲಿ ಅಲೋ ಆಗಿದೆ. 6475 ಓದ್ಕೊ ಬಂದಿರ್ತೀವಿ. ನೀವ್ ಯಾಕೆ ಬಂದ್ ಟೈಮ್ ಕೇಳ್ತೀರಿ?
ಒಂದು ಪರ್ಸನಲ್ ಇನ್ಕಮ್ 1 week.
ಆಯ್ತು. ಲಿಸ್ಟ್ ಇನ್ ದ ಮಂತ್ ಆಫ್ ಡಿಸೆಂಬರ್, ಇದು ಜನವರಿ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ನಾವು ಓದ್ಕೊ ಬರೋದು, ಇಲ್ಲಿ ಮತ್ತೆ ನೀವು ಟೈಮ್ ಕೇಳೋದು.
32 and 33.
32 and 33.
412.
412.
36 to 43.
Serial number 37, my lord.
37 ಹೇಳಿ ಏನು?
Kindly out next week, my lord.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಡೇಟ್ಸ್ ಇಲ್ಲ. ಇವತ್ತು ಕೊಟ್ಟಿದೀವಿ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಕೇಳ್ತೀವಿ, ಇಲ್ದವ್ರು ಇಲ್ಲ.
Next week. Intimation.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Enter ಮಾಡಿ.
ಇಲ್ಲ ತೋಳೆ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್ ಹೇಳಿದ್ರೆ ಯಾರ ಬಾಲಗಂಗಾಧರ್.
41, my lord.
Intimation ಮಾಡಿ.
37 ಇಂಟಿಮೇಷನ್ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಮಾಡಿ.
ಕೌನ್ಸಿಲ್ ಆಲ್ಸೋ ಸಬ್ಮಿಟ್ ದಟ್ he has already intimated this matter on 412.
My lordship, serial number 39, my lordship.
39 ಹೇಳಿ ಏನಾಗಬೇಕು?
Lordship, I have received NOC wakalat yesterday, my lordship, for appellants.
ಯಾರಿಗೆ NOC ವಕಾಲತ್?
For appellants, my lordship.
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್
Please, my lordship.
ಅದರ್ ಸೈಡ್ ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ರಾ?
Please,
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನಾರು ಇದೆಯಾ?
no entry, my lord.
ಎಂಟ್ರಿ ಮಾಡಿರ್ಲಲ್ಲ?
No, my lordship.
Appellant counsel 6 time on the ground that he has received the NOC wakalat and going to file wakalat. ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ?
Today itself filed for
Today itself. And ಹೆಸರು ಹೇಳಿ ನಿಮ್ದು?
Bipin Hegde, my lord.
Bipin Hegde. And if wakalat is filed, show the name of the counsel Bipin Hegde and delete the earlier advocate name from the cause list. List this matter on 412.
Grateful.
My lord, serial number 41, my lords.
41 ಹೇಳಿ.
I'm for the petitioner, my lords.
ಹೇಳಿ.
My lord, senior is not available, my lords.
Not available is not a ground. ಯಾರು?
My lord,
Not
senior.
available is not a ground. Entry ಮಾಡ್ರಿ ಏನಾರು ಇದೆಯಾ?
ಇಲ್ಲ, madam.
Entry ಮಾಡ್ರಿ ಏನಾರು ಇದೆಯಾ?
ಇಲ್ಲ.
ನೀವ್ ಯಾರಿಗೆ?
Petitioner, my lord.
ಅಪಲೆಂಟ್ ಗ ಅದರ್ ಸೈಡ್ ಹೇಳಿದಾರ. VB ಸಿದ್ದರಾಮಯ್ಯ ಇಲ್ಲೆಲ್ಲ ಇದ್ರಲ್ರಿ ಈಗ? ಇಂಟಿಮೇಟ್ ಮಾಡಿಲ್ಲ ಅದರ್ ಸೈಡ್ ಗೆ?
No, madam.
ಇಲ್ಲೇ ಇದ್ರು.
ಈಗ ಇದ್ರಲ್ರಿ ಇಲ್ಲಿ?
ಇವಾಗ ಮೆಮೊ ಕೊಟ್ಟು.
ಮೆಮೊ ಕೊಟ್ಟು ಹೋದ್ರಲ್ಲ, ಈಗ ಇದ್ರಲ್ಲ ಆಫ್ಲರ್ ಹೇಳೋದಲ್ವಾ? ನೋಡಿ ಇಂಟಿಮೇಟ್
My
ಮಾಡಿ.
lord, kindly post it for tomorrow,
ಇಂಟಿಮೇಟ್
my lord.
ಮಾಡಿ ಆಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
Serial number 40,
Both
my
are
lord.
restrained from alienation of the property ಅದು.
Serial number 40, my lord. I'm for the respondent. File the objections, my lord.
ಯಾವ್ದು?
40 and
Serial number 40, my lord. I'm for the respondent.
ನೀವ್ ಯಾರಿಗೆ?
For the respondent, my lord.
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದಿರಾ?
ಇಲ್ಲ.
ಹೇಳಿ ಆಮೇಲೆ ನೋಡೋಣ.
My lord,
ಏನ್ರಿ?
entry ಮಾಡಿದೆ, my lord. I'll file the
ಇಷ್ಟಲ್ಲಿ
objections.
ಇರೋದೆಲ್ಲ 5-6 ಮ್ಯಾಟರ್ ಆಲ್ರೆಡಿ ಅಡ್ಮಿಷನ್ ನಾವು ಓದ್ಕೊ ಬಂದಿರ್ತೀವಿ, ನೀವೆಲ್ಲ ಬಂದು ಡೇಟ್ ಕೇಳ್ತೀರಿ. ಇನ್ಮೇಲೆ ಡೇಟೇ ಕೊಡೋದಿಲ್ಲ.
Serial number
No
49.
mentioning in the early morning ಅಷ್ಟೇ.
44 to
This is the
47.
attitude.
44 to 47.
44 to 47.
48 to 51.
49, my lord.
ಹೇಳಿ
I am for the appellant.
ಹೇಳಿ.
My lord, have taken, my lord, some inconvenience today, my lord.
Side ಹೇಳಿದಿರಾ?
Yes, my lord, informed Basuraj.
Intimate ಮಾಡಿದಿರಿ?
Yes, my lord.
ಯಾರು ಬಹಳ
Basuraj.
ಬಸವರಾಜ್ ಫಾರ್ R1 ಮಾತ್ರ.
Yes.
ಇನ್ನೊಬ್ಬ ಶ್ರೀಹರ್ಷ ಆರ್ ಲೋಂಡೆ
Not appearing, my lord. He is not appearing.
Is not appearing.
Contested respondent is the first respondent. They are the formal.
ಇದೇನೋ ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಇದೆಯಲ್ರಿ?
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, my lord, the suit for partial partition not maintainable have taken defense.
Matter is part heard.
ಹೌದು, ಅಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು, have secured the documents recently, my lord. Issues are framed, evidence are led. Documents, since the documents has not been given before the trial court. My lord, that issue has been answered as
Counsel
negative.
seeks time and also counsel submit that he has already intimated counsel for R1. And R6 counsel is not
Contesting respondent.
testing in the matter. And hence list this matter. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? Ordered.
10 days, my lord, after 10 days.
ಯಾವ್ದಾರ date ಕೊಡು.
28,
28/11.
Yes, my lord.
52 to 57.
Apologies, my lord. Serial number 40, the counsel is present, my lord. He is also appellant, counsel for appellant is present. Start for adjournment.
40.
The lordship
40
didn't
na?
permit. 40.
Appellant counsel, respondent counsel seeks time. Appellant counsel says no objection. List this matter on
Manu,
4/12.
Entry modern it's
Entry matter ಇದೆಯಾ? Entry matter granted earlier is extended till next date of hearing.
52 to 57.
My lord, serial number 55,
Ahead.
I have informed the other side, I need a week's time, my lord,
55.
55.
Appellant counsel seeks time and.
My lord, I am
counsel
for the
also submits that-
respondent.
Huh?
I am for the respondent, I am seeking
Right.
time.
ಅವ್ರಿಗೆ
Yes.
ಹೇಳಿದಿರಾ? Respondent counsel seeks time and counsel for the petitioner appellant also present and says no objection. List this matter on. ಯಾವಾಗ? 4/12.
58. 59 to 62. 63 and 64. 230 matters.
Remaining all 230 matters.
This one, orders matter, serial number 1. Cyril Prasad Pais.
Non-payment of cost of
Needful
rupees
is done.
10,000 at registry.
Paid, my lord, needful is done.
Huh?
So, first, the
ಕೊಟ್ಟಿದ್ದೀರಾ?
first, so for the first case is concerned, I deposited 10.
Appellant counsel submit that he has deposited the cost imposed by this court of rupees 10,000.
Yes,
ಇದು ಇಲ್ಲಿ ಇಲ್ವಲ್ಲ, ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿದೆ? ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಆಗಿರೋದು ಯಾವಾಗ?
last time,
ಲಾಸ್ಟ್ ಟೈಮ್
I
ಇಲ್ವಲ್ಲ?
was unable to come on.
5,000 ಅಂತ ಹೇಳಿ ಇಲ್ವಲ್ಲ? 10,000?
My lord, there are two appeals, my, I think they recorded on the other,
ಬೇರೆ ದಿವಸ.
both appeals, my lord, 10,000 each. The first, my lord, I am for the appellant, in that I have
ಎರಡು
deposited.
ಕೇಸಲ್ಲೂ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಿರಾ? ಇವ್ರು ಯಾರು? ಸಿದ್ದಪ್ಪ ವಿಡಿ. ಹಾ, ಕನೆಕ್ಟೆಡ್. ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಇದೆಯಾ? Diligently and earlier also this court made it clear that no further adjournment will be given on perusal of the entire order sheet. It discloses that on many occasions the matter was urgent at the request of the counsel for the appellants only. Hence, instead of dismissing the appeals, the same are urgent on cost of rupees 10,000 each payable at registry if cost is not paid and filed. ಆಯ್ತು, ರೆಡಿ ಇದೀರಾ ಆರ್ಗ್ಯುಮೆಂಟಿಗೆ? ಆರ್ಗ್ಯುಮೆಂಟಿಗೆ ರೆಡಿ ಇದೀರಾ? ಬರೀ ಕಾಸ್ಟ್ ಕಟ್ ಬಂದಿದ್ದೀರಾ? ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ?
ಅವರು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ ಇನ್ನೊಂದು.
ಅವ್ರು ಮಾಡ್ಲಿ,
ಆಯ್ತು.
ಅದಕ್ಕೂ ಇದಕ್ಕೊಂದು ಸಂಬಂಧ ಇಲ್ಲ. ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ ಬಿಡಿ.
ಒಂದು ಡೇಟ್
ಅರ್ಜೆಂಟ್ ಆಗಿರೋದೇ ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಮೇಲೆ.
ಡೇಟ್
Totally. Deposited and first matter totally deposited the amount and in connected appeal, counsel submits that he is going to pay the cost today. And hence both of them request for final argument, final argument and list this matter on 4/12. ಕಟ್ಬೇಕು ಇವತ್ತು, ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್
ಆಯ್ತು, ಮಾಡ್ತೀವಿ sir.
ಆಯ್ತು. Next 2,
Serial number 2.
non furnishing of PF. Three ಏನು ತೀರ್ಕೊಂಡಿದಾರಾ? 3 ಏನು ತೀರ್ಕೊಂಡಿದಾರಾ? ಅವ್ರಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರಾ?
ಸತಿ ಹಾಕ್ತೀನಿ ಅಂತ.
ನಾಟ್ ಟೇಕಿಂಗ್ ಸ್ಟೆಪ್ಸ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಬೇರೆ ಇದೆ. ಲಾಸ್ಟ್ ಟೈಮೇ ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಅದೇ ಡೀಟೇಲ್ ಸಿಕ್ಕಿದ್ರೆ ಎಲ್ಲರಿಗೂ ಸೇರಿ ಪೇಪರ್.
Issue notice on IA 192, this is respond number 4. Learned counsel for the appellant seeks time to take out paper publication against respond number 3. Paper publication 24/10 ಡೇಟ್ ತಗೊಂಡಿದ್ದೀರಲ್ರಿ?
ಅದೇ
Since already 3 times notice was issued against them,
ಡೀಟೇಲ್ ಸಿಕ್ಕಿಲ್ಲ.
ಡೀಟೇಲ್ ಸಿಗೋದಿಲ್ಲ. ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಳಕ್ ಡೀಟೇಲ್ಸ್ ಏನ್ ಬೇಕು? Hence time is granted to take steps. The learned counsel for the appellant is granted 2 weeks time to bring the legal representative ಕೊಡೋಣ time. But why you have not filed an application for paper publication?
ಎಲ್ಲಾರ್ಗು ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳೋಣ.
ಎಲ್ಲಾರ್ನು ಒಟ್ಟಿಗೆ ಆಗೋದಿಲ್ರಿ? ಅದನ್ನು ಇದ್ರಲ್ಲೇ ತಗೊಳ್ತೀರಾ?
ಹೌದು.
ಫಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು. ತತ್ವನಿಗೆ ಡೀಟೇಲ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಲ್ರಿ ಪೇಪರ್ ಪಬ್ಲಿಕ್ ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ ಆಯ್ತು ತಗೊಳ್ಳಿ ಇದೇನ ಮತ್ ಪಿ ಎಫ್ ಬೇರೆ ಇದೇನ LRs ಆಫ್ R4 ಅಂತ ಇದೆಯಲ್ಲ ನೋಡಿ ಅದ ಮೇಡಮ್ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಇಲ್ಲ ತಗೊಳ್ಳಿ ದೋ ಕೌನ್ಸಿಲ್ ಸಾಟ್ ಟೈಮ್ ಟು ಫೈಲ್ application for paper publication against respond number 3D and 3E and respond number 5B and 5D not taken any steps and hence ಏನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾ ಏನ್ ಹೇಳಿ ಇವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ರೆ ಇಟ್ಕೊಂಡಿರ್ತೀನಿ ಪಾಸ್ ಓವರ್
Great.
ನೆಕ್ಸ್ಟ್
3.
9 ವರ್ಷ ಆಗಿದೆ ಆಗ್ಲೇ ಇನ್ನೂ ಬರೀ ಪ್ರೋಸೆಸ್ ಅಲ್ಲೇ ಇರಿ
Serial number 3.
PN Putlingaya, dismissal of appeal for non-amendment of cast title and non-filing of typed amended cast title with order dated 5/11/24. Kodi. In spite of matter is listed for dismissal, council has not taken any steps and also not filed amended appeal memo and also not filed amended cast title, and it appears that council is not pursuing the matter diligently. And in view of the order dated 5/11/2024, the appeal is dismissed.
4.
Next, awaiting service of notice in respect of proposed R3. ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿದೆ 7/11.
My lord, I appear for the proposed respondent.
ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
Please, my
ಯಾರು
lord.
ವಕಾಲತ್
We have
ಹಾಕಿ-
been, we'll file the wakalat in the due course of the day, my lord. We have been instructed to.
Council Sri
Vasan Koppar.
Vasan
Koppar.
Koppal.
Koppar.
Koppad.
Please, my lord.
Koppad undertakes to file wakalat for proposed respond number 3.
3, my lord.
Respond number 3. If wakalat is filed, show the name of the council in the cause list. List this matter.
Date may be given.
ಆಯ್ತು. List the matter on
28.
28,
11.
11.
Obligation.
5.
Non-filing of objections with order dated 5/11/2020.
For the respondent.
ಯಾರು ಹಾಕ್ಬೇಕ್ರಿ objection?
ಅವ್ರು ಹಾಕ್ಬೇಕು.
ಹಾ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಾಕ್ಬೇಕು ನಾವು ಅಪಲೆಂಟ್.
ಕೊಡಿ. Counsel for R123 filed. ಏನದು ಏನ್ ಫೈಲ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
Objections to application filed under order.
Objections to objections to ಏನು?
ಅಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ.
Statement of objections ಏನಕ್ರಿ?
ಅಪೀಲ್ ಮೆಮೋಗ್ ಹಾಕಕ್ ಬರಲ್ಲ ಬಿಕಾಸ್
Appeal memo ಗ.
ಯಾಕೆಂದ್ರೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟೇಕನ್ ಪ್ಲೇಸ್ ಮೈ ಲಾರ್ಡ್, therefore I am placing that before.
Statement of objections along with copy of document. Copy served. Copy is also served. List this matter on ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
29/11.
29/11.
Lords, they had in the order sheet, my lords, they were not addressing the arguments that is noted, my lord, from the last.
ಆಯ್ತು.
Lord, what happened is
Objections ಹಾಕಿದಾರೆ ಈಗ ಹೌದಲ್ಲ?
ಸತಿ advocate-
29/11 ಇಯರ್ ಮಾಡೋಣ ಅವತ್ತು.
ಅದು 2020 3 week ಟೈಮ್ ತಗೊಂಡಿದ್ರು ಅಬ್ಜೆಕ್ಷನ್.
ಆದ್ರೆ ಏನಂತ
24 ತಗೊಂಡಿದ್ದಾರೆ ಅವರು ಟೈಮ್.
They have suppressed the facts, my lord.
ಏನು ಸಪ್ರೆಸ್
By virtue of a will.
ಇಯರ್ ಮಾಡೋಣ 29/11.
Please, my lord.
ಇಬ್ರು
Serial number 6. Vijay Krishna Bhatt.
ಕೃಷ್ಣ ಭಟ್ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಏನು ಶೇರಿಂಗ್ ಅಗ್ರಿಮೆಂಟ್.
Respondent,
Bring the LRs of deceased R5 on record.
notice has been served,
Notice serve ಆಗಿದೆಯಾ?
ಸರ್ವಾಗಿದೆ.
Heard on IA number 1/23 and notice issued against LRs of
R5.
R5 are served. Represent ಮಾಡೋರ ಇಲ್ಲ?
ಸರಿ
ಇಲ್ಲ.
ಸರ್ ಒಬ್ರು ಸರ್ವ್ ಆಗಿದ್ದಾರೆ ಇನ್ನೊಬ್ರಿಗೆ ಹೆಲ್ತ್ ಸಫಿಶಿಯಂಟ್ ಆಗಿದೆ.
Are unrepresented and for the reasons stated in the accompanying application and affidavit permitted to bring the LRs on record as sought in IA number 1/23. Appellant counsel is directed to amend the cast title and file amended cast title within 2 weeks from today. ಮತ್ ಬೇರೆ ಇನ್ನೇನಿದೆ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಶೇರಿಂಗ್ ಅಗ್ರಿಮೆಂಟ್ ಅಂತ
The first respondent has undertaken to file it.
It will be filed on the next date of hearing, my lord.
Next
It
date
will
of
be
hearing.
filed within couple of days.
For R123 again seeks time to file sharing agreement and hence finally 1 week time granted.
Interim
Date
order
may
may
be
be
fixed in this
extended.
matter, my lord.
Interim order may be extended.
ಇದೆಯಾ?
ಇದೆ.
Entry order granted earlier is extended till next date of hearing. ಹೇಳಿ ಏನು?
Date may be fixed in this matter, my lord.
ಸಾಕ್ರಿ. 2 ವಾರ ಬಿಟ್ಕೊಡಿ. 4/12.
Great, my lord.
Varun P.
7.
Awaiting service of emergent notice in respect of R1, R3, R4 to 16. ಯಾವಾಗ? 11? 11/11. ನೋಡಿ. Await notice of R1, R3 and R4 to 6. List this matter on 11/12.
8. Prakashvi and
In this case, my lord, there is a discrepancy in.
Discrepancy in date of disposal of impugned case.
Number 17.
ಆಯ್ತು. ಆಯ್ತು. There is a typographical error in mentioning the date and hence the office objection is overruled. ಅಷ್ಟೇನಾ?
Yes.
List the matter for admission on 4/12.
9.
Arun Rao,
For the appellant, my lord.
811 home.
811. Avoid service of notice of R12, R7 and 9. List this matter on
912.
My lord,
912.
9/12. ಹೇಳಿ.
Lord, respondent number 10, the impleading application may be allowed, my lords. My lord, on the last date, my lord, we had actually made
ಮಾಡ್ಬೇಕ್ರಿ
the,
ಈಗ
my lord,
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅಲ್ವಾ?
please, my lord,
ಸರ್ವ್ ಆಗ್ಬೇಡ್ವಾ?
please, my lord.
ಆಗ್ಬೇಕಲ್ಲ?
Right.
ಆಗವರೆಗೂ ಇರಿ. 9.
Lord, an impleading application notice has not served.
Pleading ಬೇರೆ ಇದೆ ಇದರಲ್ಲಿ.
Recently they filed.
Impleading R10 ಅಂತಿದೆ.
Please, my lord.
ಈಗ ಹೊಸದಾಗಿ ಹಾಕಿದೀರಾ?
Please, my lord, actually, we had made R10 a party, but my lords had said that you cannot make them a party because their joinder in the trial court is also pending. So, in trial court, they proposed different number 10. I had made them over here respondent number 10, but my lords,
Issue notice against the proposed R10 also and list this matter 9/12. Notice over ಅದ್ರ ಮೇಲೆ NIA number 4 of 24. Proposed R10 ಗೆ NIA number 4 notice. Next.
10.
Memo along with report filed on 11/11 by council Vachan reappearing for BDA. ಏನ್ರಿ ಅದ್ memo?
I appeared
appellant.
for. ಇದು
ಏನ್ memo
ಸರ್ವ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಇದು BDA ಕಮಿಷನರ್
Last time ಏನೋ ಹೋಗಿ ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿದ್ವಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದೀವಿ.
This, the report is filed along with the memo, my lords.
ಆಯ್ತು. ಯಾವಾಗ ಬೇಕು ಮ್ಯಾಟ್ರ್ ಹೇಳಿ.
ವೀಕ್ ಟೈಮ್
ಫೈನಲ್ ಇಯರಿಂಗ್ ಏನು? ಫೈನಲ್ ಇಯರಿಂಗ್
ಇಲ್ಲ ನೋಡ್ಬಿಟ್ಟು ಸರಿ ಇತ್ತು ಅಂದ್ರೆ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಲ್ಲ, ಇಲ್ಲ ಅಂದ್ರೆ
ಏನ್ನ?
ಅಲ್ಲ ಈಗ
ರಿಪೋರ್ಟ್ ಈಗ
ರಿಪೋರ್ಟ್ ಒಂದು
ರಿಪೋರ್ಟ್ ಯಾರು ಫೈಲ್ ಮಾಡೋದು ನೀವಾ?
Please, I am appearing for BDA, my lords.
ಕಾಪಿ ತಗೊಳ್ಳಿ ನೀವು
ತಗೊಂಡಿದ್ದೀನಿ,
ಕೊಟ್ಟಿದ್ದು.
ಸರ್ವ್ ಆಗಿದೆ.
ಕೊಟ್ಟಿದಾರಾ? ಏನ್
ಕೊಟ್ಟಿದ್ದಾರೆ.
ಟೈಮ್ ಬೇಕು?
ಟೈಮ್ ಬೇಕು.
Counsel for appellant seeks time to file objections to commissioner report. ಬೇರೆಯವ್ರದ್ದೇನಿಲ್ವಾ?
Lordships may.
ನಿಮ್ದೇನೇನ್ರಿ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್?
I'll file my objections.
ನೀವು
I'm
ಹಾಕ್ತೀರಾ?
the contesting respondent.
ನೀವು ಹಾಕ್ತೀರಾ?
ಹೌದು sir.
And counsel for respondent also seeks time to file objections to commissioner report. And hence 2 weeks time granted finally since matter of the year 2009 and list this matter on 4/12.
One submission, my lord.
Yeah.
Lordships may kindly record that order dated 6/9/2013 is complied by the BDA.
Report
Because-
ಹಾಕಿದಿರಿ ಅಂತ ಇದೆ ಅಷ್ಟೇ. ರಿಪೋರ್ಟ್ ತಗೊಳ್ಳಿ. The counsel appearing for the BDA would submit that report is filed in terms of the order dated
6/9/2013.
6/9/2013.
13,
ಆಯ್ತು.
please. Grateful, my lords.
ಬಾಕಿ ಆಗಿದೆಯಾ? ಯಾವ್ದು ಇವತ್ತೇನು ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿಸೋದಿಲ್ಲ ಅದಿರೋದು ಅಪ್ಲೋಡ್ ಮಾಡಕ್ಕೆ ಹೇಳಿ.
11.
11
Yes,
unfinding
Balraj.
of acknowledgement
Yeah,
having
for the
paid the
appellant,
cost
my
of rupees 1,000
Needful is
received
done,
by
my lord.
advocate for appellant. ಏನಾಯ್ತ್ರಿ?
Needful is done, my lord.
Huh?
Needful is done, my lord.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀರಾ?
Yes, my lord.
The council submits that cost is paid. ಏನಾಗಬೇಕು ಮ್ಯಾಟ್ರ್?
Final hearing, my lord.
This the matter for final hearing on 4/12.
12.
CM
CM
Nagabhushan
Nagabhushana.
For respondent.
on filing of appointment having.
4/9/2024
Ah.
has been recalled by this court on 26/9/2024. So the entire order is recalled.
ಕಾಸ್ಟ್ ಯಾರು ಕಟ್ಟಬೇಕು?
ಅಲ್ಲ, ಆರ್ಡರ್ ರೀಕಾಲ್ ಆಗಿದೆ ದಿಸ್ ಕೋರ್ಟ್ ಆನ್ 26/9/2024.
ಈ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿದ ರೀಕಾಲ್ ಆಗಿದೆಯಾ?
ಹೌದು.
ಕೊಡ್ರಿ.
26/9/2024.
26/9/24 ಕೊಡಿ. 4/9 ಆದ್ಮೇಲೆ 26/9/4. Recall the order dated 4/9. This application is not seriously contested by the contesting respondents. Accepting the cost shown, the order dated 4/9/20 is recalled in entirety. ಮತ್ತೆ ಹಾಕಿದ್ನ ಆರ್ಡರ್ ರೀಕಾಲ್ ಮಾಡಿದ್ಮೇಲೆ ಇವ್ರು ತೋರಿಸಿದ್ರು
ಅದು ಏನೋ ತಪ್ಪಾಗಿದೆ ಕೋರ್ಟ್ ಆಫೀಸರ್. Your lordship may post it for a final hearing.
ನೋಡೋದೇ ಅಲ್ವಾ? ತಗೊಳ್ಳಿ. The order dated
lordship may fix a date
4/9/24
for
already
final
been
hearing.
recalled. Wait, order dated 26/9/24 and hence question of payment of cost doesn't arise. The matter for final hearing on 4/12.
Much obliged.
ಏನೋ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಸಿನಾಪ್ಸಿಸ್ ಅದೇನೇನೋ ಇದೆ.
Synopsis ಆಗ್ಬಿಟ್ಟಿದೆ.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ 13.
30.
My lord, I appear for the appellant.
Raised on IA 1 of 24.
My lord.
Pisaruda.
Copy served and my lord,
My lord,
Wakalat also has been filed.
My lord, for I appear for the my lord rest.
A one of 24 entry, 2 of 24 entry,
My lord, may I make small submission, my lord, please?
R 15, 16.
My lord, I
My
will
lord.
undertake to one minute, sir. I will undertake to appear for LRs of respondent number 15
15.
and my lord 16. My lord, I have already filed my wakalat for respondents number 16A and B.
Hmm.
And I will file wakalat for 15A, my lord.
15 Gobre ಇರೋದಾ A?
15 Gobre.
The counsel appearing with the appellant would submit that he has served the copy of A number 1 of 24 and A number 2 of 24. The counsel Sri Balagangadhara.
Please,
Balagangadhar submits that he has already filed wakalat for LRs of
15, my lord.
R 16,
Yes,
A and B na?
please, my lord.
A and B and going to file wakalat on behalf of R 15A.
Please.
ಯಾವಾಗ ಹಾಕ್ತೀರಾ?
My lord, I will file it in the office.
Ah.
And so far as the LR applications on
ಗಾಡಿ ಬರಕ್ allow ಮಾಡ್ಬೋದಾ?
ಮಾಡ್ಬೋದು sir. ಅಲ್ಲ ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಮಾಡ್ಬೋದು sir.
ತಕರಾರು ಇಲ್ಲಲ್ಲ?
ನಮ್ದೇನಿಲ್ಲ ಬರ್ಬೋದು.
No objection.
And hence, A number 1 of 24 and A number 2 of 24 are allowed since the other side also not disputing the same.
Please.
Appellant counsel is directed to amend the cast title in terms of A 1 of 24 and A number 2 of 24 within 1 week from today.
Please.
And file amended cast title. Iದೇ
Please.
memo reporting death of R 17 on ಬೇರೆನೇ ಇದೆ.
ಅದು ಮೆಮೊ ಹಾಕಿದ್ದೇವೆ, ಲೀಗಲ್ ಹೇರ್ಸ್ ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್ ಇದ್ದಾರೆ.
ಹೇಳಿ.
May I make a submission?
ನಾ ಒಂದ್ ನಿಮಿಷ ಕೇಳಿ ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ ತಕ್ಷಣ ನಿಮ್ದು ಕೇಳ್ತೀನಿ. ಕೋರ್ಟ್ ಯಾರ್ಯಾರು ಎಲ್ಲಾರು ಹೇಳ್ರಿ.
My lord, the legal heirs of respondent number 15 and 16 are the LRs of
15 and 16 ಅವರು ಕೂಡ ಸತ್ತೋಗಲ್ಲ.
ಅಲ್ಲ 50, ಅದೇ LRs of 15 and 16. Now they have been brought on record.
Ah.
They are the legal heirs of 17.
ಅವ್ರುನು
ಹಾ.
ಏನ್ರಿ ಮೆಮೋಗ್ ನಿಮ್ದೇನ್ ಕರೆಕ್ಟಾ? R7
ಹೌದು, ನಮ್ದು.
R17 ಸತ್ತೋಗಿದ್ದಾರೆ. R7 ಗೆ ಲೀಗಲ್ ಹೇರ್ಸ್ ಈಗೇನ್ R15, 16 ನೀವ್ ಹೇಳ್ಬೇಕ್ರಿ.
15, 16 ಗೆ
ಅವರೇ ಇವ್ರಿಗೂ ಕೂಡ ಎಲ್ಲ
ಮೂರ್ ಜನ ಅಣ್ಣ ತಮ್ಮಂದ್ರು ಅವರು. 15, 16, 17 are the brothers.
ಬ್ರದರ್ಸ್.
17
ಆಯ್ತು.
died without
please.
any issue.
Appellant
Hello.
counsel files memo stating that legal heirs of R15, 16 are also the legal heirs of R17.
please.
And the other side also not objects the same and hence the memo is accepted. Appellant counsel is also directed to amend the cast title in terms of the memo
Please.
in respect of R17 also. ಈಗ ಹೇಳಿ ಏನ್ ನಿಮ್ submission.
My lord,
Simple submission, my lord.
ಹಾ.
So when concerned to R1B, my application for vacating the interim order consent is pending.
R1B na.
My lord, small submission because my lord, my kindly peruse this photograph. I will not put up any further construction. My lord, first floor portion which is uncompleted, so plastering ಹಾಕೊಂಡು ನಾನು ಆಕ್ಯುಪೈ ಮಾಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಕೊಡಿ ಸಾಕು ಸರ್. ಫಸ್ಟ್ ಫ್ಲೋರ್ ಪೋರ್ಷನ್
my lord,
ಲೆಫ್ಟ್ ಸೈಡ್ ಇರೋ ಬಿಲ್ಡಿಂಗ್ ಸರ್ ಹಂಗೆ ನಿಂತಿದೆ.
my lord, as far as this application is concerned, your lordship,
Floor portion, I will not put up any further construction.
your lordship has already heard the
Actually, my
matter.
lord,
Then my lord, your lordship made it very clear that it will be taken up along with the main. My lord, as far as the house are concerned, all the persons, my lord, all the contesting respondents are having sufficient place for abode. And my lord, even they have rented out several premises. And now this one also they are trying to construct and they wanted to rent it out. My lord, I have serious objections. My lord, it may be heard finally. Date may be fixed. My lord, only for these reasons it was held back.
my lord, we will not let out, my lord.
My lord, R5 is.
Vacating entry ಮಾಡಿ ಹಾಕಿದ್ದಾರೆ.
Yes, my lord, your lordship, already there is an order.
My lord, you
ಇಲ್ಲೇ ನಾವು ನಾನ್ ಟೇಕಿಂಗ್ ಸ್ಟೆಪ್ಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್.
Yes, my lord.
R5 ಬೇರೆ ಇದೆ.
Last date they reported, my lord, I tried to collect the information, they have not yet furnished.
5.
R5 is concerned. In 2 days I will take this.
R5 ಯಾರು ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ರು ಹೇಳಿ.
R5 ಗೆ ನಾನು
Shankar Reddy.
I prefer.
ಇಲ್ಲೇನ ತಾರೇಶ ಫಾರ್ R3, R4, R5 ಅಂತ ಇದೆ.
I prefer. Five, my lord.
5 ಗೆ
Five.
ಒಂದು ಯಾರು ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಡೆತ್ ನ.
ನಾವೇ ರಿಪೋರ್ಟ್
ಏನ್ ಅವ್ರು ತರ್ಸ್ಕೊಂಡು
Details ಬೇಕು.
ಎಲ್ಲರ್ಸ್ ವಿಲ್ ಫೈಲ್ ವಕಾಲತ್
ಯಾವಾಗ ಹಾಕ್ತೀರಿ?
ನೆಕ್ಸ್ಟ್ ಡೇಟ್
ವಕಾಲತ್ಗಿಂತ ಮುಂಚೆ ಅವ್ರ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು.
ಹಾಕ್ಲಿ
ಫಸ್ಟ್ ಅವ್ರಿಗೆ ಡೀಟೇಲ್ಸ್ ಕೊಡಿ. R5 ಡೀಟೇಲ್ಸ್ ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಮೆಮೋ ಹಾಕೋಗ್ಲೇ ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿರ ಮಾಡ್ತಿದ್ರಲ್ಲ.
ಫರ್ನಿಶ್ ಡೀಟೇಲ್ಸ್
ಹಾ.
Can be heard finally, my lord.
ಫಾರ್ಮಾಲಿಟೀಸ್ ನೆಲ್ಲ ಕಂಪ್ಲೀಟ್ ಮಾಡೋಣ. ನೀವು ನೆಕ್ಸ್ಟ್ ವಕಾಲತ್ ಎಲ್ಲ ರೆಡಿ ಇಟ್ಕೊಳ್ಳಿ.
ಆಯ್ತು.
ಆಯ್ತಾ? ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ of this appeal since this is a matter of the 2012 and list this matter next week alla kodri.
22.
11 ಎಲ್ಲಾರು ರೆಡಿ ಆಗಿ ಬನ್ನಿ ಅವತ್ತು.
Much.
ಇಲ್ಲ ಸಾಟರ್ಡೆ ಹಾಕೋಣ 23rd ಸ್ವಲ್ಪ ಫ್ರೀ ಇರ್ತದೆ. ದಟ್ ಇಸ್ ಬೆಟರ್.
23rd ಒಂಚೂರು
23rd
ಕಷ್ಟ ಇದೆ. 22.
ಡೇಟ್ ಬೇರೆ ದಿವಸ ನಿಮ್ಗೆ ಎಲ್ಲ ಬರೀ MFS ಇರುತ್ತೆ, ಆಗಲ್ಲ. ನಾನು ಅದಕ್ಕೆ ಏನ್ ಮಾಡಿದೀನಿ 23rd ಬರೀ RFS ಗಳನ್ನ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ. ಯಾವ್ದು ಹಾಕಿಲ್ಲಲ್ಲ ಮೇಡಮ್? 23rd ಯಾವ್ದು MFA ಗಳು ಹಾಕಿಲ್ಲಲ್ಲ?
ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇದೆ.
ಸ್ವಲ್ಪ ಕಡಿಮೆ ಹಾಕಿರ್ತೀವಿ. ಮುಗಿಸ್ಕೊ ಬನ್ನಿ, ನಿಮ್ಗೆ ಅಕಾಮಡೇಟ್ ಮಾಡೋಣ.
ನಮಗೂ ನಂಗೂ ಅವತ್ತೊಂಚೂರ
ಅಂದ್ರೆ ಈ RFA ಗಳು ರೀಚ್ ಆಗಲ್ಲ, ಇವ್ರು ಬರೀ MFA ಗಳನ್ನೇ ನಾವು ಡಿಸೈಡ್ ಮಾಡೋದಾಗುತ್ತೆ. ಅಟ್ಲೀಸ್ಟ್ 23ನೇ ತಾರೀಕು ಒಂದ್ ನನ್ಗೆ ಏನಂದ್ರೆ ಒಂದು 10 ಮ್ಯಾಟ್ರ್ ಹಿಯರ್ ಮಾಡ್ಬಿಟ್ಟು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಬಿಡ್ತೀನಿ RFA. ಆಯ್ತು, ಬಂದ್ಮೇಲೆ ಆಯ್ತು. ಮೊದ್ಲು R15, 16 ಯಾರಿದ್ದವ್ರು?
ಬೇರೆ ಅಲ್ಲ, ಇದ್ರು ಬೇರೆಯವ್ರು ಇದ್ರು.
My lord, R15 and all, they are sailing with the plaintiff, my appellant.
ಆಯ್ತು, 22.
ಆಯ್ತು.
Copy, Swami MM.
Non-filing of exhibits, 5/11/24 order.
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಬುಕ್
Exhibits ಹಾಕಿಲ್ಲ ಅಂತ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೇನೆ,
ಯಾವಾಗ?
ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ನಿನ್ನೆ ಫೈಲ್
The
ಮಾಡಿದ್ದೀನಿ.
council submits that he has filed exhibits yesterday, and hence registry is directed to put up the same and list this matter for final hearing on
4/12.
4/12.
50.
My lords, for the appellant, my lords,
RP, ಹೇಳಿ.
needful has been done. We have taken the corrected
Placing of etc. to issue as notice for second time respondent. The council submits that
needful has been done, my lords.
CF is paid.
Paid
Issue
today,
notice against the
respondent.
ಒಬ್ಬರೇ respondent.
Only one sole
Respondent.
respondent.
60. Harish Shakshi.
Petitioner, my lord.
Says to be taken for service of notice to R4, R5, R6, R7. ಏನಾಯ್ತು ಹೇಳ್ರಿ?
1 week time, my lord.
Appellant counsel seeks 1 week time. Finally, 1 week time granted.
Submission, ಎಲ್ಲಾರ application pending, ಅದ್ರ ಮೇಲೆ notice ಮಾಡ್ತಾರೆ.
Notice ಹೋಗ್ಬೇಕು.
And issue notice against the LRs of
R9.
R9 on IA number 1/24, 3/24, 2/24, correct?
ಹೌದು.
70.
And list this matter on date ಕೊಡಿ, ಒಂದ್ 3-6 bit 9/12.
70.
17, perusal of letter dated 4/10/24 received from Principal District Judge Kolar along with copy of proceedings. Ready to submit that here with that as per letter cited reference number DA24 has been initiated as Srimati Rupavani, senior solicitor of so and so Kolar, working on deputation basis in the district and Assistant Judge Kolar and senior solicitor in Kolar for carelessness in sending the part of the record invoice number so and so on the file of senior citizen JMFC and file of 5 Karnataka, copy of proceedings number so and so is. ನಾವೇನು ಇದೆಲ್ಲ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ನೋಡಿ ಮೇಡಮ್.
There is a delay in sending the record from the trial court.
That
is why the explanation has been called for.
Explanation call for ಮಾಡಿದ ತಕ್ಷಣ ಅಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ಮುಗ್ದೋಯ್ತು. RSM ಮುಗ್ದೋಯ್ತು.
ಅಲ್ಲಿವರೆಗೂ
ಡಿಸ್ಪೋಸ್ ಆಗೋಗಿದೆ ಮ್ಯಾಟರ್.
ಕೇಸು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
ಹೌದು.
ಎಲ್ಲಿ? ಇಲ್ಲೂ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ.
ಹೌದು.
ಮತ್ತೆ ಇಲ್ಲ ಈಗ ಲಿಸ್ಟ್ ಮಾಡಿರಿ ಇವತ್ತು.
ಕಾಲ್ ಫಾರ್ ರಿಪೋರ್ಟ್ ಅಂತ ಮಾಡಿದ್ರಿ.
ಡೈರೆಕ್ಷನ್ ಕೊಡಿ. ಫೈನಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಫೈನಲ್ ಆರ್ಡರ್ ಸಪರೇಟ್
ಲೆಟರ್ ಸೈಡ್ ಅಷ್ಟೇ ಇದೆ.
ಅದಕ್ಕೆ ಮೊದಲು ಏನು, ಅದಕ್ಕಿಂತ ಮೊದಲು ಮಾಡಿ. ಫೈನಲ್ ಆರ್ಡರ್ ಅಲ್ಲ
ರೆಸ್ಟೋರ್ಡ್ ಅಂತ ಇದೆ.
(22, 2024) order.
This court has received the letter dated 4/10/24 from the principal district judge wherein reported that already initiated the proceedings against the concerned officials and the same is taken on record.
Hearing on again, 18.
For the respondent number 1, 2, 3, madam.
Maybe
bringing
LRs of appellant, copy
ಹೌದು.
serve ಮಾಡಿದ್ರೆ other
ಸರ್ವ್
side.
ಮಾಡಿದೀವಿ,
ಹಾ.
ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ. There
ಏನ್
is one
objections?
ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. ಏನಂದ್ರೆ ಫೈಲ್ ಮಾಡುವಕಾರೆ ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಬೇರೆದ್ರದ್ದು. ಅಲ್ಲಿ ಅಪ್ಲೆಂಟ್ ಲಕ್ಷ್ಮಮ್ಮ ಅಂತ ಆಗಿದೆ, ಅಪ್ಲೆಂಟ್ ರವಿ ಅಂತ ಆಗ್ಬೇಕು ಅಷ್ಟೇ ಆ ಇದ್ರಲ್ಲಿ. ಅದಾದ್ರೆ ಮತ್ತೆ ಎಲ್ಲಾರ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಸರಿ ಇದೆ. ಅದ್ರಲ್ಲಿ ಬರಿಬೇಕಾದ್ರೆ ದಿ ಅಕಂಪ್ನಿ ಅಪ್ಲೆಂಟ್ ಲಕ್ಷ್ಮಮ್ಮ ಅಂತ ಆಗಿದೆ, ಅಪ್ಲೆಂಟ್ ರವಿ ಅಂತ ಆಗ್ಬೇಕು. ಅದೇ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ
Instead of Ravi ಅಂತ.
ರವಿ. ಆಮೇಲೆ ಅವರು
ಯಾರು ಎಲ್ಲಾರು ಇಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ.
ಆಯ್ತು.
Lashmama is not at all the party.
ಪಾರ್ಟೀಸ್ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು
Only objections,
ಅಲ್ಲಲ್ಲ, ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಯು ಆರ್ ನಾಟ್ ಎಲ್ಲಾರ್ಸ್, ಮ್ಯಾರಿಡ್ ಆಗಿಲ್ಲ ಅಂತ,
ಮದ್ವೆನೇ ಆಗಿಲ್ಲ ಅಂತ.
ಮದ್ವೆ ಆಗಿಲ್ಲ, ಮಕ್ಕಳಲ್ಲ ಅವ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
ಮಕ್ಕಳೆಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ.
22 Rule 5 ಪ್ರಕಾರ ಅದಕ್ಕೆ ಅವರು ಏನೋ ಕಾಂಪ್ರಮೈಸ್ ಹೇಳಿದ್ದಾರೆ. ಒಂದು 9ನೇ ತಾರೀಕು ಹಾಕೊಂಡ್ರೆ, ಯಾಕಂದ್ರೆ ಮದುವೆ ಇದೆ ಅವ್ರ ಮಗಳದು, ನಾಡಿದ್ದು 20ಕ್ಕಿದೆ. ಆಮೇಲೆ ಅದು ಆಗದಿದ್ರೆ
ನೋಡೋಣ. Both counsel submits that there is an element of settlement and hence list this matter on ಯಾವ ತೆರಬೇಕು ಹೇಳಿ. 9/12
Obliged.
90.
Delay. Issue notice.
ಎಂಟ್ರಿ ಮಾಡ್ರಷ್ಟೇ.
ಯಾವ್ದ್ರಲ್ಲಿ ನಿಮ್ದ್ರಲ್ಲ ಎಂಟ್ರಿ ಮಾಡೋ granted earlier is extended till next date of hearing. 1/23 delay.
My lord, I am for the
Notice on A number 1/23 and also on mail against the respondent.
My lord, everybody is on record, my lord. ಯಾರು ಇಲ್ಲ ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ನಿಲ್ಲ.
Madam, delay ಇಲ್ಲದೆಯಲ್ಲ ನಿಮ್ಮ
ಇಲ್ಲ, ಅದೆಲ್ಲ ಆಗಿದೆ. ಇಟ್ಸ್ ಫಾರ್ ಟುಡೇ ಎಲ್ಲ ಆಗಿದೆ ಸರ್. ವಿ ಹ್ಯಾವ್ ಕಮ್ ಆನ್ ರೆಕಾರ್ಡ್. ಎಲ್ಲರೂ ನಿಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್.
ಡಿಲೇ ಇದೆಯಲ್ಲ, ಅದೆಲ್ಲ ಆಗಿದೆ ಅಂದ್ರೆ ಏನು ಏನಾಗಿದೆ?
ಮೆಲೋಡ್ ಅಲ್ಲ, ದಟ್ ಹಸ್ ಬೀನ್ ಕಂಡೋನ್ಡ್ ಅಂಡ್ ವಿ ಹ್ಯಾವ್ ಕಮ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂಡ್
ಯಾವಾಗ ಕಂಡೋನ್ ಆಗಿದೆ ರೀ? 1/23 ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿದೆಯಾ ಮೇಡಮ್?
ಲಾಸ್ಟ್
ಡಿಲೇ ಇನ್ ಫೈಲಿಂಗ್ ರೀ ಇದು?
ಅಲ್ಲ, there is no
ಫೈಲಿಂಗ್
delay in filing. My lord, there is no respondent as such, my lord.
ಆಯ್ತು ರೀ, ಯಾರೋ ಇಂಪ್ಲೀಡ್ ಮಾಡಿದಿರಿ ನೀವು?
Earlier
10 ಎಲ್ಲ ಹಾಕಿದ್ರಿ
earlier ಇವರೆಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದ್ರು. ವಿ ಹ್ಯಾವ್ ನೋ ಡಿಸ್ಪ್ಯೂಟ್ ಅಮಾಂಗ್ ದ ರಿಲೇಶನ್ಶಿಪ್.
ಆಗಿದೆ ಆಲ್ರೆಡಿ. ಯಾರಿಗೂ ನೋಟಿಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ನೋಟಿಸ್ ಹೆಂಗಾಗ್ತದೆ?
ಮಾಡಿದೀನಿ, ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟು.
ಇಲ್ಲಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅಂತ ಆಗಿದೆ.
ಅದಾದ ನಂತರ ಬಂದ್ ಮೆಲೋಡ್ ಐ ಹ್ಯಾವ್ ಕಮ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂಡ್
ಕಮ್ ಆನ್ ರೆಕಾರ್ಡ್ ಆಸ್ ಪಿಟಿಷನರ್ಸ್.
ಟ್ರಾನ್ಸ್ಫಾರ್ಮ್ ಫ್ರಮ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಐ ಹ್ಯಾವ್ ಬಿಕಮ್ ಟ್ರಾನ್ಸ್ಫಾರ್ಮ್.
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದ್ರು,
ಹೌದು,
ಈಗ ಟ್ರಾನ್ಸ್ಪೋಸ್ ಆಗಿದೆ.
ಹೌದು,
ಹೌದಾ?
ಹೌದೌದು.
Learned counsel for appellant submit that respondents intend to transpose themselves as respondents and so learned counsel for appellant settlement. In settlement ಏನಾಯ್ತಾ? Propose the settlement.
My lord, absolutely there is no dispute. Whatever the amount, because earlier our P&SC was dismissed.
ಏನಾಯ್ತು? ನಿಮ್ ಟ್ರಾನ್ಸ್ಪೋಸ್ ಅಪ್ಲಿಕೇಶನ್ ಆಲ್ಸೋ
ಅಲೋ ಆಗಿದೆ.
ಯಾವಾಗ ಅದ್ರ ಮೇಲೆ ಇನ್ನೇನು ಆರ್ಡರ್ ಇಲ್ಲ?
ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್, my lord.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಂತಾನೆ ಇದೆ.
ಅದ್ ಮಾಡಿದೆ.
Transposing all respondents. Difference of opinion between there is no subsisting into the dispute so and so. ಆಯ್ತು.
My lord.
ಮೇಲೆ ಹೇಳಿ ಈಗ ಏನು?
My lord.
Delay reasons ಹೇಳಿ.
My lord, earlier
reasons ಹೇಳ್ರಿ.
ಅದೇ earlier
ಕಂಡೋನ್ ಮಾಡಕ್ reasons ಹೇಳಿ.
My lord, earlier I have not filed the legal heir certificate, my lord. Twice it has come with the same reason. I have applied there. It has to be published in Gazette, paper publication and all. It took time, my lord, and all of them are like the appellant senior citizen, my lord. 6 lakhs amount is deposited in the post office. Only because of that.
ಎಲ್ಲಿದೆ ಮೇಡಮ್ ಇದರಲ್ಲಿ? ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿರೋದು ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್? ಏನು ಕೋವಿಡ್ ರೀಸನ್ಸ್ ಹೇಳಿದಿರಿ?
My lord,
ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಯಾವಾಗ ಆಗಿರೋದ್ರಿ?
I will verify, my lord. I will verify.
ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಯಾವಾಗಿಂದು ಒಂದು ಡೇಟ್ ಎಲ್ಲ ನೀವೇ ನೋಡ್ಕೊಳ್ಳಿ ಅಂತಾನ 11th day of August 2020. ಹಾ, ನೀವೇ ಅಪ್ಲಿಕೇಶನ್ ತಗೊಂಡು ನೋಡಿ ಓದಿ ನೀವೇ ಆರ್ಡರ್ ಬರೀರಿ ಅಂತ.
ಇಲ್ಲ, my lord.
ದಿಸ್ ಇಸ್ ದಿ ಸಿಚುಯೇಷನ್ ನೌ. ಫೀಸ್ ಇಟ್ಕೊಂಡು ಫೀಸ್ ತಗೊಂಡು ಮಾತ್ರ ಜೇಬಲ್ಲಿ ಇಟ್ಕೊಂಡು.
ಇಲ್ಲ, my lord. Your honor, it was,
ತೊಗೊಳ್ಳಿ. Heard the appellant counsel on IA number 5 of IA filed under section 5 of the Limitation Act to condone the delay of 264 days in filing the above appeal. And in support of the application, an affidavit is sworn to, and in paragraph number 3, it is stated that the order was passed on 28/10/2000. 28 only. Yeah, in paragraph number 5, it is stated that the appellant filed P&SC number 3 of 2019. And trial judge passed an order on 28/10/2019 without challenging the order filed. Another petition in P&SC number 536 of 2019. And applied copies on 4/1/2023 and the same were delivered on 21/2023 and 17/1/23 respectively, and unable to file the appeal on the above orders within time due to COVID pandemic. And so my age-related ill health. And on perusal of the affidavit, age is mentioned as 76 years, and also though earlier respondents were there, now they have also filed an application for transposing them as petitioners. And also this court has already allowed and amended the petition, and in view of no respondents and also considering the reasons assigned in the application, delay of 264 days is condoned. List the matter for admission on the other date code admission ke
29/11.
29/11.
much obliged.
Urgent 4/12. 29 ತುಂಬಾ ಇರ್ಬೇಕು ನೋಡಿ. 4/12.
20.
ವೆಂಕಟ್ ಸುಬ್ಬರಾವ್. Delay in filing.
307 days.
Other side idara?
May I be permitted to file objections to delay?
Objections ಆಗ್ತಾ ಇದೀರಾ?
Copy.
Counsel for respondent file statement of objections. Copy could have other side and copy is also served. List this matter for admission along with IA on 4/12.
Much obliged.
Non-filing of objections ಈಗ ಹಾಕಿದ್ರ ಅದೇನಾ? Of 24. Next.
21.
Ketan B.
For the
124 days in delay in filing.
Beg to appear, my lords, for the respondent, my lords. I seek my lords permission to appear on BC, not well, my lords.
ಆಯ್ತು ಹೇಳಿ, objections ಏನು ಹಾಕಿದಿರಾ ಹೇಗೆ?
I'll file objections, Lord. It may be taken up on 23rd, my lords. I'll file my objections to that.
ವಕಾಲತೆ ಹಾಕಿಲ್ವಲ್ಲ ನೀವು?
ಜೊತೆಗೆ ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ.
Counsel for the respondent seeks 1 week time to file wakalat and also the objections on IA number 1 of 24. Next, list this matter on 4/12.
Please.
1 week another 2 week ಮಾಡಿ.
Please.
4/12 ಅಂದ್ರೆ 2 ವಾರ ಆಗುತ್ತೆ.
22.
Copy for the respondent, my lord.
Application has been filed.
Calling the order dated 5/3/24. ಏನ್ರಿ ಆರ್ಡರ್ ಅದು? ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಆನ್ IA 1 of 24. ಏನೋ IA ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಬೇರೆ ಇದೆ?
Objection, if no objection, prayer is correct, my lord.
Huh?
What happened is the appeal has been dismissed for non-prosecution. Subsequently, application has been filed.
ಆಯ್ತ್ರಿ 1 of 24 ಏನ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಲ್ಲ ಏನದು?
That is the only the objection office is raising, my lord.
ಏನ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್?
With regard to prayer to be corrected. Prayer is correct, my lord, to restore the appeal.
ನೋಡ್ರಿ ಅದೇನ್ ನೋಡ್ರಿ 1 of 24. ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಿದೆ ನೋಡಿ. ಪ್ರೇಯರ್ ಟು ಬಿ ಮೇಡ್ ಸ್ಪೆಸಿಫಿಕ್ ಅಂತ ಇದೆಯಲ್ರಿ?
Pick ಅಂತ ಇದೆ.
ಏನಂತ ಇದೆ ಪ್ರೇಯರ್ ನಿಮ್ಮದು?
Restore the appeal to its original file. That was the prayer made in the application.
Recall the order ಅಂತ ಹಾಕಿಲ್ವಾ ನೀವು? ಬರ್ದಿಲ್ವಾ?
What happened is, my lord, I have filed one more application to recall the order. That is,
IA not pressed ಆಗರೆ?
Allah, IA 2 has been filed to recall the order, my lord. 2 application has been filed. That is the objection office is raising, my lord.
Is to restore the above appeal.
That is IA 1 of 24, my lord.
Separate. ಎರಡು ಹಾಕ್ಬೇಕ್ರಿ IA?
2 application has been filed.
ವೈ ಅಂತ ಕೇಳಿದೆ.
Only one, I will not press the other application, my lord. Only application, one application,
Call the order ಯಾವ್ದು ಈಗ ಇರೋದು?
5324.
ಈಗ IA 2 of 24 ಒಂದಿದೆ. ಈಗ IA 1 of 24 ನಾಟ್ ಪ್ರೆಸ್ಟಾ? ಹೌದು. ಹಾ. ಹಾ. ಓ ರೀಕಾಲ್ ಆರ್ಡರ್ ಒಂದ್ಸರಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಹಾ. ಹಾ.
Recalling of 5324 order.
5324 ಆರ್ಡರ್ ಏನೇ ರಿಕಾಲಿಂಗ್ ಆರ್ಡರ್ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು. ಹಾ. ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು ಬೇರೆ ಡೇಟ್ ಅಲ್ಲಿ, ಆಮೇಲೆ ಒಂದು ಐ ಹಾಕಿದ್ರು, ಆ ಏನು ಕೂಡ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಮತ್ತೀಗ ಇನ್ನೊಂದು ಐ ಹಾಕಿದ್ದಾರೆ. ಅದೇಗ್ರಿ?
That on that
ಆಲ್ರೆಡಿ
day,
ರಿಜೆಕ್ಟೆಡ್ ಅಲ್ವಾ ಐ? Once again, how can you file an application for recalling? ತೊಗೊಳ್ಳಿ.
council is not keeping well on the said day.
ಎಲ್ಲ ಮೊದ್ಲು ಅದೆಲ್ಲ ಅವಾಗ ಅಲ್ಲೇ ಹೇಳ್ಬೇಕಿತ್ತು, ರಿಕಾಲ್ ರಿಜೆಕ್ಟ್ ಮಾಡಕ್ಕಿಂತ
On that day itself, my lord.
ಒನ್ ಮೋರ್ ಅಪ್ಲಿಕೇಶನ್.
On that day itself, I have stated in the affidavit, my lord.
ಆಯ್ತು, ಅದು ಆರ್ಡರ್ ಆಗಿಲ್ಲ, ನೀವು ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಷ್ಟೇ ಅದನ್ನ. ಯಾವಾಗ ಅರ್ಲಿಯರ? ಈ ಆರ್ಡರ್ ಮೇಲೆ ಐ ಕೆನಾಟ್ ಅಗೇನ್ ಸಿಟ್ ಆಸ್ ಅನ್ ಅಪಲೇಟ್ ಜಡ್ಜ್. ಆಲ್ರೆಡಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಒಂದು ಮ್ಯಾಟರ್ ಇಸ್ ಕಾಲ್ಡ್, ದೇರ್ ಇಸ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ದ ಅಪಲೆಂಟ್ ಅದರ್, ಅವ್ರ ಮುಂದೆನೇ ಹೋಗ್ಬೇಕು. ನನ್ನ ಆಮೇಲೆ ಮತ್ತೆ ಬಂದಿಲ್ಲ, ಸುಮಾರು ದಿವಸ ಹೋಗಿಲ್ಲಲ್ರಿ ನೀವು?
He was hospitalized.
Representation on 15-2 also.
He was hospitalized.
price, my
at
lord.
the set point of time.
Huh?
He was hospitalized at the set point of time. He couldn't appear, my lord. That's what I
Are
stated.
hospitalized
Advocate was appearing on earlier occasion, was on record. I have filed NOC.
on 5/3/24.
Please, my lord.
ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಏನೋ ಹಾಕಿದೀರಾ?
Was not
ಅಡ್ವೊಕೇಟ್
available.
ವಾಸ್ ಹಾಸ್ಪಿಟಲೈಸ್ಡ್ ಅಂತ
He has
ತೋರ್ಸಕ್ಕೆ.
filed affidavit and application thereafter. he has
ಅದನ್ನ
given.
ಹಾಕೊಂಡು ಅದೇ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗಿ ಅಲ್ಲಿ ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡಿ. ನಾನು
Maybe posted.
ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನನ್ ಮುಂದೆ ಬರಲ್ಲ ಅದು.
Please, maybe
The
posted.
council is directed to comply with office objections. On A number 1 of 24. And council also submits that on the date of the rejection of order dated 5/3/24, council was not, earlier council was not feeling well and he was admitted to the hospital. And with that document, the appellant can approach the very same court for recalling the earlier order passed by the court. And
23.
hence register is post the same before the very same bench after filing of documents of admission of the advocate.
23.
ಹೇಳಿ. Grant of leave to the applicant along with statement of objections. ಹೇಳಿ. AF4 already allowed.
How dated? 25.
Non-compliance of office objection raised on statement of
25
objections
for
filed by advocate.
That's the IA number 4 has already been allowed. By considered.
Huh? ಏನ್ ಕರೆಕ್ಷನ್? A 1 of 24 ಅಂತಿದೆ. ಹಾ.
4 ಆಗ್ಬೇಕು. IA 4 of 21.
ಈ ಕರೆಕ್ಷನ್ ಎಲ್ಲ ಏ ಆಗ್ಬೇಕದು. ಅದರ್
3 ಅಂತ ಆಗಿದೆ, 4 ಆಗ್ಬೇಕು.
ಆಯ್ತು, ಈಗ ಕಾಪಿ ಶುರು ಮಾಡಿದ್ರ ಇದನ್ನ ಅದರ್ ಸೈಡ್ಗೆ.
Copy has been served.
ಹೇಳಿ ಏನ್ರಿ?
No.
ಟೈಪೋಗ್ರಾಫಿಕಲ್ ಎರರ್ ಅಲ್ವಾ?
Typographical.
Allow ಮಾಡ್ಬೋದಾ?
Allow.
Sorry, heard the appellant counsel and also the counsel appearing for the respondent on application filed under section 152 of CPC, which is numbered as, number ಆಗಿಲ್ಲ ಮೇಡಮ್ ಇದು? ಯಾವಾಗ ಹಾಕಿರೋದು ಇದು? ಹಾ? ಎಲ್ಲಿದೆ ನಂಬರ್ ನೋಡಿ? ಇದೆಯಾ? ಇಲ್ಲಿ ಎಲ್ಲಿ ತೋರ್ಸೇ ಇಲ್ಲ ಇಲ್ಲಿ? ಬರೀ ತಂದು ಕೊಟ್ಟವ್ರ ಅಷ್ಟೇ. ಅಯ್ಯೋ 1 of 24. ಅಯ್ಯೋ 1 of 24. Wherein prayer is sought to correct the clerical typographical error which has crept in the order dated 25/4/24. Wherever there is a reference to A number 3, the same may be read as A number 4. The counsel appearing for the respondent also not objects the same and also admits that there is a typographical error and in view of the prayer sought in IA, the same is allowed. The registry is directed to correct the same order dated 25/4/24 where there was an error referring IA number 3 and the same may be corrected as IA number 4. Correct? ಎರಡರಲ್ಲೂ ಹಂಗೆ ಇದೆಯಾ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲೂ ಎರಡಯ್ಯ ಇದೆಯಾ ಆಯ್ತು ಎರಡು ಸೇಮ್ ಮಾಡ್ರು ಕಾಮನ್ ಆರ್ಡರ್ RFA 2514/2017 ಅಲ್ಲಿ ಏನಿಲ್ಲ ಅದ್ರಲ್ಲೇನು ಇಲ್ಲಲ್ಲ ಮತ್ತೆ ಎರಡಯ್ಯ ಕೊಟ್ಟಿದ್ದಾರೆ. Why you have filed 2 IAs?
In the connected matter, we are appealing.
Second set same second set ಹಾಕವ್ರಾ 24 K Ananta
24.
production of additional evidence IA will be considered along with main appeal. IA will be considered
Please,
along with main appeal.
Please.
Unregistered sale deed has been produced.
ಆಯ್ತು ನೀವು objections ಹಾಕಿ IA will be considered along with main appeal and also the respondent counsel is permitted to file statement of objections to IA number 1/24.
Please.
In the meanwhile, this matter for final hearing 2010 ಅಲ್ಲ 4/12.
Okay.
In the meanwhile, objections ಹಾಕಿ ನೀವು.
Instead of 4 any other day.
Kept below ಅಂತಿದೆ.
Milord.
PB kept below, TCR also
ಹಾಕಿದೀವಿ
kept below.
ಪೇಪರ್
ಒಂದೇ ಇದೆ ಕಾಪಿ.
ನಾನು ರೀಸೆಂಟ್ NOC ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. ನಾನು ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. ನನ್ನ ಹತ್ರ ಒಂದು ಕಾಪಿ ಇದೆ NOC ವಕಾಲತ್ ಫೈಲ್ ನಾನು ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಏನ್ ಕೊಡ್ತೀರಿ?
ಪೇಪರ್ ಬುಕ್ ಏನಾದ್ರು
ಕೊಡಿ ಅವ್ರಿಗೆ ಒಂದು ಅಷ್ಟೇ. ಅಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ ಇಲ್ಲ ಅಂದ್ರೆ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ. ಒನ್ ಸಬ್ಮಿಷನ್ ಮೇಲೆ
ಹಾ?
ಅಲ್ಲ ನಾನು ಕೊಡ್ತೀನಿ.
ಟೋಟಲ್ ಇಲ್ಲ ಅವರೇ ಕೊಡ್ತಾರಂತೆ.
ಕೊಡ್ತೀನಿ.
ಕೊಟ್ಬಿಡ್ರಿ ನಿಮ್ಮ ಹತ್ರ ಒಂದು
ಕೊಡ್ತೀನಿ.
ಕಾಪಿ ಇದ್ರೆ ಈಗಲೇ.
ಆಮೇಲೆ ಒನ್ ಸಬ್ಮಿಷನ್ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 4th milord any other because last 2 matters also 4th.
ಆಯ್ತು 5/12
6 or 7.
5/12
6 or 7.
ಆಯ್ತು 6/12
Publish.
25. ರಶೀದ್ ಖಾನ್.
ಏನೋ recalling application ಇದೆ.
ಹೌದು.
Recalling the order dated 8/12/22 along with common statement of objections. ಹಾ ಹೇಳಿ ಮೇಡಮ್.
We filed application for recalling the order dated.
ಹಾ ಹೇಳಿ why it was dismissed.
My lord, earlier case was looked after by the
Dismiss
PA order.
ಡಿಸ್ಮಿಸ್ ಆಗಕ್ಕಿಂತ ಮುಂಚೆ ಎಷ್ಟು ಸರಿ ಬಂದಿದೆ ಹೇಳಿ ಮೇಡಮ್. Despite sufficient time granted, paper book is not filed. Paper book ಹಾಕಿಲ್ಲ ಅಂತಲ್ಲ ನೀವು?
Filed, madam.
ಅಡ್ಮಿಟ್ ಹಾಕಿದ್ದೆ ಯಾವಾಗ? ಅಡ್ಮಿಟ್ ಆಗಿದ್ದೆ ಯಾವಾಗ? Without obtaining no objection certificate from the previous counsel. So also no application is filed seeking condonation of delay in filing IA number 1/23. Accordingly, IA number 1/23 is rejected. ಯಾವ earlier ಕೂಡ ಯಾವ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ IA number 1/23?
Earlier council filed a recalling application that was dismissed.
8/12/2022.
ಹಾ ಈಗ ಮತ್ತೊಂದು IA ಹೆಂಗ್ ಹಾಕಕ್ಕಾಗುತ್ತೆ ನೀವು?
2 and 3 ಹಾಕಿ.
ಲಾಯರ್ ಬೇರೆನಾ ಈಗ?
ಹೌದು.
ಹಾ ಮತ್ತೆ? The same is filed by the advocate without obtaining no objection from the previous counsel ಅಂತಿದೆ.
ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ರಿ ಸ್ವಾಮಿ, ಅದು ಪುಟ್ ಅಪ್ ಮಾಡಿರ್ಲಿಲ್ಲ, that is.
With NOC ಹಾಕಿದ್ದೀರಾ?
ಹೌದು.
Here counsel represented and in spite that this court dismissed the appeal. So that was on 8/12/2022.
Weeks time granted to comply the office objection, failing which comply office objections ಅಂತ ಆಯ್ತು. ಆಮೇಲೆ learned counsel for the complaint is permitted to file paper book within 2 weeks ಅಂತ ಆಲ್ರೆಡಿ ಪೇಪರ್ ಬುಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ 10/1/24 ಕೊಟ್ರ ಹಾಕಿದ್ರೆ ಪೇಪರ್ ಬುಕ್ ಹಾಕಿದಿರಿ ಈಗ?
ಆದ್ಮೇಲೆ ಅದು ಹಾಕಿರಿ. After dismissal they filed.
After dismissal ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದಾರ್ರಿ?
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು.
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದಾರಲ್ಲ?
ಪರ್ಮಿಷನ್ ಕೊಟ್ಮೇಲೆ
counsel appearing for the appellant is permitted to file paper book within 2 weeks ಅಂತ ಇದೆಯಲ್ಲ ಆಲ್ರೆಡಿ ಆರ್ಡರ್.
ವಿತಿನ್ ಟೈಮ್
ಆರ್ಡರ್ಗಳು ನೋಡೋದಿಲ್ಲ ಮತ್ತೆ ಸುಮ್ಮನೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಾಡ್ತೀರಾ? Learned counsel for the appellant is absent. One more opportunity is given to the learned counsel to appear before the court if the counsel. Last time ಯಾಕೆ ಬರ್ಲಿಲ್ಲ ನೀವು? ಇಷ್ಟೆಲ್ಲ ಆಗಿ ರಾದಂತ ಕೋರ್ಟ್ಗೆ ಯಾಕೆ ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ 4/11 ಅಲ್ಲಿ?
ಸ್ವಾಮಿ, ಅದು ನಮ್ದು ವಕಾಲತ್ತು ಪುಟ್ ಅಪ್ ಆಗದೆ ಲಿಸ್ಟ್ ಬರ್ಲಿಲ್ಲ.
ನಿಮ್ಮ ವಕಾಲತ್ ಪುಟ್ ಅಪ್ ಆಗಿರ್ಲಿಲ್ವಾ?
ಫಸ್ಟ್ NOC ವಕಾಲತ್ತು ಪುಟ್ ಅಪ್ ಆಗಿರ್ಲಿಲ್ಲ.
ಇದೆಯಲ್ಲ ಇವತ್ತು ಇದೆಯಲ್ಲ ವನಜಾಕ್ಷಿ, ನೀವು ವನಜಾಕ್ಷಿನ?
ಈಗ ಬಂತು ಸ್ವಾಮಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಇರ್ಲಿಲ್ವಾ ನಿಮ್ಮ ಹೆಸರು?
ಹೌದು.
ಆಯ್ತು ಏನ್ರಿ ರಿಕಾಲಿಂಗ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನು ಹಾಕಿದ್ರಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್?
56 days.
Reasons are 200 days delay ಇದೆ.
ಎಷ್ಟು ದಿವಸ ಡಿಲೇ ಇದೆ?
256
days delay. In spite of granting time to apply. And the earlier advocate also appeared.
ಅಡ್ಮಿಟ್ ಆಗಿದ್ದ ಯಾವಾಗ? ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡಕ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದ ಯಾವಾಗ? Advocate for appellant submits that he has no instructions and seeks time ಅಂತ ಆಯ್ತು. ಯಾವಾಗ admit ಆಗಿರುತ್ತೆ ಯಾವಾಗ ನೋಡಿ ಮೇಡಮ್. ಆಯ್ತು ಏನೇ ಪೇಪರ್ ಬುಕ್ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಪರ್ಮಿಷನ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ ತಗೊಳ್ಳಿ. Heard on IA number 2 of 23 and there is a delay of 256 days in filing the recalling application. And IA number 3 of 23 is also filed for recalling the order dated 8/12/22. And record discloses that now matter was admitted on 2/3/2018. And then the matter listed on 8/1/2021. This court granted another 6 weeks time to file paper book and also made it clear that if paper book not filed within 6 weeks, the appeals will be listed for necessary orders. And again, matter was listed on 1/6/21. And as a last chance, 4 weeks time was granted. And once again, matter was listed before the court and counsel appeared and made submission on 8/2/22 that no instructions and seeks time. And again, matter was listed on 22/2/22. At the request of the counsel, 4 weeks time was granted to file paper book and ultimately the appeal was dismissed on 8th day of December 2022. And even though matter was listed, admitted in 2018 and time was given periodically, paper book was not filed and dismissed on the ground that paper book was not filed. However, this court subsequently, when the application was filed, IA was also rejected, IA number 1 of 23 on the ground that no objection certificate was not obtained. And again, IAs are filed and once this court has given time to file paper book once again within 2 weeks. And now the counsel has already filed the paper book, having taken note of conduct and also the delay in filing the paper book and also in filing the application. There is a delay of 256 days and matter was not heard on merits and hence the IAs are allowed on cost of ₹500 each payable at registry and order dated 8/12/22 is recalled subject to payment of cost and appeal will be restored subject to the payment of cost within 1 week. If cost is paid within 1 week, restore the appeal and list the matter for final hearing on 4/12.
26. P. Sheshgiri Rao.
Appointment of trustees.
My lord, I have filed impleading IM.
Impleading applicants as R11A to E. Non taking steps in respect of this is R2, R4, R8, R9.
My lords, they are.
ಆಯ್ತು ಹೇಳ್ರಿ ಯಾರು ಇಂಪ್ಲೀಡಿಂಗ್ ಹಾಕಿರೋದು ಯಾರು?
Yes, my lord.
ನೀವಾ?
I have my.
ನೀವು ಟ್ರಸ್ಟೀಸಾ?
No, my lord. We are co-partners. Co-partners of appellant family. They have left us while filing a suit and also in appeal.
ಈ ಇಂಪ್ಲೀಡಿಂಗ್ ನೀವು ಹಾಕಿದಿರಿ?
Also,
ನೀವು ಆ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಸೆಕ್ಷನ್ ಹಾಕಿದಿರಾ?
served with the copy, my lords.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
we have served through post and thereafter we have filed.
ಪೋಸ್ಟ್ ಅಕ್ನಾಲ್ಮೆಂಟ್ ಇದೆಯೇನ್ರಿ?
ಅದು ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ, receipt ಹಾಕಿದೀವಿ.
ಕೊಡಿ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Through post, I have got the memo, new list of trustees, the memo ಸಿಕ್ಕಿದೆ. ಅದು ಒಂದೇ.
ಏನ್ ಹಾಕಿದ್ರಿ ಮೆಮೋ ಅದು? ನೀವೊಂದು ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ. ಮೆಮೋ ಇದೆಯಾ? ಈ ಮೆಮೋ ನೀವು ಕೋರ್ಟ್ ಹಾಕಿದೀರಾ?
Upon that we have.
ಮೆಮೋ ಎಲ್ಲಿದೆ ಅದು? ಮೆಮೋ ತೋರ್ಸಿ ನೋಡ್ರಿ. ಅದ್ ನೀವ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಪೋಸ್ಟಲ್ ಕಳ್ಸಿರೋದ್ ಎಲ್ಲಿದೆ ರೀ ದಾಖಲೆ?
ಅದು receipt ಹಾಕಿದೀವಿ, ಅದು acknowledgement ಬರ್ಲಿಲ್ಲ.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಟ್ರಸ್ಟೀಸ್ ನೀವ್ ಹಾಕಿದಿರಾ?
Yes, my lords.
ಅಯ್ಯೇ ಕಾಪಿಗೆ ಕಾಪಿ ಸರ್ವ್
Order
ಮಾಡಿದಿರಾ ಅವ್ರಿಗೆ?
22 rule 10, my lords.
No objection from bring your record.
They have only given the list of.
ನಿಮ್ಮನ್ನೇ ತರ್ಲಿಕ್ಕೆ ಹಾಕಿದಾರಾ? ನಿಮ್ದೇನ್ ತಕರಾರಿಲ್ಲ.
We are the trustees, we asked us.
Heard on IA 1 of 24 for appointment of trustees and the same is filed by the appellant ಅಲ್ಲ? And counsel for the respondent ನೀವ್ ಯಾರಿಗೆ? R1 R1 says no objection to allow the application and hence IA 1 of 24 is appointment ಅಂತ ಆಗಲ್ರಿ, bringing ಅಂತ ಬರ್ತದೆ. ನೀವ್ ಹೆಂಗಿಲ್ಲ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೇಳ್ತೀರಿ?
Appointment ಇಲ್ಲ, my lords. We have filed under order 22 rule 10 as the interest as the village.
Prayer ಏನಂತಿದೆ? Please to bring the following persons as the trustees of respondent. ಇವ್ರಿಗೆ ಎಲ್ಲಿ ಸಿಕ್ತ್ರಿ ಇದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ವರ್ಡ್? Prayer is sought to bring the persons who have been mentioned in the application as the trustees of respondent number 1 and counsel for the respondent not filed any objections on content that and submits that they are the new trustees appointed and no objections to bring them on record, and hence IA is allowed. Now, the IA2 for impleading is also filed and counsel for the appellant submits that copy is not served, and hence the counsel is directed to serve the copy
Yes,
of
Lord.
this IA number 2 of 24 on the appellant as well as the first respondent forthwith, and both of them are given 2 weeks time to file statement of objections to IA number 2 of 24.
And also
ಇವತ್ತೇ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕು ನೀವು.
the steps with respect to the respondents mentioned may be dispensed, my lords, as they are no longer the trustee.
And the question of taking steps doesn't arise in view of already IA 1 of 24 is filed before the court regarding death of R2, R4, R8, R9 and R10 with order dated 24/10/24. ಸರಿ ಆಯ್ತಾ? ಕಾಪೀಸ್ ಇವತ್ತೇ ಕೊಡಿ. Objections. This matter on 412. ಏನು dismissal ಅಂತದ್ದು?
Number 27, a mention was made in the morning.
ಹೇಳಿ ಏನು?
ಅದು senior ಬೆಳಗ್ಗೆ mention ಮಾಡಿದ್. My senior, my lord, senior
IA 1
counsel.
for temporary injunction restraining the respondents from transferring suit scheduled properties. IA 2 for restraining the respondents from putting up construction. ಹೇಳಿ ಯಾರು?
So admission ಗೆ case
ಹಾಕಿರೋದೆಲ್ಲ ಯಾರು?
appellant ಹಾಕಿರೋದು.
ಹಾ.
ಎಲ್ಲ admission ಗೆ ಕೇಳ್ಬೇಕು. In the morning, my lord, senior counsel, my lord, made a mention that is not well. He requested for
ಸರಿ ರೀ, ನೀವು ಇದನ್ನ ಅಡ್ಮಿಷನ್ಸ್ ಫೈನಲ್ ಇಯರಿಂಗ್ ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಕ್ ಇರೋದಲ್ಲ. ಹಾ, ಮತ್ತೆ ಹಾ
ಅಲ್ಲ, we are ready with the matter, but ಅವ್ರು ಸ್ವಲ್ಪ ಇವತ್ತು
ಹೇಳಿ ಏನು?
ಒಂದ್ ಡೇಟ್ ಬೇಕು ಅಂತ.
ಯಾವತ್ತು ಹೇಳ್ರಿ? ಏನೋ ಹೆಲ್ತ್ ಸರಿ ಇಲ್ಲ. ಅಯ್ಯ ಹಾಕಿರೋದ ಯಾರು? ಅಯ್ಯ ಮೇಲೆ ಏನಾರು ಆರ್ಡರ್ ಇದೆ? ಅಯ್ಯ ಮೇಲೆ ಏನಾರು ಆರ್ಡರ್ಸ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಇಲ್ಲ, there is no interim order.
ಮತ್ತೆ ಈಗ ಯಾಕೆ ಡಿಸ್ಮಿಸಲ್ ಗೆ ಅಂತ ಹಾಕಿಟ್ಟಿಲ್ಲ?
ಯಾಕಂದ್ರೆ
ಹಾ,
what happened?
ಹಾ.
This is an MFA against the order of the court below under order 39 rule 4. Dismiss vacating the injunction
Order vacate
on
ಆಯ್ತು.
the ground that he had misrepresented facts and he had come to court with unclean hands. That was the finding given by the court below.
ಆಯ್ತು.
He has not challenged those grounds in this MFA.
ಹಾ.
If your lordship goes through the order and the grounds, you'll see he has not challenged that. That particular finding he has not challenged. When it came up before the earlier judge in the earlier, he was not present. So the judge had heard us
Dismissal ಗೆ ಯಾವಾಗ
and then
ಹೋಗಿದ್ದಾರೆ?
kept the matter saying he has not come, he has posted for dismissal, let him come ಅಂತ ಮಾಡಿದ್ರು. ಅದಾದ್ಮೇಲೆ he has come now and he has sought for time on this ground. I leave it to your court, my lord. And whatever IA he has filed, this IA he has not sought in the court below.
No
Whatever relief is
representation,
claiming
no
here, he has not
representation
got.
on behalf of the appellant, learned counsel for the respondent is present. Post this matter for dismissal on 4/9/24 ಅಂತಿತ್ತು. 4/9 ಏನಾಯ್ತು?
ಆಮೇಲೆ thereafter we have appeared, my lords. We have appeared.
4/9 appeared.
At the previous date ಅಲ್ಲಿ ಕೂಡ
Matter on 12/9.
previous date ಅಲ್ಲಿ ಕೂಡ senior counsel he comments the arguments.
List on 29/10/24. Yes sir, ಇರಿ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಿದ್ ಮ್ಯಾಟ್ರು.
ಅಲ್ಲ, ಅದು ರೀಚ್ ಆಗ್ಲಿಲ್ಲ, ಮತ್ತೆ ಮ್ಯಾಟರ್ಸ್ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ.
Documents and also the memo submitted on behalf of the respondent number 13 along with the annexures. Same is taken on record. Copies are also served on the other side.
Not that was after hearing the matters for some time, my lords.
Filed a memo along with documents. The same is taken on record. List this matter on 13/11.
ಅದು after hearing the matter for some time, my lord, they produce the document. Lordships posted the matter today. Today some inconvenience, lordship may fix a date.
Counsel for the appellant seeks time on the ground of ill health, and counsel for the respondent is present, and the record discloses that on several occasions appellant sought time. And this court also in one occasion post the matter for dismissal, and thereafter also matter was adjourned at the request of the counsel, once at the request of the counsel for respondent alle. And also matter was adjourned at the request of the respondent on 4/9/24, 12/9/24.
Senior counsel appears for respondent.
Lords, my sincere apologies, my lords. I had.
ಆಯ್ತು, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. ಯಾವತ್ ಬೇಕು ಹೇಳಿ?
Lords, any date, my lords. I had an injury in my leg, so I could not.
This matter on ಯಾವತ್?
Next week, in a day, my lords, I'll be ready.
ನೋಡ್ರಿ ಮೇಡಮ್.
23rd ಆಗ್ಬೋದಾ ಮೇಡಮ್?
23rd ಆಗ್ಬೋದಾ ಸಾಟರ್ಡೆ?
Please, my lords, please.
My lord, I have some inconvenience on
23rd ಬೇಡವಾ?
23rd I am out of.
ಆಯ್ತು, 26/11.
26.
Please, grateful, my lords.
Started in admission 28. Pramod R, Ajay Prabhu M,
Having objection to the ADR report.
ADLR report, ಗೊತ್ತವಳೆ. Respondent counsel files objections to ADLR report. ನಿಮ್ದೇನ್ objections ಏನಿಲ್ವಾ? Appellant counsel says no objection to ADLR report. ಹೇಳಿ ಏನ್ ಮ್ಯಾಟರ್ ನೋಡ್ರಿ.
May I request for
ಹಾ?
next week, Lord.
ಯಾಕ್ರಿ?
Because not well.
ನೀವೇ ಓದ್ಕೊಂಡು ತಕರಾರೆಲ್ಲ ರೆಡಿ ಮಾಡ್ಕೊ ಬಂದಿದ್ದೀರಲ್ಲ ಮತ್ತೇನು?
Don't ಮಾತ್ರ.
ಹಾ? Parted matter. Why you have to keep the matter pending?
Not keeping well.
Not keeping well. Totally. The counsel for respondent seeks time on the ground of not keeping well, and hence this matter on. Other date kodi. Parted. 29/11.
Mission matter
Mr.
29,
Chandrachud.
B. Chandrachud, C. Shankar Reddy.
Yes,
One more connected matter,
connected ಇದೆಯಾ? ಯಾವ್ದದು?
1258 of 2020,
1258
2023.
23. ಈ ಐಎಗಳು ಎರಡು ಅರೈಸಿಂಗ್ ಔಟ್ ಆಫ್
Taking out of the common order.
same common order. Totally. Appellant counsel submits that MFA number 1258 of 23 is also arising out of common order, and the same may be listed, and hence registry is directed to list the same along with this appeal on 4/12.
Grateful.
30,
Sanjay.
G.
For the petition, appellant, my lord, sir.
Counsel
Challenging the,
submission with regard to non-filing of documents of trial court for verification of schedule as details as stated in the appeal memo and IA. ಏನ್ರಿ ಇದು?
my lord, sir. A suit is filed in respect of a property belonging to me by mentioning a different schedule.
ಯಾಕ್ರಿ schedule ಹಾಕ್ಬೇಕು? Order 9 rule 13 ಗೆ
ಅಲ್ಲ, dismiss ಆಗಿದೆ ಸ್ವಾಮಿ. Suit
ಹಾಗೆ
is expert,
ಡಿಸ್ಮಿಸ್ ಆಗ್ಲಿ. Order 9 rule 13 ಹಾಕಿ ನೀವು ರೆಸ್ಟೋರೇಷನ್ ಕೇಳಿರೋದು.
please, my lord.
ರೆಸ್ಟೋರೇಷನ್ ಇದೆಲ್ಲ ಯಾಕೆ ಬೇಕು ಅಂತ ಹಾಕಿಸ್ತಾ?
That's what I said, I tried to convince there.
ಏನಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಏನಿದೆ? ಕೈ ಹಾಕಿದಿರಾ ನೀವು?
IA for stay ಹಾಕಿದ್ದೀನಿ, IA for stay ಮತ್ತೆ ಕಂಡೀಷನ್ ಡಿಲೇ ಹಾಕಿದ್ದೀನಿ.
ಸ್ಟೇ ಆಫ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಆರ್ಡರ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಷ್ಟೇ.
ಮತ್ತೆ ಕೆಲಸ ಇಲ್ಲ ಮೇಲೆ ಹೊರಗಡೆ. ಜಡ್ಜ್ಮೆಂಟ್ ಸರಿ ಇದೆಯಲ್ಲ ನೋಡ್ಬೇಕಷ್ಟೇ. IA CD, IA1 CD, IA1 of 24 for
ಡಿಲೇ
dispensation. Could be pleased to dispense the same. ಆಮೇಲೆ ಇನ್ನೊಂದೇನ
IA for stay ಒಂದಿದೆ, ಡಿಲೇ ಇದೆ ಸರ್, 236 days ಡಿಲೇ ಇದೆ.
ಸ್ಟೇ ಆಫ್ ದಿ ಇಂಪ್ರೂವ್ಡ್ ಆರ್ಡರ್.
ಇಂಪಿಂಡ್ ಆರ್ಡರ್ ಅಷ್ಟೇ.
ಎಲ್ಲಿ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ವಲ್ಲ?
ಪೇಜ್ ನಂಬರ್ 30 ಸ್ವಾಮಿ.
ಒಂದು ಇದೆಯಾ?
31.
ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತಿದೆ.
31.
ಹಾ?
ಪೇಜ್ ನಂಬರ್ 31 IA for stay ಇದೆ. ಪೇಜ್ ನಂಬರ್
31. IA1 of
IA1 for condonation of delay ಸ್ವಾಮಿ.
ಡಿಲೇ ಎಷ್ಟು ದಿವಸ ಇದೆ?
236 days delay.
ಡಿಲೇ ಮೇಲೆ ನೋಟಿಸ್ ಹೋಗ್ಬಿಡುವ?
Please, my lord.
ಏನು ತೋರ್ಸೋದೇ ಇಲ್ವಲ್ರಿ? ಡಿಲೇ ಇದೆ. ಆಮೇಲೆ ಸೆಕ್ಷನ್ 5 ಏನೋ ಬೇರೆ ಇದೆ.
236 ದಿವಸ ಡಿಲೇ.
ಎಷ್ಟು ಕಂಡೋನ್ ಡಿಲೇ ಆಫ್ ಅದು ಎಷ್ಟು ದಿವಸ ಅಂತ ಬರೆಯೋದೇ ಇಲ್ವಲ್ರಿ ನೀವು?
ಅಲ್ಲ ಬರ್ದಿ 236 days.
ಹಂಗೆ ಇದೆ ಇದ್ರಲ್ಲಿ.
ಸಾರಿ.
ಡಿಲೇ 286 ಅಂತ ಒಂದು ಇದೆ. ಎರಡು ಸೆಟ್ ಹಾಕಿದ್ರೆ ಯಾಕೆ? ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಯಾವ್ದು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ನೆಕ್ಸ್ಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಿ.
ಹಾ?
IA number 2
ಅಪ್ಲಿಕೇಶನ್ ಯಾವ್ದು ಇಲ್ಲ.
IA number 2.23.
ಬೇಡ, ಈಗ ನೋಡಿ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಆನ್
ಡಿಲೇ.
ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ. ಏನ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ರೀ? ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಯಾಕೆ ಬೇಕು ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಮತ್ತೇನ್ ಆರ್ಡರ್ ಆಗಿದೆ? ಏನಿದೆ ಆರ್ಡರ್ ಅದು ನೋಡಿ. ಹಿಂದೆ 2 ಸರಿ ಬಂದಿದೆಯಲ್ಲ, ನಮ್ಮ ಮುಂದೆನೆ ಏನ್ ಆರ್ಡರ್ ಅದು?
ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಮೆಮೊ ಸಬ್ಮಿಟ್ ಮಾಡೋದು ಸಮಯ ಟೈಪ್ ಕಾಪಿ ಹಾಕ್ಬೇಕು ಅಂತ. ದಟ್ ವಾಸ್ ಕನ್ಸಿಡರ್ಡ್ ಬೈ ದಿಸ್ ಕೋರ್ಟ್.
ಏನ್ ಕಾಸ್ಟ್ ಬೇರೆ ಇದೆ? 2000
ಕಟ್ಟಿದೆ ಸ್ವಾಮಿ.
ಏನಕ್ಕೆ ಕಾಸ್ಟ್? ಕಂಪ್ಲೈ ಮಾಡಿಲ್ವಾ?
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಇಟ್ ವಾಸ್ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್. ಕಾಸ್ಟ್ ಇಸ್ ಆಲ್ಸೋ ಪೇಡ್ ಯು.
For appointment of Assistant Director of Land Records ADLR Monday as Commissioner, the counsel for the respondent submits that land. ಇದಲ್ಲ ಮೇಡಮ್, ಇದು
ನಾನೇನ್ ಕೇಳಿಲ್ಲ ಸರ್, ಬೇರೆ
ಇದು ಯಾವ್ದು? 2210 ಕೊಟ್ಟಿದ್ದಾರೆ. 2210 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಸಾರಿ.
ಬಿಟ್ಬಿಡಿ, ಈಗ ನೋಟಿಸ್ ಹೋಗಿ. ಡಿಲೇ ಇದೆ. ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಅಲ್ವಾ?
ಇದೆ ಸ್ವಾಮಿ. IA number 1 of 23.
ಕೊಡಿದ್ರು. ಅದು ಬೇರೆ ರೆಕಾರ್ಡ್ಸ್ ಕೊಟ್ರ?
ಇಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಪೇಜ್ ನಂಬರ್ 30.
Application for stay ಈಗಿದೆ ನೋಡಿ ಕೊಟ್ಟಿರೋದು.
ಪೇಜ್ ನಂಬರ್ 31.
$286 days delay. Can I number ಹಾಕ್ಲಿಲ್ಲ ಮೇಡಮ್?
ಐ ನಂಬರ್ 1/23 ಅಂತ ಇಲ್ಲಿ
Stamp
ಬರ್ದಿದೆ.
affixed in old IN. Old IN ಅಂತ ಏನೋ ಹಾಕಿದ್ರಿ? 2 ಐ ಹಾಕಿದಿರೇನ್ರಿ?
2 ಯಾಕೆ?
ಯಾಕೆ? ಡಿಲೇಗೆ 2 ಐ ಹಾಕಿದೀರಾ?
ಇಲ್ಲ, ಒಂದೇ ಐ ಹಾಕಿದ್ದು.
ಓಲ್ಡ್ ಐ ಅಂತ ಬರೀತೀರಾ ಅದ್ರ ಮೇಲೆ? ಸಿಡಿನಾ? ಅದ್ ಬಿಟ್ಬಿಡಿ. Issue notice on IA 1/23 since there is a delay of 286 days, 286 days. And also issue notice on main against the respondent. ಹೋಗ್ ಬರ್ಲಿ. Prakash MH. CD of delay of 69 days. Other side are either D Manjunath for R1 to R3. ಏನ್ರಿ?
Keeping
Yes, Prasanna Kumar.
office
Huh?
objection.
Objections ಹಾಕಿದಾರ ಅವರು?
ಇಲ್ಲ
ಏನಾರು?
ಇಲ್ಲ office objections ಏನಿಲ್ಲ. We are the suit for partition.
Office objections are kept in abeyance for the present as per court order dated 11/4/23 na.
Please.
Office objection regarding 1 non-filing of IA plaint.
It is filed.
Violation slip of OS.
It is submitted, my lord, along with the appeal papers.
Difference in name and signature of A3 ಬೇರೆ ಏನಿದೆ?
My lord, I will look into that, my lord.
Filing of IA plaint valuation slip.
ಅದ್ ಪೆಂಡಿಂಗ್ ಇಟ್ಟಿದಾರ್ರಿ ಅದು?
ಅದೊಂದಿದೆ sir.
ಅದು
ಆಮೇಲೆ
kept
difference in
pending ಇದೆ
name and
ಬಿಟ್ಬಿಡಿ.
sign of A3.
Plaint valuation slip ಯಾಕೆ ಹಾಕಿಲ್ವಾ ನೀವು?
ಹಾಕಿದೆ.
ಮತ್ತೆ
My
ಅದಕ್ಕೆ
lord,
ಅದನ್ನ
I don't know why even the plaint copy is also produced at page 34. It is actually-
ಡಿಫರೆನ್ಸ್ ಇನ್ ನೇಮ್ ಆಫ್ ಸಿಗ್ನೇಚರ್ ಆಫ್ ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 3 ಅಂತ ಇದೆ. ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 3 ಹೆಸರೇನೋ, ಸಿಗ್ನೇಚರ್ ಏನೋ?
Lord, appellant number 3 is Pillakkamma alias Muniratnamma ಅಂತ.
ಪಿಳ್ಳಕ್ಕಮ್ಮ. ಸೈನ್ ಏನಂತಿದೆ? ಪಿಳ್ಳಕ್ಕಮ್ಮ ಅಂತ ಯಾರು ಸೈನೇ ಮಾಡಿಲ್ಲ? ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 3 ಪಿಳ್ಳಕ್ಕಮ್ಮ ಅಂತ ಯಾರು ಸೈನೇ ಮಾಡಿಲ್ಲ ಅಲ್ರಿ? ಮೇಲ್ಗಡೆ ಹೆಸರೇನೋ ನೋಡಿದ ಮೇರೇನಿದೆ? ಮುನಿರತ್ನಮ್ಮ. ಮಟಲ್ನಾಡ್ ಸುಮಾರು ಎಷ್ಟು ಜನ ಅವ್ರು ನೋಡಿ ಅಪ್ಲೈಂಟ್ಸ್?
3 appellants.
ಊರೇ ಇರೋದು?
ನಾರಾಯಣಮ್ಮ, ಚೆನ್ನಮ್ಮ ಮತ್ತೆ ಪಿಳ್ಳಕ್ಕಮ್ಮ.
ಮುನಿರತ್ನಮ್ಮ ಇದೆಯಾ ನೋಡಿ ಇಲ್ಲಿ? ಮತ್ತೆ ಇಲ್ಲಿ 4 ಸೈನ್. ಮುನಿರತ್ನಮ್ಮ. ಆಯ್ತು. ಮತ್ತೆ ಇನ್ಯಾರು ಸಿಗ್ನೇಚರ್ ಅದು? ಅವ್ರದೇ ಈಗ ಡಿಫ್ರೆನ್ಸ್ ತಗೊಳ್ಳಿ. The name of appellant number 3 is mentioned Pillakkamma alias Muniratnamma, but she has signed in the name of Muniratnamma, and hence office objection is overruled regarding difference in name. ಆಯ್ತಾ? ಬಾಕಿದೇನಾಗ್ಬೇಕು ಈಗ?
Even the plaint is also produced as well as valuation slip.
ಅದೇನ kept in abeyance for the present as per
Please.
court order ಅಂತ ಇದೆಯಲ್ಲ?
In fact,
11/4/23 ನಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಇದೆ ನೋಡ್ರಿ. 11/4 office objections are kept in abeyance for the present. Registry name is Prasanna Kumar as learned counsel for the list of admission immediately after summer vacation ಅಂತ ಇದೆ. ತಗೊಳ್ಳಿ. Post this matter for admission along with IAS.
Please.
ಅಡ್ಮಿಷನ್ ಗೆ ಬಂದಿಲ್ಲ.
Admission ಗೆ
ಈಗ ಬಂದಿರೋದು ಅಡ್ಮಿಷನ್ ಗ ಯಾರು ಬರ್ಲಿಲ್ಲ ಅವ್ರ ಅದರ್ ಸೈಡ್?
maybe condoned and the matter will be taken. In fact, 2 appeals filed by
on
the
IA 1/23 and there is a delay of 69 days in filing the appeal. And so the respondents are represented through their counsel. They are not filed. First time ಬಂದಿರೋದು, ಆಮೇಲೆ ಬಂದೇ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲೇನ್ರಿ?
ಇಲ್ಲ sir.
And totally respondents counsels are absent. Given 1 week time to file statement of objections to IA number 1/23. If objections not filed, it will be taken as no objections to IA 1/23. And list this matter for admission along with IA 1/23 on 4/12.
3233 adjourn 34. Yes sir.
Fayaz of busy. ಹೇಳಿ.
Point in this case.
Ketan N for Kivetar. ಹೇಳಿ.
For respondent in this case.
Huh?
For respondent in this case.
Respondent ಒಬ್ಬರೇ ಇರೋದಾ?
Only one respondent, my lord.
ಆಯ್ತು,
It is
ಹೇಳಿ.
suit for permanent injunction, my lord. The appellant before this court is the absolute owner of the suit scheduled property under registry.
Defendant.
Pardon, my lord.
ನೀವೇ plaintiff
Plaintiff, my lord.
Ah,
Plaintiff appeal.
ಹೇಳಿ.
Lord, the appellant before this honorable court is the sole and absolute owner of the immobile property which is referred as the suit schedule property, my lord. The defendant is the brother, son, adjacent owner to that property.
Son.
ಹೌದು ಸ್ವಾಮಿ. Annexure B, my lord, page 24 is the partition, registered partition deed taken place between this appellant and the respondent, my lord. Page 24, my lord. Kindly see page 36, my lord. Item number 4.
36.
Yes, my lord. Item number 4. That is the suit schedule property that has been fallen to the share of this appellant before this court.
Para 34
Page 36, my lord. Page 36. That is the partition. Item number 4. That is the suit schedule property that is fallen to the share of this appellant. Thereafter, my lord, this adjacent property, which is the property of this respondent before this court. So he started interfering in my possession and enjoyment of this property. Then I filed a suit for a permanent injunction. So, my lord, kindly page 21, my lord, page 21 of the impugned order, page 21. My lord, kindly see. The property of the respondent is 63/1, para 10, my lord, page 21, para 10. The property of this appellant is that respondent is 16/3, 39/5, 15, measuring is so and so. Next property, that is the 36, 12, 37, this is the property of mine. So this property belongs to him. This property is situated to adjacent to my property. This respondent has been started interfering in my possession. For that, I filed the suit for parody this injunction, my lord. The trial court has observed that the findings given in OS number 2979 ಅಲ್ಲಿ ನಾವ್ ಹೇಳಿರೋದು ಏನಂದ್ರೆ ಇದು ಈ ಪ್ರಾಪರ್ಟಿ 16/3, 13/15 is belongs to the respondent ಅಂತ ಹೇಳಿರೋದು. But that is not the issue, my lord. The issue is only with regard to that my property, which is item number 4 in the partition deed. In that property is trying to interfere with that. For that, I filed the suit for permanent injunction. The trial court has dismissed that application filed under Order 39 Rule 1 and 2 on 2/9/2023. For that, I filed this appeal, my lord. And also, my lord, I produced the document khata of Panchayat. This Gram Thana khata is also produced. In that also, that name of this appellant is reflected as a owner.
Suit OS number 2979 of 2019 ಇದೆಯಲ್ಲ, ಡಿಗ್ರಿ ಆಗಿದೆ ನಿಮ್ಮ ಅಗೇನ್ಸ್ಟ್.
ಅದೇ ಅದರಲ್ಲಿ ಬಂದು ಈಗ ನಾನು ಪ್ಯಾರಾ 21 ನಲ್ಲಿ ತಮ್ಗೆ ಏನ್ ಪೇಜ್ ಓದಿದ್ನಲ್ಲ, ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದ ಫಸ್ಟ್ ಐಟಮ್ ಇದೆಯಲ್ಲ, ಅದಕ್ಕೆ
ಫಸ್ಟ್ ಐಟಮ್ 16/3, 39.
ಹೌದು, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ಅದು ಇರೋದು. So I am also not disputing that. That is as per the partition deed, that property has been allotted to him. But the court has wrongly construed that ಇದರಲ್ಲಿ ಅಡ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ, ಅದಕ್ಕೋಸ್ಕರ ದಿಸ್ ಇಸ್ ನಾಟ್ ಅಂತ ಹೇಳಿ. ಬಟ್ ದಿಸ್ ಪ್ರಾಪರ್ಟಿ, ದಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಅಲಾಟೆಡ್ ಟು ಮೀ ಅಂಡರ್ a registered partition deed dated 19/8/2006. This property belongs to me. In this regard, he has no right over this property.
Partition deed or not?
Hello?
Do you admit the partition deed or not? Item number 4 ಇದೆಯಲ್ಲ, ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿದೆಯೇ ಇಲ್ಲ?
ಅಲ್ಲ, ಅದನ್ನ ಒಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ತೀವಿ ಸರ್. ನಮ್ಗೆ
Objections ಆಮೇಲೆ ಹಾಕಿರಂತ್ರಿ, ಈಗ ಹೇಳ್ರಿ objections ಏನ್ ಹಾಕ್ತಿರಿ? ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅವ್ರದ್ದು ಪ್ರಾಪರ್ಟಿ ಮಾಡಿ ಕೈಂಡ್ಲಿ ಪೇಜ್ 37.
ನೀವು ಪಾರ್ಟಿಷನ್ ಡೀಡಿಗೆ ಪಾರ್ಟಿ.
ಹೌದು, 37 ಅಲ್ಲಿ ಅವ್ರ ಶೇರ್ ಅಲಾಟ್ ಆಗಿರೋದು ಇದೆ ಸ್ವಾಮಿ.
4 ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿದೆ. ಹೌದಾ? ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ ನಿಮ್ಗೆ ಅಲಾಟ್ ಆಗಿದೆ. ನಿಮ್ಗೆ ಐಟಮ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಏನಿದೆ ಹಕ್ಕು?
ಅಲ್ಲ, ಅದೇ senior is not in station ಸ್ವಾಮಿ. Senior not in station ಸ್ವಾಮಿ. ಹಿಂಗಾಗಿ ಬಂದಿನ ಸೀನಿಯರ್ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಹೋಗಿದೆ ಸ್ವಾಮಿ.
ಸೀನಿಯರ್ ನಾಟ್ ಇನ್ ಸ್ಟೇಷನ್. ಇಲ್ಲಿ ಆರ್ಡರ್ ನಲ್ಲಿ ನೋಡಿ, OS ನಂಬರ್ 2919 ಅಲ್ಲಿ ಡಿಗ್ರಿ ಆಗಿದೆ ಎಗೇನೆಸ್ಟ್ ಹಿಮ್ ಅಂತ ಬರ್ದಿದ್ರಿ, ಬರ್ದವ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವರು. ಆ ಡಿಗ್ರಿ ಆಗಿರೋದು ಪ್ರಾಪರ್ಟಿ ನಿಮ್ಗೆ ಏನ್ ಅಲಾಟ್ ಆಗಿದೆಯೋ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ, ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿರೋದು ಯಾವ್ದು ಐಟಮ್ ನಂಬರ್?
ಐಟಮ್ ನಂಬರ್ ಕೈಂಡ್ಲಿ ಪೇಜ್ 37 ಬನ್ನಿ ಸ್ವಾಮಿ.
37.
ಹೌದು ಸ್ವಾಮಿ. ಶೆಡ್ಯೂಲ್ ಬಿ ಪ್ರಾಪರ್ಟಿ ಅವರು ಮಲ್ಟಿಪಲ್ ಶಿವಾನಂದಯ್ಯ, ದಟ್ ಇಸ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಅಂಡ್ ಅದರ್ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಗೆ
ಶೆಡ್ಯೂಲ್ ಬಿ.
ಹೌದು. ಸೊ ಇತರ ಶೆಡ್ಯೂಲ್ ಬಿ ನಲ್ಲಿ ಇರೋಂತ ಐಟಮ್ಸ್ ಅವ್ರಿಗೆ ಆಗಿರೋದು. ಇದು ಜಾಯಿಂಟ್ ಆಗಿ ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ಗೆ. ಶಿವಾನಂದಯ್ಯ ಇಸ್ ಆಲ್ಸೋ ನಂಬರ್ 2. ದಟ್ ಮಂಜುಳಾ, ಶಿವಾನಂದಯ್ಯ, ಜಯಶೀಲ, ಸೋಮಶೇಖರಯ್ಯ ಮತ್ತೆ ಬ್ರಹ್ಮರಾಂಬ. So far as this scheduled property is concerned, this respondent has no right over this property.
Paragraph number 10 ನಲ್ಲಿ ನೋಡ್ರಿ. In OS number 2979 of 2019, the defendant claimed his right over the para number 10 ನಲ್ಲಿ ಖಾತಾ ನಂಬರ್ 16/3, 39/15 ಅದ್ರಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ನಿಮ್ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲೂ ಕೂಡ ಅದಿದೆ.
ಅದೇ ಇದೆ.
16/3, 39/15, measurement is 150, 130, 110, 108. ಹೌದಾ?
ಹೌದು.
ಅದಕ್ಕೆ ಡಿಗ್ರಿ ಇದೆ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಕ್ ಯಾಕೆ ಮಾಡ್ಬೇಕು ಅವ್ರು ಪ್ಲೇಂಟಿಫ್? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬರ್ದಿರ ಆರ್ಡರ್ ನೋಡಿ, the plaintiff has not challenged the said decree.
Why should I challenge?
The
Because
honorable apex court. The plaintiff has failed to prove his prima facie case as pleaded in the plain schedule property. Prima facie, there is a partition deed.
yes, no.
You are also a party.
Hmm.
Item number 4 was allotted to him.
Yes,
Now,
no.
what prima facie
Pursuant
case
to that
requires-
partition, they give an effect, they change the revenue records in their name and they have been possession and enjoyment of this
Prima facie
properties.
case requires ರೀ, ನಿಮ್ ಶೆಡ್ಯೂಲ್ ಯಾವ್ದು ನೋಡಿ. ನೀವು ಅಯ್ಯ ತೋರಿಸಿ, ನಿಮ್ಮ ಅಯ್ಯ ಶೆಡ್ಯೂಲ್ ಯಾವ್ದು ತೋರಿಸಿ.
No, kindly, I hear that, but page 55 notice. Schedule 55. That is the item number 4.
55.
Page 55, plaintiff.
ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಅಲರ್ಟ್ ಆಗಿರೋ ಐಟಮ್ ನಂಬರ್ ಅದನ್ನೇ ಹಾಕಿ.
4. Item number 4, schedule that same. Eastern portion is same number.
7/13, 189, 189/172. Same schedule.
Howದು? The property which has been allotted to me under registered partition dated 18/9, that 19/8/2006, item number 4, the same property is the scheduled property in OS number 59, 16 and 55 of that 22 more.
This matter is listed for admission. I heard the counsel for the appellant and also the counsel for the respondent. The trial court rejected the application filed under order 39 rule 1 and 2, wherein prayer is sought to restrain the defendant from interfering with plaintiff's peaceful personal enjoyment of the social property. The main contention of the plaintiff that he is the absolute owner of the social property, which is more fully described in the schedule. And the same is also allotted in the partition deed dated 19/8/2006. And defendant is interfering with possession of the property. The defendant appeared and filed the written statement, admitted the partition deed
Yes.
dated 19/8/2006. But the contention was taken by the defendant that plaintiff was executed registered release deed in favor of his father, that is brother of the plaintiff, and deceased in respect of the property. ಯಾವ್ದ್ರಿ ನೀವೇನೋ registered release
ಯಾವ್ದಿಲ್ಲ ಸ್ವಾಮಿ, partition deed, that is only that even that revenue records have placed it before this court.
release deed ಯಾವ್ದಿಲ್ವಾ?
ಇಲ್ಲ.
The defendant also took the contention that his father was in possession and enjoyment of the property. Since the same was released by the plaintiff after the death of his father, he is in possession and enjoyment of the social property, and stated that plaintiff has no right over the social property.
The registered partition was taken place and they have given effect to that.
Plaintiff in the partition deed dated 1980, without his consent and without mentioning the release deed, entered the social property in the partition. It is also contended that the plaintiff has falsely stated that the defendant has created a story and filed OS number 2979 of 2019 against him and sought decree against him, and hence prayed the court to dismiss the same. ನೀವೇನ್ ರಿಲೀಸ್ ಡೀಡ್ ಅನ್ನು ಹಾಕಿದ್ರೇನ್ರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ರಿಲೀಸ್ ಡೀಡ್ ಯಾವ್ದು ಇಲ್ಲ, ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಆಗಿದೆ, ಅದ್ರ ಪ್ರಕಾರ ಅವ್ರು ದೇ ಆರ್ ಟೇಕನ್ ದ ರೆಸ್ಪೆಕ್ಟ್ ಟು ಶೇರ್ಸ್ ಅಂಡ್ ದೇ ಹ್ಯಾವ್ ಬೀನ್ ಎಂಜಾಯ್ಮೆಂಟ್.
ಡಿಫೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದಾರೆ ಏನೋ ರಿಲೀಸ್ ಡೀಡ್ ಹಾಕಿದಾರ ಅಂತ ಕೇಳಿದೆ.
ಇಲ್ಲ ಸರ್, ಇವನ್ ದೇ ಆಲ್ಸೋ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್. Is 21 para 10 ನಲ್ಲಿ issues with regard to the 16/3, 39/15. So that is their property which allotted to this the respondent virtue of the partition deed dated 19/8/2006.
In the partition deed, the measurement of the social property is shown as east to west 40 feet.
ಅಲ್ಲಿ page 36 item number 4. The same measurement schedule ಅಲ್ಲೂ ಇರೋದು.
46 ಇಲ್ವಲ್ಲ 55 feet ಇದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ page 36 ಅಲ್ಲಿ
ಹಾ
36 ಅಲ್ಲಿ item number 4 the same measurement is there in the schedule client ಅಲ್ಲಿ.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲ ಬಟ್ ಇಲ್ಲಿ ಕೋರ್ಟ್ನವರು ಅಬ್ಸರ್ವ್ ಮಾಡಿರೋದು ನೋಡ್ತಾ ಇದೀನಿ ಬೇರೆ ಇದೆ.
page 36 ಅಲ್ಲಿ partition ಅಲ್ಲಿ
ಟೆಂಪಲ್ ಅದು ಬೇರೆ ಬರ್ತಾರಲ್ಲ ಇವರು.
The item allotted under that item number 4, the same schedule property description is there in the suit note. Item number 4 ಮತ್ತೆ page 55 ನಲ್ಲಿ schedule note.
ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಮೇಡಮ್?
In the partition deed, the measurement is shown as east to west 40.
ಹಿಂದಿನ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಫೈಲ್ಡ್ ಡಿಫೆಂಡೆಂಟ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಯ್ತಲ್ಲ.
Hence prior to dismissal.
Dismiss the suit. Third, the trial court having considered the pleadings of the parties, framed the point for consideration for granting of temporary injunction and answered the point as negative and dismissed the same. In coming to the conclusion in paragraph number 9, that the property claimed by defendant in OS number 2979 of 2019 and property claimed by the plaintiff in present case are two different properties. And also taken note of the boundaries, schedule mentioned in the plaint. And also claim is based on the partition deed dated 19/8/2006. And also made an observation that defendant has not produced the deed of partition. Also taken note of whether the claim made by the plaintiff over the social property is in consonance with or defect in terms of the partition deed. But made an observation erroneously that boundaries, the description given in the plaint and also the description given in the partition deed is different. And also made an observation that there was a decree against him in OS number 2979 of 2019 and the same has not been challenged and hence not made out prima facie case. Dismiss, being agreed by the said dismissal of the application, the present appeal is filed and counsel will vehemently contend that not in dispute that there was a family partition registered document dated 19/8/2006. In pursuance of the said document, even revenue records are also changed in the name of the parties. And counsel also brought to notice of this court the item number 4 of schedule which was allotted in favor of the plaintiff in terms of the partition deed. And the suit is also filed for the relief of the said item number 4. And also the description of the property given in the plaint as well as in the IA, also the item number 4 of the partition deed. The counsel would vehemently contend that trial comes to an erroneous conclusion that the decree granted in favor of the plaintiff in favor of the defendant has not been challenged in OS number 2979 of 2019. And counsel also would submit that he is not claiming any right in respect of the schedule mentioned in OS number 2979 of 2019. And counsel also brought to notice of this court Schedule B mentioned in the partition deed, and the same is in respect of item number 1 of the scheduled property mentioned in Schedule B, and he is not claiming any right in respect of Schedule B, particularly in respect of the said suit. And when such being the case, no need to even challenge that decree passed against the plaintiff. The counsel appearing to the respondent would vehemently contend that trial court having taken note of the discrepancy mentioned in the schedule, particularly in paragraph number 9, discuss the same. And in paragraph number 9 also comes to the conclusion that already appellant has suffered a decree in OS number 2979 of 2019, and the same has not been challenged. And dismiss the same. Coming to the conclusion that not made out any prima facie case and also no balance of convenience. Having heard the appellant counsel and also the counsel appearing for the respondent, both of them not dispute the partition deed, which is also registered on 19th August 2006. The very claim of the plaintiff also that he got the property. Schedule A, item number 4. And suit is also filed in respect of item number 4 of the schedule, which is mentioned in the partition deed. And also having perused the description of the property mentioned in the partition deed as well as the plaint as well as IA. And the same is the same. And the observation made by the trial court in paragraph number 9 is contrary to the schedule shown in the plaint as well as partition deed. The trial court fails to take note of the setback, but instead of taken note of the boundaries mentioned. And also erroneous approach is made by the trial court that OS number 2979 of 2019, and having perused that source description of the property in OS number 2979 of 2019 is also in respect of Kata number 16/3, 39/15. And the same measurement is item number 1 of B schedule property, which is more fully allotted in favor of the defendant. And rightly pointed out by the counsel appearing for the appellant that he is not claiming any right in respect of item number 1 of the property, which is more fully described in Schedule B of partition deed. When such being the case, even though the plaintiff has suffered the decree, the said suit, and the same is in respect of item number 1 of the B schedule property, and also the appellant not claiming any right in respect of the said property. And when such being the case, the trial court ought not to have made such an observation, and the very approach made by the trial court is erroneous, and the plaintiff is claiming only injunction in respect of the property allotted in his favor in the partition deed, which was registered on 19th day of August 2006. And the same is also not disputed by the defendant. However, defendant contend in the written statement that even prior to the release date, but prior to the registration of the partition deed, there was a relinquishment deed. And no such document, the relinquishment or the release deed in favor of the father, that is brother of the plaintiff, and release the property. And in order to substantiate the said contention, no document is placed before the court. And trial court also not given the reasoning to reject the application on the ground of release deed as put forth by the defendant. Nothing is discussed in the order with regard to the release deed is concerned. And in the absence of any such material also, the question of accepting the contention of the defendant also doesn't arise. And trial court fails to take note of the very pleading schedule mentioned in the plaint as well as in the objection IA as well as in the partition deed. And when the partition deed is not disputed by both the parties, the trial court ought not to have dismissed the application filed under Article 39 Rule 112 in granting the relief of injunction, and hence it requires interference. In view of the discussions made above, I pass the following order. Appeal is allowed, impugned order is set aside, and consequently, IA filed by the appellant, IA number?
IA number 1
Is allowed, and the relief is granted as sought in IA number 1. As against the respondent.
IA number 1 and 2 ಅಂತ ಇದೆ.
1 and 2 ಇದೆಯಲ್ಲೇ 1 ಇದೆ.
ಆರ್ಡರ್ ಸ್ವಲ್ಪ 16
1 and 2 ಯಾಕೆ ಬರುತ್ತೆ? 2 ಏನು? 1 and 2 ಅಂತ
ಅಂತ
ಹಾಕ್ತೀರಿ.
ಹೌದು. ಪೇಜ್ 16 ಲಾರ್ಡ್.
ಹಾ?
ಪೇಜ್ 16 ಅಲ್ಲಿ
16 ಅಲ್ಲೇ ಇದೆ 1 and 2 ಹೇಗ್ ಬರುತ್ತೆ? ರಿಸ್ಟ್ರೈನಿಂಗ್ ದಿ ಪೀಸ್ಫುಲ್ ಪೊಸಿಷನ್ ಅಂಡ್ ಎಂಜಾಯ್ಮೆಂಟ್ ಆಫ್ ದ ಸೂಟ್ಸ್ ಪ್ರಾಪರ್ಟಿ. ಇಟ್ ಇಸ್ ದ ಕೇಸ್ ಆಫ್ ದ plaintiff is absolute owner. ಅದು ಅಷ್ಟೇ ಇರೋದು. ಡಿಪೆಂಡೆಂಟ್ ಫ್ರಮ್ ಇಂಟರ್ಫಿಯರಿಂಗ್ ವಿತ್ plaintiff's position ಅಷ್ಟೇ ಅಲ್ವ ಇರೋದು?
ಹೌದು ಹೌದು.
ಹಾ, ಪ್ರೇಯರ್ ನಿಮ್ಮ ಐಎನ್ಎಲ್ ಏನಿರೋದು?
ಅದೇ ಇರೋದು ಸೇಮ್.
ಮತ್ತೆ ಇನ್ನ 2 ಹೆಂಗ್ ಬರುತ್ತಲ್ಲಿ?
ಹತ್ರ ಎಲ್ಲ ಮೆನ್ಷನ್
ನೀವು
ಮಾಡಿದ್ರು.
ಹಾಕಿರೋದ 1 ಅಲ್ವಾ?
ಹೌದು ಪೇಜ್ 57 ಲಾರ್ಡ್.
ಒಂದೇ ಹಾಕಿರೋ.
ಹೌದು ಒಂದೇ
2 ಹೆಂಗ್ ಬರುತ್ತೆ? 1 ಅಷ್ಟೇ. ಯಾವ್ದೋ ಕಾಪಿ ಅಂಡ್
ಪೇಜ್ 57.
ಕಾಪಿ ಅಂಡ್ ಪೇಸ್ಟ್ ಇರ್ಬೇಕು ನೋಡಿ.
ಹಾ ಬಂದಿರು.
56 ಅಲ್ಲ?
57 ಹೌಸ್ 57 ಅಲ್ಲಿ ಐ
ಪ್ರೇಯರ್ ಅಯ್ಯೇ 1 and 2 ಅಂತ.
ಒಂದೇ ಇರೋದು.
ಒಂದೇ
ಇರೋದು.
ಹೌದು. ಬಟ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಐ 1 and 2 ಅಂತ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
1 ಅಷ್ಟೇ.
35 ಕಾಶಿನಾಥ್ ಜೆಡಿ ರವಿಶಂಕರಿ.
1 and 2 are rejected.
This is my lord, plaintiff's appeal.
Hmm.
Yeah, my lord, initially, my lord, the suit is filed for declaration and injunction, my lord.
Yeah.
And both application for not to alienate and not to interfere with the possession, both are dismissed. Against which this appeals have been, 2 appeals are, my lord, connected to one. One is in respect of, my lord, not to alienate, another one is in respect of not to interfere. Kindly, my lord, I'll brief the facts. I submitted, my lord, one paper book, my lord, of the trial court documents. That is on, my lord, 8 July 2024. That lordship may got it. This, my lord, I'll start with the, my lord, the family tree, which is in respect of the plaintiff and the defendant number 2 and 3 is concerned. My lord. The family tree, my lord, kindly.
KG Puttanna.
KG Puttanna, my lord, is the father of the plaintiff.
Father of the plaintiff.
Plaintiff. And grandfather of the respondent number 2 and 3.
Respondent number?
2 and 3. Grandfather.
ಅದೇ ಭಾರ್ಗವಿ ಪಿ ಶ್ರುತಿ ಅಂತಿದಾರಲ್ಲ ಅವ್ರಿಗ?
ಅವರ ತಂದೆ
ಪ್ರಭಾಕರ.
Prabhakar is, my lord, the 5th child of KG Puttanna. In kindly, lordship may got it in there. Yes, this, my lord, the family consists of 5 children out of KG Puttanna. Had enormous of lands, my lord, in which, my lord, the partition deed was executed in the year 1961. Kindly, my lord, that is the next document, my lord. That is registered on 21/9/1961. 21/9/1961.
Partition deed.
Yes. In this, my lord, 5 children have been allocated with the different properties.
All the 5.
Yes, all the 5. The issue involved in this, my lord, in respect of the present appeal, is in respect of survey number 117 of the Hanumanahalli village of Kanapura Taluk.
117?
Hanumanahalli village of Kanapura Taluk. Here, my lord, this issue is not with any other brothers except the Prabhakar and their children and the plaintiff appellate. KG Venkatappa. Kindly, my lord, the typed copy of the partition deed I have produced.
ನೀವು ಫಸ್ಟ್ ಸನ್ನ ಪುಟ್ಟಣ್ಣನ್ಗೆ?
ಹೌದು.
KG ವೆಂಕಟಪ್ಪ.
ಹೌದು.
ವೆಂಕಟಪ್ಪ ಇದಾರಾ?
ಇದಾರೆ. He is 89 years or something.
ಆಯ್ತು.
Kindly. It's Prabhakar is no more, my lord. He is died.
Prabhakar is no more.
Yes.
ತಂದೆ ತಾಯಿ ಇಬ್ರು
He is died on 28/7/2001.
ಆಯ್ತು.
Yes. Both Almelamma and Puttanna is no more. The kindly, my lord, the typed copy of the partition deed, my lord. Yes, my lord, it starts from, my lord, page 29 onwards. Here, my lord, this particular Hanumanahalli village, my lord, it's declared as an earlier, my lord, Inam village. And most of the lands, my lord, were taken to the custody by virtue of the Inam Abolition Act. And pending proceedings were there during the registration of this partition deed. By taken into consideration of those proceedings, the Puttanna was undertaken to pursue the remedy in respect before the authorities. In presence of those proceedings, the properties of the entire family has been allocated among the brothers, children of the KG Puttanna. Kindly, my lord, the awareness page 13 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ ಅದು. 30-31 ಅಲ್ಲಿ. 13 ಮೇಲ್ ರೀಡ್ ಮಿಲೋಡ್. ನಾವು ಗಾರ್ಡಿಯನ್ ತಂದೆ ಕೆಜಿ ಪುಟ್ಟಣ್ಣ 6 ಜನರು ಮಾಡಿಕೊಂಡ ವಿಭಾಗದ ಪತ್ರದ ಇವೇನೆಂದರೆ ಕೆಜಿ ಪುಟ್ಟಣ್ಣ ಅವರ ಧರ್ಮಪತ್ನಿ ಅಲುಮೇಲಮ್ಮನವರು ದಂಪತಿಗಳಿಗೆ ಮೇಲ್ಕಂಡ 5 ಜನ ಮಕ್ಕಳಿಲ್ಲದೆ ಮತ್ತೊಬ್ಬ ನಳಿನಿ ಎಂಬ ಹೆಣ್ಣು ಮಗಳಿದ್ದಳು. ಆಕೆಗೆ 10 ವರ್ಷ ಹಿಂದೆಯೇ ಮದುವೆಯಾಗಿತ್ತು. ಆಕೆಯು ತನ್ನ ಗಂಡನ ಸಂಸಾರ ಮಾಡಿಕೊಂಡಳು. ಈ ಹಿಂದೆ ಹೇಳಿದ ಸೋಣಸೂರ್ ಅವರಿಗೆ ವಿವಾಹವಾಗಿರುವುದಿಲ್ಲ. ಮೇಲ್ಕಂಡ ಕೆಜಿ ಪುಟ್ಟಣ್ಣನವರು ಮೂಲಕರ್ತ ಚಿಂದಗಿರಿಯಪ್ಪನವರಿಂದ ದತ್ತುವಾಗಿ ಸೂಚಿಸಲ್ಪಟ್ಟು ಅವರ ಬಾಪ್ತು ವಿಶಿಷ್ಟ ಆಸ್ತಿಗಳಿಗೂ ಹಕ್ಕುದಾರರಾದರು. ಅವರ ಕಾಲದ ನಂತರ ಆಸ್ತಿಗಳೆಲ್ಲವೂ ತಂದೆ ತಾಯಿ ಮೇಲ್ಕಂಡ ಮಕ್ಕಳು ಮತ್ತು ಒಳಗೊಂಡ ಅವಿಕ್ತ ಕುಟುಂಬಕ್ಕೆ ಸೇರಿ ತಂದೆಯವರು ಕುಟುಂಬದ ಯಜಮಾನರು ಆದ ಮೇಲ್ಕಂಡ ಪುಟ್ಟಣ್ಣವರು ಮ್ಯಾನೇಜ್ಮೆಂಟಿನಲ್ಲಿತ್ತು. ಅವಿಕ್ತ ಕುಟುಂಬದ ವ್ಯವಸಾಯವೇ ವಂಶಾನುಗತವಾಗಿ ಬಂದ ವೃತ್ತಿಯಾಗಿದ್ದ ಮೇಲ್ಕಂಡ ಮಕ್ಕಳುಗಳ ಪೈಕಿ 1ನೇ ಕೆಜಿ ವೆಂಕಟಪ್ಪನು ವ್ಯವಸಾಯಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ವಿಷಯಗಳನ್ನು ಕೆಜಿ ಪುಟ್ಟಣ್ಣ, ಕೆಜಿ ಸೋನ್ಸೋ 3 ಸೇರಿಸಿಕೊಂಡು LG ಡಿಗ್ರಿ ಸಹ ಪಡೆದಿರುತ್ತಾನೆ. 2ನೇ ಕೆಜಿ ಶ್ರೀನಿವಾಸನು PUC ವರೆಗೆ ವಿದ್ಯಾಭ್ಯಾಸ ಹೊಂದಿ ಆತನು ವ್ಯವಸಾಯನೇ ಮುಖ್ಯ ವೃತ್ತಿಯಾಗಿಸಿಕೊಂಡಿರುತ್ತಾನೆ. ಈ ಕಾರಣ ನಮ್ಮಗಳು ಇಷ್ಟಾನುಸಾರ ತಮ್ಮ ಆಶಯಗಳಿಗಾಗಿ ಆಧುನಿಕ ರೀತಿಯಲ್ಲಿ ತಮ್ಮ ಶಕ್ತಿ ಸಾಮರ್ಥ್ಯಗಳನುಸಾರವಾಗಿ ವೃತ್ತಿಯಲ್ಲಿ ತೊಡಗಿ ಕುಟುಂಬದ ಘನತೆ ಗೌರವಗಳಿಗೆ ತಕ್ಕಂತೆ ಜೀವನ ಅನುಕೂಲಿಸುವಂತೆ ಈ ವೃತ್ತಿಯನ್ನು ಈಗಿನಿಂದ ವೃದ್ಧಿ ಮಾಡಿಕೊಳ್ಳಬೇಕೆಂದು ಸೋನ್ಸ್ ಕೈಂಡ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್.
ಆಯ್ತು. ರೀಸನ್ ಫಾರ್ ಮೇಕಿಂಗ್ ಪಾರ್ಟಿಷನ್.
ಎಸ್
ಆಯ್ತು.
ಅಂಡ್ ಮೈ ಲಾರ್ಡ್ ಪೇಜ್ 32 ಮೈ ಲಾರ್ಡ್ಸ್.
ಪ್ರತ್ಯೇಕ ಶೆಡ್ಯೂಲ್.
ಹೌದು, ಪೇಜ್ 32 ಮೈ ಲಾರ್ಡ್ಸ್. ನಮೂದು ಸಹ ಮಾಡಲ್ಲ. ಈ ವಿವರಗಳನ್ನು ಪ್ರತಿಯೊಬ್ಬರ ಹಿಸ್ಸೆಗೆ ಬಂದಿರುವ ಸ್ವತ್ತುಗಳನ್ನು ಅವರವರ ತಮ್ಮ ಪ್ರತ್ಯೇಕ ಸ್ವಾಧೀನಕ್ಕೆ ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಇಬ್ಬರು ಮೈನರು ಹಿಸ್ಸೆಗಳ ಕೊಟ್ಟಿರುವುದನ್ನು ಅವರುಗಳಿಗಾಗಿ ಅವರುಗಳ ಪರ ಗಾರ್ಡಿಯನ್ ತಂದೆ ಕೆಜಿ ಪುಟ್ಟಣ್ಣ ಅವರು ತಮ್ಮ ಪ್ರತ್ಯೇಕ ಸ್ವಾಧೀನಕ್ಕೆ ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಮೈನರುಗಳು ಮೆಜಾರಿಟಿಗೆ ಬರುವಾಗಿ ಗಾರ್ಡಿಯನರ್ ಆಗಿ ತಂದೆಯವರ ಅದನ್ನು ಸರಿಯಾಗಿ ರೂಢಿಸಿ ಜಮಾ ಖರ್ಚು. ಹೌದು. ನೆಕ್ಸ್ಟ್ ಸೊಮ್ಮೆ ಅಲ್ಲೇ ನೆಕ್ಸ್ಟ್ ಲೈನ್. ಹನುಮಾನಹಳ್ಳಿ ಇನಾಮ್ ಗ್ರಾಮವು ಇನಾಮ್ ರದ್ದಿಯಾತಿ ಕಾನೂನು ಪ್ರಕಾರ ಸರ್ಕಾರಕ್ಕೆ ತೆಗೆದುಕೊಳ್ತಿದ್ದು ಈ ಸಂಬಂಧವಾಗಿ ಇನಾಮದಾರರಾದ ಅವಿಭಕ್ತ ಕುಟುಂಬಕ್ಕೆ ಸಲುವಾಗಿ ಎಲ್ಲ ಪರಿಹಾರಗಳ ಬಗ್ಗೆಯೂ ಕುಟುಂಬದ ಯಜಮಾನರ ಕೆಜಿ ಪುಟ್ಟಣ್ಣವರು ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಂಡು ವ್ಯವಹಾರ ನಡೆಸುತ್ತಿದ್ದು ಇನ್ನೂ ಇತ್ಯರ್ಥವಾಗಿಲ್ಲ. ಈ ವಿಷಯದಲ್ಲಿ ಅನೇಕ ತೊಡಕಿನ ಪ್ರಶ್ನೆಗಳು ಹುಟ್ಟುವ ಸಂಭವವು ಕಾರಣದಿಂದ ಸೂಕ್ತ ಕೋರ್ಟ್ ವ್ಯವಹಾರಗಳೇ ತೆಗೆದುಕೊಳ್ಳುವ ಅಗತ್ಯ ಕಂಡು ಬರುವುದಾಗಿ ಈ ವಿಚಾರದಲ್ಲಿ ಸಂಪೂರ್ಣ ಮಾಹಿತಿ ಪರಿಶ್ರಮ ಕೆಜಿ ಪುಟ್ಟಣ್ಣವರೇ ಲಕೇರು ಒಳಗೆ ನಡೆಸಿ ನಮ್ಮಗಳಿಗೆ ಸಲ್ಲಬೇಕಾದ ಪರಿಹಾರವನ್ನು ಪಡೆಯಬೇಕಾಗಿದೆ. ನಾವೆಲ್ಲರೂ ಸಮ್ಮತಿಸಿ ಅವರೇ ಕೈರುವರೆಗೆ ಸೂಕ್ತ ಕ್ರಮವನ್ನು ನಡೆಸಲು ಒಪ್ಪಿರುತ್ತೇವೆ. ಈ ಸಂಬಂಧವಾಗಿ ಅಂದರೆ ಇನಾಮ್ ಸಾಹಿತಿ ರದ್ದಿಯಾಗುವುದರಿಂದ ಬರುವ ಪರಿಹಾರ ಇಷ್ಟೇ ಎಂಬುದನ್ನು ಹಾಲಿ ನಿರ್ಧರಿಸಲು ಸಾಧ್ಯವೇ ಇಲ್ಲವಾಗಿ ಪರಿಹಾರಗಳು ಬಂದ ನಂತರ ಅದಕ್ಕೆ ಹಕ್ಕುದಾರರಾದ ನಾವು 6 ಜನರು ನಮಗಿರುವ ಹಕ್ಕು ಬಾಧ್ಯತೆಗಳಿಗೆ ಅನುಸಾರವಾಗಿ ಅದನ್ನು ಹಂಚಿಕೊಳ್ಳಲು ನಿರ್ಧರಿಸಿಕೊಂಡ ಕಾರಣ ಅನುಮತಿನಲ್ಲಿ ಇಟ್ ಈಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಮೂವಬಲ್ಸ್ ಇಸ್ ಕಾಂಪನ್ಸೇಷನ್ ಇಸ್ ಕನ್ಸರ್ನ್ ಮೈ ಲಾರ್ಡ್ಸ್. ಅಮಾನತಿನಿಟ್ಟ ಮಧ್ಯಕಟ್ಟದಲ್ಲಿ ಇಟ್ಟಿರುತ್ತೇವೆ. ಹಾಲಿ ಅದನ್ನು ಹಂಚಿಕೊಂಡಿರುವುದಿಲ್ಲ. ಅವರ ಪ್ರತ್ಯೇಕ ಹಿಸ್ಸೆಗೆ ಬಂದಿರುವ ಸ್ವತ್ತುಗಳನ್ನು ಇನ್ನು ಮುಂದೆ ಸರ್ಕಾರಿ ಲೆಕ್ಕ ದಾಖಲೆಗಳಲ್ಲಿ ಅವರವರ ಹೆಸರಿಗೆ ದಾಖಲು ಮಾಡಿಕೊಳ್ಳಲು ಪ್ರತಿಯೊಬ್ಬರು ಸಂಪೂರ್ಣ ಸಹಾಯ ಮತ್ತು ಸಹಕಾರವನ್ನು ಕೊಡತಕ್ಕದ್ದು. ಜಮೀನು ಮತ್ತು ಮನೆಗಳು ಹಂಚಿಕೆಯಾಗಿರುವ ರೀತಿಯಲ್ಲಿ ಒಬ್ಬರ ಜಮೀನು ಮತ್ತು ಮನೆ ವಾಸದ ಅನುಕೂಲಕ್ಕೆ ಉಪಯೋಗಿಸುವ ಎಲ್ಲ ಅನಿವಾರ್ಯವಾದ ಸೌಕರ್ಯಗಳು ಮತ್ತೊಬ್ಬರ ಜಮೀನು ಮನೆ ಸಂಬಂಧವಾಗಿರುತ್ತವೆ. ಅವೆಲ್ಲ ಅವಶ್ಯಕವಾಗಿ ಬೇಕಾಗಿರುವುದರಿಂದ ಹಿಸ್ಸೆಯ ಮೂಲಕ ಹಿಸ್ಸೆಯನ್ನು ಅನುಭವಿಸಲು ಹೋಗಬೇಕಾ ರಸ್ತೆ, ಸೌಕರ್ಯ, ಕಾಲುವೆ, ದಟ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಆಲ್ usury aspects is concerned, it is dealt. Here, my lord, the kindly for a moment, my lord, the page 34. Ali reference is here in a survey number 117, my lord. It is more than 7.5 acres where land was there, in which, my lord, some portion of the land was cultivated by one of the tenant to an extent of 4 acres. Therefore, my lord, survey number 117 is referred in the partition. ಇದಕ್ಕೆ ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಒಂದು ಅಡಕವಾಗಿರೋ ಸ್ವತ್ತುಗಳಲ್ಲಿ ಕೆಲವು ಸ್ವತ್ತುಗಳು ಕೈಬಿಟ್ಟು ಹೋಗಿಯೂ ಅದಲು ಬದಲು ಬೇರೆ ಸ್ವತ್ತುಗಳು ಹೊಸದಾಗಿ ಬರುವ ಸಂಭವವೂ ಉಂಟಾಗುವ ಪರಿಸ್ಥಿತಿ ಉದ್ಭವಿಸಬಹುದು. ಅಂತಹ ಹೊಸ ಅನಿವಾರ್ಯತೆ ಸಂದರ್ಭ ಹೊರಗಿದಲ್ಲಿ ಆ ರೀತಿಯ ಬದಲಾವಣೆಯಿಂದ ಯಾರ ಹಿಸ್ಸೆಗೆ ಬಂದಿರುವ ಸ್ವತ್ತುಗಳು ಕೈಬಿಟ್ಟು ಹೋಗಿರುತ್ತವೆಯೋ ಅಂತಹವರು ಇತರರ ಹಿಸ್ಸೆಗಳಿಂದ ದಾಮಾಷಾ ಪ್ರಕಾರ ಸ್ವತ್ತುಗಳನ್ನು ಪಡೆದುಕೊಳ್ಳಲು ಅಥವಾ ಕೈಬಿಟ್ಟು ಹೋಗುವ ಸ್ವತ್ತಿಗೆ ಬದಲು ಬರುವ ಸ್ವತ್ತುಗಳನ್ನು ಇಟ್ಟುಕೊಳ್ಳಲು ಸಂಪೂರ್ಣ ಅವಕಾಶವಿರತಕ್ಕದ್ದು. ದಿಸ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ kindly my lord, I'll page 35. ಅದರದ್ದೇ ಕಂಟಿನ್ಯೂಷನ್ ಮತ್ತೆ ಹೇಳ್ತಾರೆ. Kindly in respect of the properties allotted to the Venkatappa starts from page 42 minutes. Page 42. My lordship got KG ವೆಂಕಟಪ್ಪನ ಹಿಸ್ಸೆಗೆ ಬಂದಿರತಕ್ಕವು page 40.
Right.
This starts from here, my lord, various properties have been allocated to KG Venkatappa, in which, my lord, the present survey number, kindly, my lord, page 40, so 44 is continued, my lord, in respect of the
Sunday one share.
Venkatappa ಅವರಿಗೆ ಬಂದಿರೋಂಥದ್ದು. It is continued, my lord, in page 45. The relevant, my lord, is page 46 till, my lord, basic Venkatappa's properties were continued. Wherein, my lord, survey number 117 is referred. Since, my lord, this property is also subjected for the tenancy proceedings, my lord, this extent and other things were not referred. In the event something goes wrong and any extent is left, then, my lord, it is referred in the recitals of the deed. Kindly, my lord, this survey number fall within the share of KG Venkatappa in a registered partition deed among the family members. Kindly, my lord, in the same manner, this properties, my lord, of the Prabhakar, KG Prabhakar, my lord, page 52 onwards, kindly. In the meantime, Chandru ಮತ್ತೆ ಉಳಿದಿರತಕ್ಕಂಥ ಪ್ರಾಪರ್ಟೀಸ್ page 52 onwards, last ಇದೆ. KG Prabhakar ಹಿಸ್ಸೆಗೆ ಬಂದಿರತಕ್ಕವು, these properties have been referred, my lord, in page 53, page 54. In all these, my lord, up to the page 56, there is no whisper or reference of allocation of share in survey number 117 of Hanumanalli village.
Yes.
Kindly, my lord. After this, my lord, kindly, my lord, paste the one document, my lord, which is produced by my learned friend before the trial court, which I have produced here. Page 115, lords. Page 115. This, my lord, the proceedings were ended, my lord, on 22/7/1976. In which, my lord, survey number 117 is also subjected for proceedings. Kindly, my lord, in this particular proceedings, one Tammanna Gowda, son of Timme Gowda, Kariyappa bin Nagegowda, Ramu bin Puttaswamaya, Hanumannahalli Gramdavaru, application proceedings hakirtare 7 Forum 7. In which, my lord, this all the members of the Puttanna, Venkatappa, Prabhakar, Chandru were also made as party proceedings. In which, my lord, survey number 117, survey number 37, 42, 43 ಎಲ್ಲ ಸೇರಿ ಇಲ್ಲಿ I'll read, my lord, the last paragraph. ಕನಕಪುರ ತಾಲೂಕು ಕಸಬಹಳ್ಳಿ ಹನುಮನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಪೇಜ್ 110 ಅಲ್ಲಿ ಟೈಪ್ಡ್ ಕಾಪಿ. 11 ಸರ್ವೆ ನಂಬರ್ 111, 115, 116, 123, 124, 125ರಲ್ಲಿ ಒಟ್ಟಿಗೆ ಸೇರಿ 22, 23 ತಮ್ಮಣ್ಣಗೌಡ ಬಿನ್ ತಿಮ್ಮೇಗೌಡ ಎಂಬುವರು ಗೇಣಿದಾರಾಗಿ ಅನುಭವಿಸುತ್ತಾ ಇರುವುದು ಸರ್ವೆ ನಂಬರ್ 34, 36, 37, 40, 42, 43, 44, 49, 117ರಲ್ಲಿ ಎಲ್ಲಾ ಸೇರಿ 30.6 ಎಕರೆ ಗುಂಟೆ ಪ್ರದೇಶ ಜಮೀನು ಕರಿಯಪ್ಪ ಬಿನ್ ನಾಗೇಗೌಡ ನಾಗೇಗೌಡ ಸರ್ವೆ ನಂಬರ್ 21 ಸೇರಿ ಎಲ್ಲ ಸೇರಿ 40ರಿಂದ 40.38 ಗುಂಟೆ ಪ್ರದೇಶದ ಜಮೀನನ್ನು 40 ಎಕರೆ 38 ಗುಂಟೆ ಸ್ವಾಮಿ ಜಮೀನನ್ನು ಸುಮಾರು 10-15 ವರ್ಷಗಳಿಂದಲೂ ಗೇಣಿದಾರರಾಗಿ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಪ್ರದೇಶವನ್ನು ತಮಗೆ ಕಾಯಂ ಮಾಡಿಕೊಡಬೇಕೆಂದು ಅರ್ಜಿದಾರರು ಕೇಳುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆ ಪರಿಶೀಲಿಸಿ ಚರ್ಚಾಸ್ಪದ ಜಮೀನನ್ನು ಅನುಭವದ ಹದ್ದುಬಸ್ತು ಅಳತೆ ಮಾಡಿಸುವ ನಿಬಂಧನೆ ಮೇರೆಗೆ ಅರ್ಜಿದಾರರುಗಳಿಗೆ ಕಾಯಂ ಮಾಡಿರುವುದಾಗಿ ಸರ್ವಾನುಮತದಿಂದ ತೀರ್ಮಾನಿಸಲಾಯಿತು. In which, my lord, only 4 acres have been given to the kindly, my lord, the next document, the form number 10, my lord, which is issued pursuant to this proceedings. Typed copy, my lord. ಇಲ್ಲಿ ಕರಿಯಪ್ಪ ಅಂತ ಹೇಳಿ ಇದು next page 112 ನಲ್ಲಿ. This, my lord, form number 10 has been issued. The index, my lord, in the next page, which is, my lord, not properly legible, in which, my lord, 117 is there. That, my lord, my typed copy, the separate ledger of the Hanumanalli village, my lord, is also I produced. After this, particular order by the revenue authority, my lord. The 3 acre 23 guntas was remain with the family of the KG Puttana, my lord. 4 acres have been given to that Karyappa son of Nagegowda. Thereafter, my lord, after conclusion of the proceedings before the land tribunal, this, my lord, land which has been left after deciding the penancy applications, which has been returned to the family, my lord, by the authorities. Kindly, my lord, that proceedings were taken place by initiating the RRT proceedings. While that RRT proceedings, my lord, this when took place by the Tahsildar, then, my lord, KG Puttana was no more, Alumelamma was alive. Since, my lord, Alumelamma was alive, KG Puttana was not there, then, my lord, without noticing this 1961 partition, this, my lord, mutation register has been entered in the name of Alumelamma. Kindly, my lord, for a moment, that order. Page 60, my lord, typed copy.
16.
Page 60, how? 15, 60, my lord.
0.
Yes. It starts, my lord, 59. It is, my lord, not legible. I have submitted typed copy. I think, my lord.
Hakkina Swabhava.
Yes. Mutation register. Kindly. ಕಸ್ಬಾ ಹೋಬಳಿ ಶಿವನಹಳ್ಳಿ ವೃತ್ತದ ಗಲಾಸೆಯಾಗಿರುವ ಕೆಜಿ ಪುಟ್ಟಣ್ಣ ಬಿನ್ ಚನ್ನಗಿರಿಯಪ್ಪರ ಪೋತೆ ಇವರ ಗ್ರಾಮದ ಜಮೀನುಗಳಿಗೆ ಇನಾಮ್ ಡೆಕಾರ್ ಅವರಿಂದ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಡಲಾಗಿದ್ದು, ಪೌತಿದಾರ ಹೆಸರಿನಲ್ಲಿ ಜಮೀನುಗಳ ಖಾತೆಯು ಹಾಲಿ ಇದ್ದು, ಇವರುಗಳ ಖಾತೆಯನ್ನು ಪೌತಿ ಬದಲಾವಣೆ ಮೂಲಕ ಬದಲಾಯಿಸಿಕೊಡಬೇಕೆಂದು ಖಾತೆದಾರರ ಪತ್ನಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಮೇರೆಗೆ ದಾಖಲಿಸಿ ಮಾಡಲಾಗಿದೆ. ಸರ್ವೆ ನಂಬರ್ 117, 3 ಎಕರೆ 23 ಗಂಟೆ. ಶರ ಇದೆ ಸ್ವಾಮಿ. ಖಾತೆದಾರರಾದ ಕೆಜಿ ಪುಟ್ಟಣ್ಣನವರು ಪೌತಿಯಾಗಿರೋದ್ರಿಂದ ಇವರ ಹೆಂಡತಿ ಅಲುಮೇಲನವರ ಹೆಸರಿಗೆ ಖಾತಾ ಹಕ್ಕು ಬದಲಾವಣೆ ಮಾಡಲು ಆದೇಶಿಸಿದೆ. This, my lord, starts from here. Even, my lord, this mutation was registered. Except this reference, my lord, there is no other documents were mutated, including the RTC and other things, my lord. After this, my lord, suddenly, my lord, this particular document, another page 57, my lord. Page 57. This is typed copy at page 58. The same document repeatedly produced by my lord and also, my lord, other documents. 1993 and 94 also. ಇವರು ಅಲುಮೇಲಮ್ಮನವರು ಬಂದು ನನ್ನ ಮಗನ ಹೆಸರಿಗೆ ಮಾಡ್ಕೊಡಿ ಅಂತ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರು. ಅದಕ್ಕೋಸ್ಕರ ನಾವು 117 ಜೊತೆಲಿ ಅದರ್ ಪ್ರಾಪರ್ಟೀಸ್ಗಳನ್ನ ನಾವು ಅವ್ರಿಗೆ ಸೇರಿಸ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಕೈಂಡ್ಲಿ, my lord, the reference page, the second column. ಕಸ್ಬಾ ಹೋಬಳಿ ಹನುಮಾನಹಳ್ಳಿ ಗ್ರಾಮದ ವಾಸಿಯಾದ ಶ್ರೀಮತಿ ಅಲುಮೇಲಮ್ಮ ಕೋಮ್ ಲೇಟ್ ಕೆಜಿ ಪುಟ್ಟಣ್ಣ ಇವರ ಜಮೀನುಗಳನ್ನು ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ ನಮೂನೆ 11ರ ಪ್ರಕಾರ ಸರ್ಕಾರದ ವಶಕ್ಕೆ ಪಡೆದಿದ್ದು, ನ್ಯಾಯಮಂಡಳಿಯು ಮರಳಿ ಜಮೀನುಗಳನ್ನು ಹಿಂದಿರುಗಿಸಿದ ಆದೇಶವನ್ನು ಉದ್ಘೋಷಿಸಿ ಹಕ್ಕುದಾರರ ನೇಮಕ ಮಾಡಲ್ಪಟ್ಟಿದೆ. ಇವರಿಗೆ ವಯಸ್ಸಾಗಿದ್ದು ಜಮೀನುಗಳು ರೂಢಿಸಲು ಸಾಧ್ಯವಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಇವರ ಕಿರಿಯ ಮಗನಾದ ಕೆಜಿ ಪ್ರಭಾಕರ್ ಇವರ ಹೆಸರಿಗೆ ಹಕ್ಕು ದಾಖಲೆಗಳನ್ನು ನೋಂದಾಯಿಸಿಕೊಡಬೇಕೆಂಬುದಾಗಿ ಮನವಿ ಸಲ್ಲಿಸಿರುವ ಮೇರೆಗೆ ಮೇಲ್ಕಂಡ ದಾಖಲೆ. And the inability, my lord, to take care, my lord, some reference is made contrary to the partition deed, my lord. Again, this concluded. Even after this, my lord, revenue records are not muted. They may accept this reference. After this, my lord, suddenly this Prabhakar wife taken, my lord, GPA from the husband and referring that I am the GPA holder. She executed the registered sale deed in favor of the defendant number 1. That is, my lord, page 72. That is on 5/5/2007. Page 72 in my compilation. This on 5/5/2007, my lord, this particular property in survey number 117, measuring 3 acre 23 guntas, been sold as representing the GPA holder. GPA holder.
Yes.
After this, my lord, till filing of my suit and till filing of my lord, the application before the assistant commissioner seeking non-induction of revenue entries by the plaintiff, as per annexure 81, my lord, page 81, document number 6. In the year 2019-20, my lord, the petition of the appellant has found that revenue entry in respect of survey number 117 is not found. Therefore, he made a request to the Assistant Commissioner by filing an appeal, my lord. Then only he found that, my lord, this particular property was sold. And in my appeal, my lord, the Assistant Commissioner is directed to mutate the revenue entries in respect of survey number 117 in favor of the defendant number 1, that is respond number 1, based on the sale deed, kindly in the law space, and relegated me to go before the civil court. Accordingly, my lord, I have filed suit as well as the appeal, madam, which is appeal pending before the Deputy Commissioner in respect of this. Till filing of this, my lord, revenue entries pursuant to registered sale deed not mutated. It is my information, my lord, in the year 2007 and 8, he filed an application for change the revenue interest, and same was rejected, and till same was not challenged by the first defendant. Thereafter, my lord, when I filed my application, which is returned, my lord, relegating me to civil court, saying that there is a title dispute, then, my lord, he filed one another appeal before the Assistant Commissioner, which was allowed, and revenue entries have been mutated in favor of the first respondent for first defendant. Here, my actual submission is, my lord, the entire case, my lord, based on my placed before the trial court, my lord, seeking declaration, my lord, in respect of my right, which is accrued, my lord, by virtue of the registered family members in the 1961. After that, my lord, there is in the said partition deed, there is a recital that if any changes in the lands which are subject matter of the statutory proceedings before the authorities under the Inam Abolition Act and Land Reforms Act, that will be adjusted. Here in a case, my land is some extent 4 acres has been left. I am not expected anything. But my lord, by taking advantage of that, my lord, the Alumelamma was alive on account of death of Puttanna. Wrongly, my lord, revenue entries have been mutated in the name of Alumelamma. By taking advantage of the age-old condition of the Alumelamma, the KG Prabhakar will get mutated, my lord, the mutation in the year 93-94, my lord, in his name, saying that my mother has informed to change the revenue in his name because she is not able to take care of the things. Here, my lord, in the entire properties, my lord, which is referred to in the mutation register at the time of mutating it in the name of the KG Prabhakar or otherwise in the earlier stage, every properties, my lord, transferred and allocated by virtue of the registered partition deed. Otherwise, there is no other mode of proceedings. Therefore, my actual submission is the KG Prabhakar and the Alumelamma are not the absolute owners having no source of title to transfer and alienate this property. Therefore, my lord, the alienation by the Sudha, the legal heir of the KG Prabhakar as a GPA holder, it is, my lord, it is completely null and void. And based on that, my lord, I submitted my suit for declaration. Here, my lord, in respect of the revenue entries, my lord, section 133, there is a presumption, my lord. Here, partial revenue entries are there, my lord. Partial revenue entries, my lord, is in respect of the mutation is registered, how it kata has to be changed. IHC kata is referred. Kindly section 133, as per 133 of Land Revenue Act, my lord, it is a rebuttable presumption, my lord, where revenue entries have been made. In my case, my lord, by applying the principles to rebut the presumption, my lord, in respect of revenue entry in the present case, where, my lord, the partition took place in the year 1961, all properties of the family, my lord, has decided and allocated among the members, and the pending proceedings of these land reforms and the Inam Abolition Act proceedings were noticed. And in respect of this, there is a specific recital to adjust the lands. Because, my lord, the authorities, while return back the lands to the original owners, without noticing this, my lord, the registered partition deed, a wrong revenue entries have been inducted through an IHC kata in the name of Alumelamma. By taking advantage of that, my lord, in the year 1994, my lord, Prabhakar has get mutated, my lord, on the oral request. There is no other document, my lord. And only on the one mutation register, in the absence of any other revenue documents, in the year 2007, my lord, this Sudha, wife of KG Prabhakar, has alienated this property in favor of the respondent number 1. My actual submission is, my lord, based on applying this principle, by taken into consideration of the registered partition deed, this, my lord, the entry made in the 1993 and 94, which is, my lord, completely irregular, improper, and without any basis. It is clear, my lord, either Alumelamma or Prabhakar have no right or a title over this particular property as on that day of entering the revenue records. That is exactly my case, my lord. When case is placed before the trial court, my lord, kindly, my lord, the findings of the trial court. Page 21 of my appeal memo. Para 8, my lord. I'll read, my lord.
Yes.
According to the plaintiff, suit scheduled property is the ancestral joint family property of himself and his family members, and in partition date dated 21/9/1961. Suit property was fallen to his share. However, there were proceedings initiated by the government under the Land Reforms Act, and this property was taken over the government. Thereafter, this property was returned to the owner, and accordingly, once again, partition. This, my lord, it is not my case. I never pleaded this particular fact, my lord. After returning of the property, there was a partition. I'll show it in the plaint. In which, my lord, the suit property was fallen to his share, and since then, he is in possession and enjoyment of the same as absolute owner. Kindly, my lord, the next para. It is further pleaded that the revenue entries were not made out in his name, but the mother of the defendant number 2 and 3, without having right, title, interest, or possession, had executed the sale deed in favor of the defendant number 1 on 5/5/2007. The defendant number 1, taking advantage of the same, is trying to interfere with his possession and enjoyment over the suit scheduled property and also trying to alienate the same. The plaintiff, in support of his case, has produced the documents such as family genealogy, certified copy of the partition deed, mutation extracts, proceedings of the government, copy of the sale deed dated 5/5/2007, artists, photographs, CD, and other assistant Ramnagara. On perusal of the family genealogy, it appears that the plaintiff is one of the son of late Puttanna and Alumelamma. Father of the defendant number 2 and 3 by name KG Prabhakara is one of the brothers of the plaintiff, and he is no more. Mother of the defendants number 2 and 3 by name Sudha, who is vendor of the suit scheduled property in favor of defendant number 1, is also no more. Perusal of the partition deed dated 21/9/1961 discloses that the suit scheduled property and other properties were fallen to the share of the plaintiff, but there were proceedings of the government in which the suit scheduled property and other properties were taken over by the government. The mutation extract produced by the plaintiff discloses that the government returned those properties to the original owners, and at that point of time, survey number 117 was returned to the mother of the plaintiff by name Alumelamma. And as per her statement, the mutation was effected in the name of brother the plaintiff by KG Prabhakar, and since then, his name appeared in the RRTC was owner in possession. After the death of KG Prabhakar, it seems his wife Srimati Sudha had executed the sale deed with respect to the suit scheduled property in favor of defendant number 1 on so and so soon. Even now, name of the KG Prabhakar is appearing with respect of the suit scheduled property, and name of the defendant number 1 is not entered. This, my lord, on that day when suit is presented, my lord, and subsequently it is mutated, none of the revenue documents were in the name, except that mutation register. Having regard to the mutation entries and RTC entries subsequent to the partition deed dated 21/9/1961, assertion of the plaintiff that he is in possession and enjoyment of the suit scheduled property as absolute owner, he is prima facie not acceptable. Kindly remember this fact. Even according to the plaintiff, after the partition deed 21/9/1961, suit scheduled property was taken over by the government and vested with the vested. Thereafter, as per the mutation extract produced by the plaintiff himself, name of KG Prabhakar is entered based on the statement of his mother. Plaintiff has not challenged the same. When once the land vests with the government, validity of the partition deed dated 21/9/1961 is a question to be considered at the time of final arguments, and this stage, plaintiff has not placed prima facie material to show that his title and possession over the suit scheduled property. Based on this, my lord, concluded. My actual submission is, my lord. Here, my lord, proceedings before the land tribunal, either under the Inam Abolition Act or under the Land Reforms Act, purely based on the revenue documents. As on that day, my lord, where revenue documents found who is in possession and what extent, Based on that, proceedings were initiated. While when proceedings were dropped in respect of some certain lands, these properties were returned back. While returning it, my lord, only IHE proceedings were initiated without noticing, my lord, the registered partition. Where, my lord, there is an error. By taken into this registered partition and are in the absence of the registered partition, none of the family members, my lord, have get any property from the family of the KG Puttana. Even, my lord, the KG Prabhakar also received the property out of the registered partition date. And there is no other instrument, my lord, among the family members. Therefore, my lord, the findings of the trial court, where, my lord, held that I have no sufficient material to show that, my lord, I have a prima facie case, that is, my lord, there is a serious error. Marital submission, another in respect of, my lord, solely relying on the revenue entries without noticing the registered document is also error committed by the trial court. In respect of this source of title and receipt of the person as a purchaser subsequent, in this regard, my lord, the Honorable Apex Court in the case of, my lord, Kijak K. Venkata Reddy Madhavan in 2024, my lord, online SEC page 17, where it is held, my lord, kindly may I pass on this judgment. It's kindly moved.
Paragraph?
Para, my lords, kindly it starts, my lord, para 18 onwards, my lord, there's a finding. Para 16 onwards, my lord, where high courts, my lord, considered only and solely on the revenue entries, my lord, without touching the root of the title. Where, my lord, who's the vendor who sells the property, lord. Para 16 onwards, the findings, my lord. Mayor, my lord, the relevance is para 18 onwards. May I read, my lord?
Yes.
The High Court has also, trial court have held that since the deeds were proved, implying that Charutai had the right to execute the lease deed on 14 July 1910, so far as the deed of release is concerned, the same might entitle her to be a beneficiary as a lessee thereof. But it would be tried to repeat that if subsistence of a deed to prove in evidence the title of executing person does not automatically stand confirmed. If a document seeking to convey immobile property ex facie reveals that the conveyor does not have the title over the same, the specific declaration that the document is invalid would not be necessary. The court examined the title in which, in the event the party to the proceeding set up this defense, Chirutai could not convey any property over which she did not have any right or title. Her right, if any, would stem from the second deed of lease. We are conscious of the fact that no claim was made before any forum for invalidating the deed dated 14 July 1910. But in the absence of proper title over the subject property, that lease deed, even if she was its sole lessor, would not have been legally valid or enforceable if right, title, or interest in certain property is sought to be conveyed by a person by an instrument who herself does not possess any such form of a entitlement on the subject being conveyed, even with the subsisting deed of conveyance on such property, the grantee on her successors in interest will not have any legal right to enforce the right. The letter may be here deprived from any such instrument. We, however, have not disturbed the transaction arise from Exhibit A20, as the two legal heirs of Madhavan were also lessors herein, and to the extent the document marked at Exhibit A20 would not have collapsed for want of conveyable title, right, or interest. What she got back by way of document marked at Exhibit A1 was limited right as that of a lessee and not as a successor of her interest, success of her first husband Madhavan, Moreover, this lease was also for a period of 12 years, and the release deed made in the year 1925, which Exhibit 10.30.A.2 could not operate as by that time, the entitlement of Kuttiperavan over the subject property also stood lapsed, as the document marked at Exhibit A1 also had a duration of 12 years. No evidence has been shown before us as to how Kuttiyappan, in the capacity of a lessee, could exercise his right after the term lease granted to him or was over. Here, my lord, this Chaturtha Devi was executed the list deed, where, my lord, based on list deed, my lord, they started to claiming that subsequent list deeds. This aspect, my lord, is considered para 16 reform the facts of the case. Here in a case, my lord, my rectal submission is in respect of the revenue entries. I place, my lord.
I travel settled la. Revenue entries
Yes.
will not confirm any
Yes,
right.
confirm any right.
Now you go to the reasoning of the trial court, paragraph number 8.
Yes,
Wherein your pleading is that property is an ancestral and giant family property himself and his family members, and in the partition
Yes,
deed
like-
21/9/1961.
I produced the print.
Property was fallen to his share anta ಇದೆ.
ಹೌದು ನಾನು
ನಿಮಗ್ ಬಂದಿದೆಯಾ ಈ ಸರ್ವೆ ನಂಬರ್ 117?
ಹೌದು, ಇದ್ರಲ್ಲಿ ತೋರಿಸಿದ್ನಲ್ಲ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ.
ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಅಲ್ಲಿ ನಿಮಗ್ ಬಂದಿದೆ.
ಹೌದು ಕೆಜಿ ಪುಟ್ಟಣ್ಣ.
ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್?
ಅದು ಎಕ್ಸ್ಟೆಂಟ್ ಡಿಟರ್ಮೈನ್ ಯಾಕೆ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ 1961 ಅಲ್ಲಿ ನಮಗೆ ಎಷ್ಟು ಉಳಿಯುತ್ತೆ ಅಂತ ಗೊತ್ತಾಗಿದ್ದಿಲ್ಲ. ಹಂಗಾಗಿ ದಟ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಶೋನ್. ಕೈಂಡ್ಲಿ ಮೈ ಲಾರ್ಡ್ ಇನ್ ಮೈ ಪಾರ್ಟಿಷನ್ ಡೀಡ್
ಓನ್ಲಿ 117 ಅಷ್ಟೇ ಹೇಳಿರೋದು.
ಹೌದು.
ಎಷ್ಟು ಅಂತ ಎಕ್ಸ್ಟೆಂಟ್ ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ.
ಬೇರೆ ಯಾರಿಗಾರು ಬಂದಿದೆ ಅದರಲ್ಲಿ?
ಇಲ್ಲ, ಎಲ್ಲೂ ಇಲ್ಲ.
ಬೇರೆ ಯಾರಿಗೂ ಎಲ್ಲೂ ಬಂದಿಲ್ಲ.
ಯಾರಿಗೂ ಇಲ್ಲ. 117 ಯಾರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ. ಇಫ್ ಎನಿ ರೆಫರೆನ್ಸ್ ಟು 117 ಟು ಎನಿ ಆಫ್ ದಿ ಅದರ್ ಮೆಂಬರ್ಸ್, ಐ ಹ್ಯಾವ್ ನೋ ರೈಟ್ ಮೈ ಲಾರ್ಡ್. The page, my lord, relevant page of the partition deed, my lord, in my compilation.
Page number
46. Page 46 in my compilation.
46.
Yes. Along with other survey numbers.
ಶ್ರೀ ಕೆಜಿ ವೆಂಕಟಪ್ಪನ ಹಿಸ್ಸೆಗೆ ಬಂದಿರತಕ್ಕದ್ದು ಅಂತ ಇದೆಯಲ್ಲ ಅದ?
ಅಲ್ಲ,
42 ನಲ್ಲ?
42 ಇಂದ ಶುರುವಾಗುತ್ತೆ ಸ್ವಾಮಿ. ಅದು ಮುಂದೆ ವರೆದು 44 ನಲ್ಲೂ ರೆಫರೆನ್ಸ್ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ. 42 ಇಂದ ಮತ್ತೆ 44 ಗೂ ಬರುತ್ತೆ. ಮತ್ತೆ ಇಲ್ಲಿ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಮತ್ತೆ 45 ದಲ್ಲೂ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಇಟ್ ಈಸ್ ರೆಫರ್ಡ್ ಇನ್.
ಇದೆಲ್ಲ ನಿಮ್ಗ?
ಹೌದೌದು. 46 ಅಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 117 ಇದೆ. ಹಂಡ್ರೆಡ್ಸ್ ಆಫ್
ಹನುಮನಹಳ್ಳಿ.
ಹೌದೌದು.
117.
ಹೌದು. ಖರಾಬ್ ತೋರಿಸಿದ್ದಾರೆ ಅದನ್ನ. ದಿಸ್ ರೆಫರೆನ್ಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ 117 ಯಾರು ಬೇರೆ ಇನ್ನು ಉಳಿದಿರ್ತಕ್ಕಂಥ ಯಾವ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ಗೂ ರೆಫರ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ.
I have verified, my lord, if my learned friend also may verify. And my lord, in respect of the share of Prabhakar, which is, my lord,
ಅವ್ರದೆಲ್ಲಿದೆ ಅದು?
next ಇದೆ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲೇ. Prabhakar partition ಇದೆ partition deed ಅಲ್ಲಿ. It starts from page 52, my lords.
ಶ್ರೀನಿವಾಸ.
Page 52. ಇದು ಅದು ಬಿಗ್ ಲೆಡ್ಜರ್ ಸ್ವಾಮಿ, ಅದು ಮೊದಲೇ ಮಾಡ್ತಿದ್ರಲ್ಲ, ಅದು 2 ಪೇಜ್ ಅಲ್ಲಿ ಇರುತ್ತೆ. ನಾನು ಟೈಪ್ಡ್ ಕಾಪಿ.
52.
ಎಸ್.
ಪ್ರಭಾಕರ ಹಿಸ್ಸೆಗೆ ಬಂದಿರತಕ್ಕಂಥ
ಇನ್ ಮುಂದಿರ್ತಕ್ಕಂಥ ಅಷ್ಟು ಪ್ರಾಪರ್ಟಿಗಳು ಪ್ರಭಾಕರ್ ಹೆಸರು. ಕೇಸ್ 15 ಅಲ್ಲಿ ಮತ್ತೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. 55 ನಲ್ಲಿ ಸ್ವಾಮಿ ಕೆಜಿ ಪ್ರಭಾಕರ್ ಅವರ ಹಿಸ್ಸೆಗೆ ಮುಂದುವರಿಸುವುದು. ಲಾಸ್ಟ್ ಸ್ವಾಮಿ ಕೆಜಿ ಶ್ರೀಮತಿ ಲೀಲಾ ಅವರ ಹಿಸ್ಸೆಗೆ ಬಂದಂತವು. ದಟ್ ಇಸ್ ಲಾಸ್ಟ್ ಗರ್ಲ್ ನೋಟ್ಸ್.
ಅದು ಬೇಡ. ಇದು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಏನಾಯ್ತು? ಟೆನೆನ್ಸಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ?
ಟೆನೆನ್ಸಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಒಬ್ಬ ತಮ್ಮಣ್ಣಗೌಡ ಮತ್ತು ಕರಿಯಪ್ಪ ಮತ್ತು ನಾಗೇಗೌಡ ಅನ್ನೋರಿಗೆ ಹಾಕಿರ್ತಾರೆ. ಅವಾಗ ಅರ್ಜಿ ಹಾಕಿದ್ರು. ಅದ್ರಲ್ಲಿ 4 ಎಕರೆ ಹೋಗುತ್ತೆ.
ಯಾವ್ದು ಈ ಸರ್ವೆ ನಂಬರ್?
ಸರ್ವೆ ನಂಬರ್ 117.
ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟಿದೆ?
7 ಎಕರೆ ಅಂಡ್ ಆಡ್ ನೋಟ್ಸ್
ಟೋಟಲ್.
ಹೌದು. ಅದರಲ್ಲಿ 3 ಎಕರೆ 23 ಗುಂಟೆ ಉಳಿಯುತ್ತೆ. Then it has to be returned to me while returning it back after dropping of the proceedings by the land tribunal. While returning that, my lord, land by the land tribunal, the revenue authorities, my lord, have found that
made an entry in favor of the
Almelama. Since, my lord, the Puttanna was not there. Later, my lord, the KG Prabhakar, taking advantage of that, Vanemaga.
Yes, counsel in there.
This is my case, my lord. And 2023, my lord, revenue entries is concerned from Jitendra case is also considered, my lord, by the apex.
Yes, counsel.
There are 5 of the
Plaint.
Para 5 of the plaint.
ಹೌದು. Page number.
Plaint copy ಹಾಕಿದಾರಾ?
ಹಾಕಿದೀವಿ. Page 28.
29.
Yes.
28 onwards.
Given according the plaint government, the suit schedule proper west with the government. Return back.
28.
It is submitted by the suit schedule property in pursuant to various agreement requirements and enactment of lands have been taken to the government and subsequently by paragraph number 5. It is submitted suit schedule property, your last can say, this is suit schedule property is 3 acres 23. This is also west with the government. Suit schedule is pursuant to various agrarian reforms and enactment of various statutes. Land have been taken to government and subsequently returned ಅಂತ ಹೇಳ್ತಾರೆ. Now you lost my kindly say, once the property west with the government, the partition deed is prior to that. So all the deeds, when the property is vested with the government, the document ceases to be operative. As the partition is concerned. Now subsequently by way of return to the procedure ಅಂತ ಹೇಳ್ತಾರೆ. Return ಆದ್ರೂನು, now you lost my kindly imagine a situation. Now the property, the entire property is vested with the government. Property, some of the property has not been, application was not filed, therefore it was returned to the original owner. Original owner KG Puttana idira. KG Puttana ಆಯ್ತು ಅಂತಾರೆ, again it was revert back to him. ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ extent ಹೇಳಿಲ್ಲ ಅವರು. Under the partition, now in view of the vesting of the property with the government, the contents or the recital of the document will not hold good. It cannot revert back to the person under this document. ಏನು land ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಹೋಗ್ಬೇಕು. It cannot be under the partition deed prior to the vesting of the property to the government. It will go to the ಇದು ಅಂತ ಹೇಳಿದ್ರೆ, then it is only with the subsequent proceeding between the parties to the procedure.
Even it goes back to the original owner Puttana ಅಂತ ಇಟ್ಕೊಳ್ಳಿ.
ಹೌದು.
Whether one of the son was only entitled for a share.
Now what is prayer notice? Prayer is partition ಆಗಿದ್ರೆ ನಾನು ಹೇಳ್ತಿದ್ದ ಹಾಕೊಳ್ಳಿ ಎಲ್ಲ ಪಾರ್ಟೀಸು ಸೇರಿಸಿ.
ಆಯ್ತು partition ಆಗ್ಲಿ, but
what is the declaration of a title or this property?
Sale ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನ್, what is the basis for selling the property? What is the basis for selling the property?
That is RDC.
Based on only the revenue.
Only revenue entry, there is no other document. Now we last may kindly see the declaration is on the basis of a registered partition 1961. Subsequent to that, property was vested with the government.
Prima facie, the property survey number 117 was allotted in his favor in the partition.
In 1961, prior to vesting of the property, that is, once the property is vested with the government.
According to you, it goes to only to you.
ನನಗ್ ಬರ್ತದೆ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ. It will go back to the original ಅಲ್ಲ.
Let the trial court decide.
ಅಲ್ಲ, that is the trial court has said. Your lordship may kindly see.
The very approach of the trial court is not correct.
Now your lordship may kindly see the finding.
Finding he read.
Paragraph 14, my lord. 24. Even according to the plaintiff, after the partition, suit schedule was taken over, they can vested with it. Once
as per the mutation extract produced by the plaintiff himself. Based on the statement of his mother.
Plaintiff has not challenged. Once the land vests with the government, validity of the partition deed is a question to be considered at the final argument. Prima facie, at the time of looking into the prima facie, once the property vest agide, it is on the basis of earlier the partition deed which was executed prior to the vesting of the land in the question. Adu ಮೇಲೆ ನಾವು injunction ಕೊಡ್ತಂತಾರೆ. It is not a question of prima facie. Prima facie means on the basis of the document.
Prima facie means very allotment of property in favor of him in the partition deed when there was a partition.
That is if it I am out of the court if the property were to be not vested with the government. When once the property is vested government, the document ceases to be operative. Registered partition deed ceases to be operative. Again, it will revert. The property will not revert back to the parties as per the partition deed. Now we also may kindly see the partition deed referred to therein. ಯಾಕಂದ್ರೆ 117 ಅಲ್ಲಿ there is no ಇದು. Number
ನೀವು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದೀರಿ ಏನಕ್ಕೇನ್ ಡಾಕ್ಯುಮೆಂಟ್
If we are in possession, my lord. ಅವತ್ತಿಂದ ಬೇರೆ ಯಾರು
ದಾಖಲೆ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳಿ.
ದಾಖಲೆ my lord, the photographs I can produce by
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೋಟೋಗ್ರಾಫ್.
otherwise my lord, he is my lord the no.
Page number.
Only I will pass an order not to alienate till the disposal of
ಅಲ್ಲ,
this.
one submission.
ಪೊಸಿಷನ್ ಆಗಿ ನಿಮ್ಮ ಹತ್ರ ಏನ್ ದಾಖಲೆನೂ
ಅಲ್ಲ,
ಇಲ್ಲ.
one submission.
ಹಾ ಹೇಳಿ.
One submission. One submission.
ಸೇಲ್ ಡೀಡ್ ಇನ್ ಫೇವರ್ ಆಫ್ ಯು ಯಾವಾಗ ಯಾವ ವರ್ಷ?
2007.
2007.
ಅಲ್ಲಿಂದ ನನ್ನ ಅಪೀಲ್ ನಾನ್ ಫೈಲ್ ಮಾಡೋ ತನಕನು ಸೂಟ್ ಹಾಕೋ ತನಕನು ಅವ್ರಿಗೆ ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬಂದಿಲ್ಲ. ಅವ್ರಿಗೂ ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್.
Lordship, may I kindly see page number 33.
ಮೇಲ್
Page number 33 of compilation document ಕೊಟ್ಟಿರಲ್ಲ partition deed ಅಲ್ಲಿ.
ಹೌದು.
There was a reference to the partition suit pending.
ಯಾ ಸೂಟ್ ಯಾರ್ದದು ಇನ್ ಬಿಟ್ವೀನ್ ಹೂಮ್?
Between ಪುಟ್ಟಮ್ಮ and others. Lordship, ಅವರೇ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು, ಯು ಆರ್ ನಾಟ್ ಕ್ಲೈಮಿಂಗ್ ಬೇಸ್ಡ್ ಆನ್ ದಟ್ ದಿ ಸೂಟ್.
ಇಲ್ಲ ನಾನು ಏನ್ ಹೇಳ್ತೇನೆ, ಆಲ್ ದೀಸ್ ಪ್ರಾಪರ್ಟೀಸ್ ವರ್ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ OS number 125 120 of 1950.
ಆಯ್ತು, 124 ಏನಾಯ್ತು?
ಅದು ಗೊತ್ತಿಲ್ಲ ಅದನ್ನ. I am a purchaser, I am not a party to the proceeding.
Here my lord, where my lord, my father was, the
ಈಗ
Puttanna's father was.
ಈಗ 117 ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಈ ಎಲ್ಲಾರ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಯ್ತಲ್ಲ, ಅದ್ರ ದಾಖಲೆ ಎಲ್ಲಿದೆ?
That is my lord, I have produced, my learned friend also produced, I have also produced my lord.
ಹಾಕಿದೀರಾ?
ಹೌದು ಹಾಕಿದೀವಿ.
ಎಲ್ಲಿದೆ ಅದು?
Kindly. Page my lord 115.
115.
ಹೌದು. That is ended in 22/7/1976.
115.
ಹೌದು. Page 11.
ಹಾ.
ಇದು ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ಡಾಕ್ಯುಮೆಂಟ್. ನಾನು ಓನ್ಲಿ ರೆವಿನ್ಯೂ ಮುಟೇಶನ್ ಎಂಟ್ರೀಸ್ಗಳು ಮತ್ತೆ ಫಾರ್ಮ್ 10 ಅಷ್ಟೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು. ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಡಿಫೆಂಡೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು. ಇದರಲ್ಲಿ 117 ಇದೆ.
ಬಟ್ ಯಾರಿಗೆ ಎಷ್ಟು ಹೋಯ್ತು ಏನೋ ಇಲ್ವೇ?
ಅಲ್ಲ, ಅದು ಬರೀಲಿಕ್ಕೆ ಅವತ್ತು ಏನಾಗಿದೆ,
ಈ ಬಗ್ಗೆ ರಾಜಪಡಿಸ ಎಲ್ಲ ದಾಖಲೆ ಪರಿಶೀಲಿಸಿ
ಅನುಭವದ
ಜಮೀನನ್ನು ಅನುಭವ
exactly,
ನಿಬಂಧನೆ
what extent they are in possession and cultivation to that extent
ತೀರ್ಮಾನಿಸಲಾಯ್ತು ಅಂತಿದೆ. ಯಾರಿಗೆ ಎಕ್ಸ್ಟೆಂಟ್ ಏನು ಇಲ್ಲ.
ಇಲ್ಲ, ಅಲ್ಲಿ ಏನದು ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಬರ್ದಿದ್ದಾರೆ ಅಲ್ಲಿ ಮೇಲೆ. ಓವರ್ ಆಲ್
ಅದು ಎಲ್ಲ ಆಸ್ತಿ ಸೇರಿ 30 ಎಕರೆ.
ಹೌದು. ಇವಾಗ ಕೊಡುವಾಗ 4 ಎಕರೆನಲ್ಲಿ ಅವ್ರು ಇದ್ರು, ಇನ್ನು ಉಳಿದಿದ್ ನಮಗ್ ಬಂತು. ಇಲ್ಲಿ ಅದನ್ನ ಎಂಟ್ರಿ ಇಲ್ಲಿ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ನೆಕ್ಸ್ಟ್ ಕೈಂಡ್ಲಿ
4 ಎಕರೆ ಅವ್ರಿಗೆ ಹೋಗಿದೆ ಅನ್ನೋದಕ್ಕೆ ಏನಾದ್ರು ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ?
ಇಲ್ಲ they have not they have not produced any material.
ಅಲ್ಲ ಇಲ್ಲಿ
ಟೆನೆಂಟ್ಸ್ ಗೆ
ಕೈಂಡ್ಲಿ ತೋರಿಸ್ತೀನಿ.
Turn to my objection statement to 100 MFN number
Page
1684 ಅಲ್ಲಿ.
64.
ಇಲ್ಲಿ page 64 ಅಲ್ಲಿ this document shows my lord earlier to proceedings, conclusion of the proceedings. The typed copies I produced relevant page 65. Survey number 117 is my lord consisting of 7 acre 22 guntas plus 1 acre karab. ಅವಾಗೆ
7 acre 22 guntas total area.
ಹೌದು. Kindly my lord, the next returning of the proceedings. Page my lord 66. Kindly my lord.
117.
ಹೌದು. ಅಲ್ಲ, ಅದು 117 ಇಲ್ಲಿದೆ, ನೆಕ್ಸ್ಟ್ ಇದೆ
66 ಅಲ್ಲಿ ಇದೆ.
ಪೇಜ್ 17 ನಲ್ಲಿ ಇದೆ. 7 acre 22 ಗುಂಟಾಸ್ ಅಂತಾನೆ ಇದೆ.
ಅದೇ ಏನೋ ಮೇ ಬಿ ಅಕ್ಸೆಪ್ಟೆಡ್ ಏನೋ ಇದೆ
ಅಲ್ಲಿ ಬರ್ದಿರೋದು ಹಾಗೆ SMT ಅಂತ.
ಆಯ್ತು.
ನೆಕ್ಸ್ಟ್ ಸ್ವಾಮಿ ಹಾಗೇನೆ
ರಿಟರ್ನಿಂಗ್ ಎಲ್ಲಿದೆ?
ಇದೆ.
ಎಕ್ಸ್ಟೆಂಟ್
ಅಲ್ಲಿ
ಏನಾದ್ರು ರಿಟರ್ನಿಂಗ್ ಏನಾದ್ರು ಎಷ್ಟು ಅಂತ ಇದೆಯಾ?
ಹೌದು ಮಾಡಿದ್ರು.
ಇಲ್ವಲ್ಲ, ಅಲ್ಲಿ ಯಾವ್ದು ಸರ್ವೆ ನಂಬರ್
ಇಲ್ಲ. ಇಲ್ಲಿ ಲಾಸ್ಟ್ಗೆ ಈ ಸರ್ವೆ ರಾಮನಗರದ್ದು ಒಂದು ಸರ್ವೆ ಇದು ಸರ್ವೆ ಟಿಪ್ಪಣಿ ಇದೆ ಅದ್ಬಸ್ ಮಾಡುವಾಗ. ಸರ್ವೆ ನಂಬರ್ ಇದರಲ್ಲಿ ಈ ಸರ್ವೆ ನಂಬರ್ 1 ಪೇಜ್ 146 ಅಲ್ಲಿ ಹಾಕಿದ್ದೀವಿ 11 ಸ್ಕೆಚ್ ಮಾಡುವಾಗ. ಈ RTC ಖಾತೆ ಕಾಯಂ ಮಾಡಿ 3 ಎಕರೆ 28 ಗುಂಟೆ ನಮಗೆ ಬಿಟ್ಟಿದ್ದಾರೆ. 146.
45, 46.
ಎಸ್. ಇಲ್ಲಿ T ಶಂಕರ್ ಅನ್ನೋರಿಗೆ 4 ಎಕರ್ ತೋರಿಸಿದ್ದಾರೆ.
ಟಿ ಶಂಕರ್.
ಹೌದು.
ಹಾ. RTC ಅಂತೆ ಕಾಯ 3 ಎಕರೆ
ಹೌದು.
22 ಗುಂಟೆ.
ಇಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ 147 ಅಲ್ಲೂ ಸ್ವಾಮಿ ಸ್ಕೆಚ್ ಡ್ರಾ ಮಾಡುವಾಗ
ಹ್ಮ್. ಹ್ಮ್.
one one second.
Your lordship may kindly see.
ಹೇಳಿ ಇನ್ನೇನು? Connected ಅದೇ. Same.
Connected matter ಅಲ್ಲಿ, that is with regard to alienation. Kindly have a look at the page number 50.
ಅಂದೆ
My
ಎರಡು
objection
just
statement
ಎರಡು
ಅಲ್ಲಿ I have
appeal
stated, I
ಹಾಕಿದೆ.
have no objection. As ಗಾದಿ ಇಲ್ಲಿ ನಾನು I undertook that I will not alienate the property ಅಂತ.
ಹ್ಮ್.
Your lordship may kindly last sentence.
ಬಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ಮೇಲೆ ಮತ್ತೆ ಕೋರ್ಟ್ ನಾವು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು.
ಹೌದು. I have no intention of alienation. As of now, I have no.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ ಯಾವುದು?
Paragraph number 9 ಅಲ್ಲಿ last your lordship may kindly.
9.
Stated in favor of this defendant is admitted. The
Okay, it
plaintiff
is somehow or
proceedings-
arrest the defendant number 1 as of now. As no
Such
such
intention.
intention of
As
alienation.
now, no
ಅದು ನಾನು
such
ಅಲ್ಲೇ
intention,
ಹೇಳಿದ್ದೀನಿ.
however, the plaintiff having filed this false frivolous case.
ಅದೇ.
ಆಯ್ತು.
ನಾನು ಇಲ್ಲೂ undertook that I will not alienate ಅಂತ ನನ್ನ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಪಾಸ್ ಆಗ್ತದೆ.
My lordship, my
As got the alienation concerned,
ಅಂಡರ್ಟೇಕಿಂಗ್ ಅಲ್ಲಿ
ಅಲ್ಲ entry order was passed.
ಹಾ.
It is on the basis of I undertook that I will not alienate ಅಂತ.
ಕೈಯ ವಾಸ್ ರಿಜೆಕ್ಟೆಡ್ ಅಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ಆ ಯಾಸಿಗಾದ alienation
ಇಲ್ಲಿ ನೀವು ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂಡರ್ಟೇಕಿಂಗ್.
ಹೌದು ಕೊಟ್ಟಿದ್ದೀನಿ.
ನಾಟ್ ಟು ಎಲಿನೇಟ್.
ನಾಟ್
Page
ಅದಕ್ಕೋಸ್ಕರ ಆಯ್ತು. As the possession is concerned, the request to be rejected.
Page 57.
ಅಯ್ಯೋ one
Page
ಯಾವ್ದ್ರಲ್ಲಿ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲ?
ಅಲ್ಲ ಮೈ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ
ನಿಮ್
my
paper
lordship
book.
has how returning of proceedings ಸಂಬಂಧಪಟ್ಟಂಗೆ
ಹೇಳಿ.
page 57.
ಹಾ.
ಅಲ್ಲಿಗೆ RRT proceedings ರೆಫರೆನ್ಸ್ ಅಲ್ಲಿ ಬರೀತಾರೆ ಸ್ವಾಮಿ ಅಲ್ಲಿ.
ಅದೇ ಇವ್ರ ಹೆಸರಿಗೆ ಬಂತು ಅಂತ.
ಹೌದು ಅಲ್ಲ ಅದ್ರ ಹೆಂಗ್ ಬಂತು ಅಂತಾನು
ಇವ್ರ
ಬರೀತಾರೆ.
ಹೆಸರಿಗೆ ಮಾಡಿದ್ರು ಅಂತ.
ಅಲ್ಲ ಅಲ್ಲಿ ಬರ್ದಿದ್ದೆ ಹೆಂಗ್ ಬಂದಿದ್ದೆ ಯಾಕೆ ಅಂತಾನು ಬರೀತಾರೆ. 93
ನ್ಯಾಯ ಮಂಡಳಿಯವರುಗಳನ್ನು ಹಿಂದಿರುಗಿಸಿದ ಬಗ್ಗೆ ಅಂತ ರೆಫರೆನ್ಸ್ ಇದೆ.
ಹೌದು
ಆದೇಶ
ರೆಫರೆನ್ಸ್ ಇದೆ.
ಹೌದು.
ಬಟ್ ಆರ್ಡರ್ ಇಲ್ಲ.
ಆರ್ಡರ್ ಇಲ್ಲ.
ಆರ್ಡರ್ my lord, order is I also verified my lord, it is which is available to my learned friend, it is the only order.
ಆಯ್ತು ಅದು
It
ಆಮೇಲೆ
is-
ಲೆಟ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡಿಸೈಡ್.
My actual submission is my lord, by virtue of that returning of land, she is the only collector of the document, document of the title, collector of the title. Then my lord, the title vests with the family. Again my lord, the partition will prevail. Alumelama or Prabhakar will not have an absolute right by virtue of returning of land. Since my lord, the partition among the family members is a contract between the family that is prevailing.
What the appellant counsel and also.
Another
the
one
counsel
submission,
appearing
my lord.
respondent. ಹೇಳ್ರಿ.
Let there be, my lord, I am ready to lead evidence. I am not filed even, my lord, the return statement. Time may be fixed, my lord. with
ರಿಟರ್ನ್
the-
ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ಲ.
And status quo may be within 6 months.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿಲ್ವಾ?
ಹಾಕಿದ್ದೀವಿ.
Now, the order ಅದಕ್ಕೆ ಹಾಕಿದ್ದಿಲ್ಲ. This direction may be issued to my lord, expedite the title with the status quo as on today.
ಕನಕಪುರನಾ?
ಕನಕಪುರ.
ಹೌದು.
ಆಯ್ತು ಕೊಡೋಣ. What the appellant counsel and also the counsel appearing to the respondent. These two appeals are filed against the rejection of IA number 1 and 2 filed under order 39 rule 1 and 2 wherein prayer is sought not to interfere with possession of the property and also not to alienate the property till the disposal of the suit. The trial court rejected both the applications and hence these two appeals are filed. The main case of the plaintiff before the trial court that the property belongs to the joint family. Property belongs to the family and it is an ancestral property. And there was a partition in the year 1961. That is dated 21/9 to 1961. The suit schedule property was fallen to his share. And no extent is not mentioned, but in the allotment of share, particularly in favor of this petitioner, survey number 117 is specifically mentioned. And also there is a recital in the partition deed with regard to the tenancy claim made by some of the family members.
Others, my lord, not the family.
Tenancy claim made by the others. And also counsel would contend that subsequent to the partition also tenancy proceedings was also taken place. And property 117 was returned to the family, but the same was mutated in the name of the Alumelamma, who is the wife of Puttannalla.
Yes.
Puttanna, who is the propositus of the family. And subsequently, the respondent A.G. Prabhakar got the property in his favor clandestinely, and subsequently when the Prabhakar passed away, his wife executed a document. Hodala?
ಹೌದು
One-
in favor of the
Wife ತಾನೆ, KG Prabhakar wife.
One submission.
ಹೇಳಿ.
I left my lord while submitting.
ಏನ್ ಹೇಳಿ?
That order, my lord, 22/7/1976,
ಹಾ,
where, my lord, all the family members, my lord, including Puttanna, his children were partying.
ಹೌದು, ಹೌದು. ಹಾ, ಅದ್ ಹೇಳಿದ್ರಲ್ಲ, ತೋರ್ಸಿದ್ರಲ್ಲ ನೀವು.
While returning this, my lord,
ಹಾ,
to the property,
ಹಾ,
as per section 11 of the Land Reforms Act,
ಹಾ.
then, my lord, it has to go to all the members.
ಅದ್ರಲ್ಲಿ ಮಾಡಿದಾರ ಆತರ ಇಲ್ಲಲ್ಲ?
It
It
is a
should go to
presumption, my
whom
lord,
ಅಂತ
it is
ಏನಾದ್ರು
left.
ಮಾಡಿದಾರ?
They
ಇಲ್ಲಲ್ಲ?
can, 44, they can only decide, my lord, the tenants.
ಆಯ್ತು, ಏನಾಯ್ತು ಹೇಳಿ? ಹಾ. Document in favor of defendant number 1 and the same is challenged before the trial court filing a suit seeking the relief of declaration, and also contend that plaintiff is in possession of the property, and also contend that if any property is further sold, it will create multiplicity of proceedings, and hence sought for an interim order praying to protect the possession of the property as well as restrain the defendant from interfering with peaceful possession of enjoyment of the property, and also restrain the defendant from alienating the property during the pendency of the suit. The defendant appeared and filed a written statement resisting the application, contending that
as on that not filed. ಅವತ್ತಿನ
Written statement was not.
written statement ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ ಹಾಕಿಲ್ಲ ಅವತ್ತಿನ ದಿವಸ
Objections ಹಾಕಿಲ್ಲ.
Objections ಹಾಕಿಲ್ಲ.
Objections, filed objections.
Except denial.
Those IAs contending that the defendant is the absolute owner in possession of the suitable property by virtue of the sale deed dated 5/5/2007, executed by the mother. Motherನು ಸೇರ್ ಬರ್ಕೊಟ್ಟಿದಾರ.
Sudha mother.
Sudha is the mother of
Mother ಅಂದ್ರೆ defendant's mother.
defendant 2 and
Number 2 and 3, our mother.
2 and 3 mother.
Defendant number 2 and 3 mother, that is defendant number 1
ಇಲ್ಲ ಇಲ್ಲ
ಅವ್ರಿಲ್ವ ಈಗ?
ಅವ್ರಿಲ್ಲ ಅವರು ಇಲ್ಲ.
Defendant number 1 ಈಗ purchaser ತಾನೆ.
I am the purchaser.
Defendant number 2 and 3 content objections ಹಾಕಿ defendant number 1 ಅಲ್ವಾ?
Defendant number 1.
Defendant number 1 contend that the mother of the defendant number 2 and 3 executed the sale deed in favor of the defendant number 1. And the KG Prabhakar was the absolute owner and in possession of the suitable property, and after his death, his wife, that is Sudha, executed the sale deed in his favor, and he was put in possession and enjoyment of the same. The assertion of the plaintiff that the suitable property was fallen to his share in family partition is denied, and contend that plaintiff has no right, title, interest over the property, and trying to interfere with the possession. And defendant was not made a party in the proceedings before the assistant commissioner, and plaintiff also not made out prima facie case, and hence prayed the court to reject the application. The trial court, having considered the pleadings of both the parties and also taken note of the claim made by the plaintiff that the property fallen to the share of the plaintiff in terms of the partition dated 21/9/1961, and also taken note of the contention of the defendant. And also in paragraph number 10, taken note of the family genealogy, it appears that plaintiff is the son of late Puttanna and Almelamma, father of the defendant number 2 and 3 by late KG Prabhakar is also one of the brother of the plaintiff and is no more. Mother of the defendants number 2 and 3 by name Sudha, who is the vendor of the suitable property, executed the sale deed in favor of defendant number 1, and she is also no more. The trial court, also having considered the relationship between the parties as well as flowing of title is concerned, and also taken note of the partition deed dated 21/9/1961. Since claim was made by the plaintiff that property 117 was fallen to the share of the plaintiff, but taken note of the mutation extract produced by the plaintiff discloses that government returned those properties to the original owner. And at that point of time, serial number 117 was returned to the mother of the plaintiff by name Almelamma. And as per her statement, mutation was effected in the name of the brother of the plaintiff by name KG Prabhakar, and since then his name appeared in the RTC as owner in possession. And also taken note of the fact that sale deed was executed by said Sudha in favor of defendant number 1. However, in paragraph number 14 comes to the conclusion that scheduled property was taken over by the government and vested with the state. And as per the mutation extract, thereafter it was came to the name of the Valmelamma, and revenue records are entered in the name of the Prabhakar. And also an observation is made that once the land was vested with the government, the validity of the partition deed dated 21/9/19, the question to be considered at the time of the trial. And at this stage, the plaintiff has not made out any prima facie material. With regard to the possession is concerned, also comes to the conclusion that only photographs are produced, and photographs cannot be relied upon with regard to the possession is concerned for the social property, and rejected the same. Being agreed by the said order passed by the trial court, the counsel appearing for the appellant would vehemently contend that when there was a partition in the family, and when the survey number 117 was allotted in respect of in favor of the appellant, also not in dispute that property originally belongs to one Puttanna. It is also not in dispute that there was a partition, and the same is also a registered partition. The counsel also would submit that when the entire extent was vested with the state, and thereafter, when the determination was made with regard to the tenancy is concerned, 3 acre 23 guntas was returned to the family. And clandestinely, the revenue entries are made in favor of the Halmelamma, and also the other son, Prabhakar, also got mutated in collusion with the revenue people, and subsequently it was sold. But the fact is that when the property was allotted in favor of the plaintiff in the registered partition deed, if remaining property also shall vest with the plaintiff only, not with the Almelamma, and any document is created, and the same will not confirm any title in favor, either in favor of the Prabhakar or in favor of the Almelamma also, and they were not having any right to execute the property. The counsel also relying upon the judgment reported in 2024 SEC online SC 517 brought to notice of this court that if any property is transferred, the very person who is having the right to transfer the property must have the right, but if the vendor is not having any title to sell the property, question of conveying any title doesn't arise. The counsel also vehemently contend that when the property was restored back to the family, it should go to the plaintiff only, since there was a registered document of partition. And instead of that, creating of revenue documents, transfer was made. And also counsel would contend that the suit is filed for the relief of declaration, particularly challenging the very sale deed. The trial court fails to take note of the document of the partition deed, and the same itself is the prima facie case in favor of the plaintiff. The same has not been considered. Per contra, the counsel appearing for the respondent would contend that the defendant number 1 had purchased the property from defendant number 2 and 3's mother. And also all the revenue records were standing in the name of the vendor, and also contend that sale was made in the year 2007. And though challenge made in the revenue entries is concerned, and when the property was sold in the year 2007 and property was also delivered, possession was delivered in 2007, plaintiff has kept quiet and filed the suit into 2024. 24 suit to 23.
No, it's 22.
2023.
20.
And also counsel would contend that no prima facie document is placed before the trial court to show that as on the date of filing of the suit, the plaintiff is in possession of the property, and hence the trial court rightly comes to the conclusion that based on the photographs, possession cannot be ascertained. And apart from that, all the documents are stands in the name of the defendant subsequent to the purchasing of the property. And also counsel brought to notice of this court when the objection was filed, in the very objection statement itself has stated that not going to make any alienation, but however the trial court rejected both the application and it doesn't require any interference. Having heard the appellant counsel and also the counsel appearing for the respondent and also considering the material on record, particularly the registered document of partition dated 21/9/1961. It is not in dispute that survey number is mentioned, that is 117, but the total extent is not mentioned in the partition deed, but it is allotted in favor of the plaintiff. There is no dispute with regard to the said fact is concerned since the document was registered document. It is also not in dispute that in respect of the partition deed is concerned, there is a reference that there are some claims made by the tenants. And also reference is also made, the same has to be ascertained and the same has to be adjusted afterwards, the determination of the claim made by the tenants. It is also not in dispute that the proceedings was taken place and subsequently the revenue entry, even while entering the same in favor of the Alumelamma also. The property was returned to the family, but the document was made in favor of the Alumelamma. It is also important to note that in the schedule mentioned in favor of Puttappa, also survey number 117 is not allotted, and also the same is not allotted in favor of any of the family members in the said partition deed. It is also important to note that subsequent to the entering the revenue entry in the name of Alumelamma, and the same was also got transferred in the name of Prabhakar. That is only based on the statement of Alumelamma, and subsequently the wife of said Prabhakar executed the sale deed. When the suit is filed for the relief of declaration and questioning the very title and sale made in favor of defendant number 1, and trial court ought to have taken note of the said fact into consideration and particularly taken note of the partition deed which was registered, wherein survey number 117 was allotted in favor of the plaintiff, but committed an error in coming to the conclusion that plaintiff has not made out any prima facie case and merely making an entry in the MR and also transfer of the same in favor of the husband of the Sudha, that is Prabhakar, and the same will not confer any title, and it is also the settled law that revenue entries cannot be a basis for deciding the title of the parties is concerned. However, the trial court in paragraph number 14 made an observation that plaintiff has not made out any prima facie case only on the ground that once the land was vested with the government, validity of the partition deed dated 21/9/1961 is a question to be considered. And when the trial court comes to the conclusion that validity of the partition deed has to be considered at the time of considering final arguments, and matter requires trial, ought to have granted the relief with regard to the not to alienate the said property, and the same would leads to the multiplicity of proceedings and fails to exercise the discretion in favor of the plaintiff when the very serious dispute is with regard to the transfer of title is concerned. The very contention of the plaintiff also that very property was allotted in the partition deed, and if subsequent sale is made and validity of the sale deed also to be considered by the trial court, and the same at the time of trial, and committed an error in dismissing IA number 2 in passing an order of restraining alienation. However, the trial court taken note of the material on record, only photographs are produced by the plaintiff to establish the possession is concerned, and hence I do not find any error committed by the trial court in coming to the conclusion that based on the photographs cannot decide the issue of possession is concerned, and on the date of filing of the suit, no documents are produced before the trial court having the plaintiff has been in possession of the property on the date of filing of the suit. When such being the case, question of granting the relief of temporary injunction restraining the dependent from interfering with possession unless prima facie case is made out by the plaintiff that the plaintiff has been in possession of the property. And hence I do not find any error committed by the trial court in rejecting the IA number 1. It is also important to note that respondent counsel also brought to notice of this court that in the very objection statement itself, the respondent also given an undertaking that is not going to alienate the property. And they said the objection also said the statement of objections also not taken note of by the trial court while passing an order when the IA was filed restraining to alienate the property. And having taken note of the said fact into consideration, it requires interference of this court, and trial court fails to consider the material on record and matter requires full-fledged trial. And with regard to the sale made by the wife of the said Prabhakar, based on the revenue entries, has to be decided before the trial court. And issue of title is also seriously disputed. Matter requires trial. In view of the discussions made above, I pass the following order. The order passed by the trial court in rejecting the IA number 1 is set aside, and MFA number,
IA number 1 is for possession, interfering with possession.
Possession, sorry, IA number 2 is set aside, and consequently IA 2 is allowed and restrained the defendant public respondent from alienating the suit and property till the disposal of the suit. The order passed by the trial court on IA number 1 is confirmed, and appeal filed by the appellant in MFA number. First one yavadu?
1679 is with regard to possession.
1579.
Interfering with possession.
1579 of 24 is dismissed. The suit is filed in the 1920, suit is filed in 23, and hence the trial court is directed to dispose of the suit within a period of 1 year from today. Both the appellant counsel and also the counsel appearing with the respondents are directed to assist the trial court in disposal of the suit within a time bound period of 1 year.
Submission. My lord, as on today, my lord, I am only cultivating the papaya is planted.
ಏನ್ ಹೇಳಿ?
Papaya is planted my lord, last 7 years.
ಡಿಸೈಡ್ ಮಾಡಕ್ಕಲ್ಲ. That's all.
Status quo, my lord, till my lord will deposit, my lord, whatever the.
Status quo council, serial deed of the year 2007, now how you are claiming that you are in possession?
Lord, he is also not having any other document, my lord, except the sale deed.
Serial deed ಇದೆಯಲ್ಲ, ಸಾಕು ಸದ್ಯಕ್ಕೆ.
Revenue documents are not mutated. He is kept quiet, madam, when his request is rejected in 2009.
ಆಯ್ತು council ನೋಡ್ರಿ, ರಿಲೀಫ್ ಕೇಳ್ಬೇಕಾದ್ರೆ injunction interference as on the date of filing the suit, you must place a document that you are in possession. Without possession, how can the court can pass such an order? That's all. ನೀವು ಇದ್ರ ಸ್ಟೇಟ್ ಇದ್ರಲ್ಲಿ ನಿಮ್ದೇನಾರು ಹೇಳ್ಬೇಕಿತ್ತ?
My lord is.
ನಿಮಗ್ ಫೀಸ್ ಬರ್ಬೇಕಲ್ಲ ಮತ್ತೆ?
Full-fledged trial has to be conducted. Fourth respondent.
ತೊಗೊಳ್ಳಿ, the council, ಅಲ್ಲಿ ಒಂದು sentence ಸೇರಿಸ್ಕೊಳ್ಳಿ. The council appearing for the state AGA submits that
Full-fledged trial.
matter
has to-
requires full-fledged trial since there is a serious dispute with regard to the title is concerned.
Yes, my lord.
And unless the trial is taken place, trial takes place, the issue with regard to the possession cannot be decided. ಅಂತ ಅಷ್ಟೊಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸ್ಕೊಳ್ಳಿ. ಅವ್ರ ಫೀಸಿಗೆ ಬಿಲ್ ಕಳಿಸ್ಬೇಕಲ್ಲ.
Obliged, my lord.
ಸೆಕೆಂಡ್ ಒನ್ ಅಲೋ ಆಗುತ್ತೆ. ಸೆಕೆಂಡ್ ಒನ್ ಅಲೋ ಆಗೋದಲ್ಲ? ಸೆಕೆಂಡ್ ಒನ್ ಅಲೋ ಆಗುತ್ತೆ. ಫಸ್ಟ್ ಒನ್ ಡಿಸ್ಮಿಸ್ ಹೇಳಿದ್ನಲ್ಲ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ.
36. Anirudh.
Obliged.
Preparing for the appellant.
It's
a suit for partition of 1/6 share, my lord. I am the defendant number 14. Plaintiff number 1 to 5 and the defendant number 1 are the descendant of one Muniappa, my lord. Originally, my lord, the Muniappa.
ಡಿಫೆಂಡ್ ನಂಬರ್ 14 ಅಲ್ವಾ?
Please, my lord.
ಆಯ್ತು, you have been restrained from creating any third party charges ಅಷ್ಟೇನೆ
Please, my lord.
ಅಲ್ವಾ?
ಹೌದು sir.
ಆಯ್ತು, ನೋಟಿಸ್ ಬರ್ಲಿ, ಇಲ್ಲಾಂದ್ರೆ ಸರ್ವಿಸ್ ಮಾಡ್ತೀರಾ, ಏನ್ ಹೇಳಿ?
My lord, if I may be permitted to serve the copy of the appeal copy to
Appellant
the
counsel is
advocate
directed to
representing
serve
the.
the copy of this miscellaneous first appeal on the counsel who appears on behalf of the ಅಯ್ಯ ಹಾಕ್ತವ್ರು ಯಾರು?
I act the plaintiffs,
ಪ್ಲೇಂಟಿಫ್ ಮಾತ್ರನಾ?
plaintiffs.
on the ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವ್ರೊಬ್ಬರನ್ನೇ ಮಾಡಿದಿರಾ, ಬೇರೆಯವ್ರನ್ನ ಮಾಡಿದಿರಾ?
ಎಲ್ಲಾರನ್ನು ಮಾಡಿದ್ದೀನಿ.
ಎಲ್ಲಾರನ್ನು ಮಾಡಿದಿರಾ?
ಎಲ್ಲಾರ್ನೂ
ಎಲ್ಲಾರು
ಮಾಡಿದ್ದೀನಿ.
ಬೇಕಾಗಿಲ್ಲ, ನೀವು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Please, my lord. Plaintiffs against.
Issue is only between the plaintiff and defendant number 14 ಅಲ್ವಾ?
Please, my lord.
ಮೆಮೊ ಹಾಕ್ತೀರಾ?
Please, my lord. I will file a
ಕೊಡಿ.
memo on.
ಯಾಕೆಂದ್ರೆ ಅಯ್ಯ ಹಾಕಿರೋದು ಒಂದಿ ಪ್ಲೇಂಟಿಫ್
ಹೌದು sir.
ಅಷ್ಟು. ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಸರ್ವಿಸ್ ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ ಇನ್ನೊಂದು MF ಇನ್ನೊಂದು 20 ವರ್ಷ ಇಟ್ಕೋಬೇಕು.
ಇಲ್ಲ, ನಾನು plaintiff, I'll file a memo.
ಮೆಮೊ ಹಾಕಿ.
Please.
The appellant counsel files memo to dispense the notice against plaintiff. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
Respondent number 1 to 6 are the plaintiffs, my lord.
1 to 6.
Please, hello. 1 to 5, 1 to 5 are the.
Dispense the notice against respond number 6 to
Respondent number 6 to 15, my lord.
6 to 18.
18, my lord. 6 to 18. 6
And
to
hence
18.
notice dispensed against the respond number 6 to 18.
Please, my lord.
6 to 18. In terms of the memo, ಒಂದು ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. Since the issue is between the plaintiffs and the present appellant. This ಬೇಕು ಯಾವತ್ ಬೇಕು?
29th, my lord.
This matter on 29/11. ಸರ್ವ್ ಮಾಡ್ಕೊ ಬನ್ನಿ.
37 urgent 38.
37
Karunakarapi,
urgent 38.
Sangamesh Sharbi,
38 appear to the appellant.
ಕರಪ್ಪಿ ಹೇಳಿ.
Suit for partition.
ಸಂಗಮೇಶ್ ಆರ್ಬಿ ಇದಾರ? ಆಯ್ತು ಬನ್ನಿ.
Unequal share ಅಂತ ಹೇಳಿದೆ.
One dismissed. Suit for partition.
Suit for partition, my lord.
ಆಯ್ತು ಹೇಳಿ.
Alleging unequal share among the family members ಅಂತ ಹೇಳಿ. There was a partition among the family members in the year 2014.
Already there was a partition.
Partition ಆಗಿದೆ. My
Registered.
mother was a party to that partition ಅಂತ ಹೇಳಿ. That has been rejected. My IA is rejected now. Lord, the suit schedule properties, there are about 13 items of suit schedule property.
13 items.
13 items. My lord, mother of the petitioner plaintiffs have been given only two items of the property. The Siddhananga Shetty, the mainly property was acquired by Siddhananda Shetty. He is he who dies in the year 2019. My lord, totally four shares have been made. One for Siddhananda Shetty, one for his wife Sarojamma, and one for elder son Deepak, and one for the wife of the deceased son Chetan Kumar's son, that is Dr. Lavanya ಅಂತ ಹೇಳಿ. So 4 shares ಮಾಡ್ತಾರೆ, out of which, my lord, one portion was kept for Siddhananda Shetty, the other one for Sarojamma, and the third one for Deepak, who gets the major share. My lord, 5 items have been given to him. That only 2 items are given to the mother. And this first plaintiff was born, my lord, at on the date of the partition.
I agree, you are not disputing the earlier partition dated 21/8/2014. ಹೌದಾ?
ಅಲ್ಲ, ಹೌದು.
Now only your contention that partition was
unequal ಅಂತ.
equitable ಅಲ್ಲ ಅಂತ.
ಹೌದು, ಹೌದು.
unequitable
ಹೌದು.
ಅಂತ ಅಲ್ವಾ?
ಹೌದು.
ನೀವು ರಿಲೀಫ್ ಏನ್ ಕೇಳಿರೋದು ಈಗ?
ಅದೇ ನಮ್ಗೆ ಈಕ್ವಲ್ ಶೇರ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದೀವಿ.
Defendants from in any way alienating or encumbering.
ಹೌದು. Not to alienate ಅಂತ ಈಗ ಕೇಳಿದ್ದೇವೆ, because there should be a equal partition. Until then, that the suit schedule property should not be alienated. That is my prayer, my lord.
Yes, counsel ಹೇಳ್ರಿ.
My lord, may kindly come to paragraph number 13 of the.
Who sold the property in favor of you?
I am not the purchaser, my lord. I am the family member.
Purchaser, family member.
I am the family member. There is no
ಮತ್ತೆ
sale.
ಇಲ್ಲಿ ಸಿದ್ಧಲಿಂಗ ಯಾರಿಗೋ
Saroja
sale ಮಾಡಿ.
Shetty and lords Deepak
Family
Shetty.
members of deceased Siddhananda Shetty.
What happens is Siddhananda Shetty is the original owner of the properties who was working as a assistant commissioner in income tax. He purchased all the properties, and some are properties purchased by him, some are properties purchased by his wife, Lord Saroja Shetty, first defendant here. And my lords, what happens? In the year 2014, there is a registered partition among all the family members, including the
Properties which were
Siddhananda
purchased.
Shetty. Siddhananda Shetty. Siddhananda Shetty was alive at that time, my lords.
ಆಯ್ತು.
So it is all, my lords, not any ancestral property. It was purchased by Siddhananda Shetty, his wife and his children. There were 2 children to these 2 people, Siddhananda Shetty and Saroja Shetty. One is, my lords, Chetan Kumar and Deepak Kumar. Chetan Kumar, who is the father of these 2 petitioners, he has expired, my lords. Then, my lords, there was a registered partition on 21/8/2014 after the death of Chetan Kumar. That is one son. Then, my lords,
Kumar is son of the Siddhananda Shetty.
Siddhananda Shetty, who is the father of these 2 minors, my lords. And Chetan Kumar has left his wife, Lavanya Chetan. And this Lavanya Chetan, my lords, who is the daughter-in-law of the first defendant and wife of Chetan, my lords, she is a party to the registered partition in the year 2014. All the properties which were acquired by the family members during their lifetime, including during the lifetime of Siddhananda Shetty, he was also a signatory to this registered partition. Properties were divided among.
Shetty
Also a registered party to, he was alive at that time, lords. ಅವ್ರು ಇರುವಾಗ್ಲೇನೆ ಎಲ್ಲ ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟಿಷನ್ ಆಗಿ ಎಲ್ಲ ಡಿವೈಡ್ ಆಗಿ ಈ ಚೇತನ್ ಶೆಟ್ಟಿ ವೈಫ್ಗೆ ಚೇತನ್ ಕುಮಾರ್ ವೈಫ್ ಲಾವಣ್ಯ ಚೇತನ್ಗುನುವೆ ಶೇರ್ಸ್ ಕೊಟ್ಟು share was allotted to her, share was allotted to the other son, share was allotted to the father, and share was allotted to Saroja Shetty, who is the mother. There was a registered partition with consent. It was divided and they have got their properties, respective properties were allotted to their shares and khata were transferred. In fact, Lavanya Chetan, who is the mother of the plaintiffs, ಅವ್ರಿಗೆ ಅಲಾಟ್ ಆಗಿರೋ ಪ್ರಾಪರ್ಟೀಸ್ ಅವ್ರು ಸೇಲ್ ಮಾಡ್ಕೊಂಡು ಬೇರೆ ಕಡೆ ಪ್ರಾಪರ್ಟೀಸ್ ತಗೊಂಡ್ರು. Everything is done, my lords. Now, after a span of 8 years, this suit is filed saying through the minor children, saying that no, that partitional inequitable ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಈಗ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. That is the reason, lords, given by the trial court that the suit itself is not maintainable. Kindly come, lords, page 13 of para 13, page 13 of the trial court order. May I read para 13, my lords?
Para 13 registered partition.
The plaintiffs themselves have produced the
was filed in 2022 and her husband was not
Partition was
challenged the
effected much prior to
partition,
his death.
during his lifetime. ಗಂಡನು ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಗಂಡ died in the year 2013 itself.
19.
ಅಲ್ಲ ಅದು
ಅಪ್ಪತ್ತಿರೋ
19.
Lords, admittedly, even as
son was passed away
2013.
the father.
ಹೌದು.
ಹೌದಾ?
prior to the father. Lords, admittedly, the properties, even as per the plaint governments, all the properties were acquired by father, that is ಸಿದ್ದನಂಜ ಶೆಟ್ಟಿ, ಈ ಅವ್ರದೇ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಬದುಕಿರುವಾಗ್ಲೇನೆ ಅವರೇ ಎಲ್ಲಾರ್ಗು ಡಿವೈಡ್ ಮಾಡಿ ಪ್ರಾಪರ್ಟಿನ ರಿಜಿಸ್ಟರ್ಡ್ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಈಗ ಮತ್ತೆ ಸಿದ್ದನಂಜ ಶೆಟ್ಟಿ ಸತ್ತ ತಕ್ಷಣ ಈಗ ಆ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಈಕ್ವಲ್ ಡಿವಿಷನ್ ಆಗಿಲ್ಲ ಅಂತ ದಿಸ್ ಇಸ್ ಎ ಸೆಕೆಂಡ್ ಸೂಟ್. ನೋಟ್ಸ್, ದೇ ಹ್ಯಾವ್ ಎಂಜಾಯ್ಡ್ ದ ಪ್ರಾಪರ್ಟಿ, ದೇ ಹ್ಯಾವ್ ಗಾಟ್ ದ ಖಾತಾ, ದೇ ಹ್ಯಾವ್ ಮೇಡ್ ದ ಸೇಲ್ ಡೀಡ್ಸ್, ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಎವ್ರಿಥಿಂಗ್. And now, lords, they say it is inequitable partition through the minors.
Any of the property ನಾವು ಮಾಡಿಲ್ಲ.
ನಿಮ್ ಶೇರಿ ಬಂದಿದ್ದು ಯಾವ್ದು ಸೇಲ್ ಮಾಡಿಲ್ವಾ?
ಯಾವ್ದು ಮಾಡಿಲ್ಲ. In this case, there was 1 crore 38 lakh was given to the wife, that is the mother of this plaintiffs, as a compensation from the company, and another 1 crore was given to as for the death of accidental death, it was. Both the money have been taken by them, my lord. They have developed one this one. That the only share which was given to the plaintiff's mother now. Other than that, nothing is given. So entire money which was because of the death of her husband, they got it. That accidental satidare. He was an engineer. Only 1 crore something was given. So 2 crore 48 lakh was taken by them. And 1/2 constructed building is given to the mother.
ಅವಾಗ ನೀವು ಪಾರ್ಟಿಷನ್ ಆಗುವಾಗ ಯಾಕೆ ಸುಮ್ನೆ ಇದ್ರಿ? ನಿಮ್ಮ
She was in a trauma, my lord. It was death to 2013 ಅಲ್ಲಿ ಆಗುತ್ತೆ. 2000
ಸತ್ತಿರೋದು
immediately before the birth of the child. She was pregnant at that point of time. Before they make a partition deed ಅಂತ ಮಾಡಿಬಿಟ್ಟು they take a signature. ಈಗ ಆಮೇಲೆ with the her money only, because she got all those monies that has been withdrawn by them. Taking all this.
ದುಡ್ಡು ಯಾವಾಗ ಬಂದಿರೋದು ಹೇಳಿ?
ಅದು after
ಪ್ರಕಾರ ಡೆತ್ ಆಗಿರೋದೇ 2013
2016 somewhere ಅಲ್ಲಿ ಎಲ್ಲ I have produced all the.
ಅಷ್ಟೊಳಗೆ ಪಾರ್ಟಿಷನ್ ಆಗೋಗಿತ್ತಲ್ಲ?
ಹೌದು, ಪಾರ್ಟಿಷನ್ ಆಗೋಗಿದೆ. ಬಟ್
ಪಾರ್ಟಿಷನ್ ಆದ್ಮೇಲೆ ನೀವ್ ಹೆಂಗ್ ಅವ್ರ ಕಾಂಪನ್ಸೇಷನ್ ದುಡ್ಡು ಅವ್ರಿಗೆ ಕೊಡ್ತೀರಿ?
ಅಲ್ಲ, 2014 ಅಲ್ಲಿ I have produced
14 ಅಲ್ಲೇ ಪಾರ್ಟಿಷನ್ ಆಗೋಗಿದೆ. 21/8/24
ಸೆಪ್ಟೆಂಬರ್ ಅಲ್ಲೆಲ್ಲ ಮನೀಸ್ ಎಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ. 27 lakh on 24th March ಗೆ.
After the partition, only the wife got the compensation. ಹೌದಾ?
ಹೌದು, ಕಾಂಪನ್ಸೇಷನ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಒಂದು ಸೈಟ್ ಅಲ್ಲಿ in the name of developing a building, they have taken all the money from her only. It is not that now.
That is matter of trial.
ಹೌದು, but only thing that, my lord, we want that now Siddhananja Shetty is died. His property is at item number 1, which has to be at least the plaintiffs will get a share out of that.
ಸಿದ್ದನಂಜ ಶೆಟ್ಟಿಯ ವೈಫ್ ಇದಾರಾ ಇಲ್ಲ?
Wife ಇದ್ದಾರೆ. He has her own ಇದು ಬೇರೆ separate share was given to her.
ಹೌದೇ?
ಸಿದ್ದನಂಜ ಶೆಟ್ಟಿ
ಆಕೆಗೂ separate share ಕೊಟ್ಟಿದ್ದಾರೆ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ.
ಹೌದು.
In the written statement, my lords, filed by the defendants, everything has been extracted. In fact, 11 properties were given to the mother.
That, my lord,
that is the
during the lifetime
mother
of
the
Siddhananda Shetty, the property was acquired in.
ಈಗ ಸಿದ್ದನಂಜ ಶೆಟ್ಟಿಗೆ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ, whether he made any provision for
that I am not aware of, but there is only one property which he retained, my lords.
ಆಯ್ತು, whether he died intestate.
Let them claim on that, but I will also come back, my lords. I have not taken instructions as to whether Siddhananja Shetty has made any will, or even during his lifetime he has gifted the whatever share he has got, or what's that, and never. But the present suit is not for that, my lords. The present suit is for all the properties, and kindly see, my lords, they does not include the properties which are allotted to their share in that partition. ಈ ಬೇರೆಯವ್ರಿಗೆ ಬಂದಿರೋದು ಎಲ್ಲಾನು 2015
ಅವ್ರಿಗೆ ಬಂದಿದ್ದು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿ,
ಅವ್ರಿಗೆ ಬಂದು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಲ್ಲ.
ಮಾಡಿದೆ ಇದೆ.
ಯಾವ್ದು ಐಟಮ್? ಯಾವ್ದು
ಶೆಡ್ಯೂಲ್ ಐಟಮ್? all the 13 items ನಾವು ಶೇರ್.
13 items ಅಲ್ಲಿ ನಿಮ್ದು ಯಾವ್ದು ಹೇಳಿ? ನಿಮಗೆ ಬಂದಿರೋದು ಯಾವ್ದು ಶೆಡ್ಯೂಲ್ ಐಟಮ್ ಪಾರ್ಟಿಷನ್ ಡೇಟ್ ಪ್ರಕಾರ?
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ?
Return
ಹಾಕಿದ್ದಾರೆ,
statement.
Return statement ಅಲ್ಲಿ your lordships will find the properties, list of properties allotted, my lords.
ಹಾ.
At page 4 of the return statement, my lords.
ಹಾ.
Share of Lavanya Chetan, wife of B.S. Chetan. ಅದರಲ್ಲಿ each share ಯಾರ್ಯಾರಿಗೆ ಹೋಗಿ ಎಷ್ಟೆಷ್ಟು ಹೋಗಿದೆ ಅಂತ
ಲಾವಣ್ಯ ಚೇತನ್. ಹಾ.
this is the property, these are all the properties, my lords, allotted to her.
Item number 8 ಮತ್ತೆ 9. Item number 8 and 9 ನಮ್ಮ ಮದರಿಗೆ ಸಿಕ್ಕಿರೋ ಪ್ರಾಪರ್ಟಿ in the plaint.
ಈಗ ಮಕ್ಕಳು ಹಾಕಿರೋದು ಈಗ ಮೈನರ್.
ಹೌದು,
ಇದು ಮಕ್ಕಳ ಕಡೆಯಿಂದ
the daughter was born actually, my lord, and she was pregnant. She was not made party to the ಇದು ಅವಳಿಗೇನು ಕೊಟ್ಟಿಲ್ಲ. Partition
ಸೂಟ್ ಹಾಕಿರೋದು ಒಬ್ನೇನಾ?
ಅಲ್ಲ, ಮಗಳು ಇಬ್ಳು ಡಾಟರ್.
ನಿಹಾರಿಕಾ ಚೇತನ್ ಅಂತಿದೆ.
ನಿಹಾರಿಕಾ ಚೇತನ್ ಮತ್ತೆ another is ಅವಂತಿಕಾ ಚೇತನ್.
ಇಬ್ರು ಹಾಕೋರ?
ಹೌದು.
ಆಯ್ತು, ನೀವು ಈ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ 8 and 9 ಯಾವ್ದೋ ಬಂದಿದೆ ಅಂದ್ರಲ್ಲ?
ಬಂದಿದೆ.
ಅದನ್ನ ನಿಮ್ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ತೋರಿಸಿದಿರಾ? ಪ್ಲೈಂಟ್ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ?
ಹೌದು, ತೋರಿಸಿದ್ದೇವೆ, ಅದನ್ನೆರಡನ್ನು ತೋರಿಸಿದ್ವಿ.
ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಪ್ಲೈಂಟ್.
ಪ್ಲೈಂಟಿನ 8 and 9 ಶೆಡ್ಯೂಲ್ ನಮ್ದೇ.
8 and 9?
ಹೌದು.
ಪ್ರಾಪರ್ಟಿ ಸಿಚುಯೇಟೆಡ್ ಅಟ್
ಲಿಂಗದೀರನ ಹಳ್ಳಿ.
ಶೆಡ್ಯೂಲ್ ಯಾವ್ದಂತ ಹೇಳಿಲ್ಲ, ಬರೀ ಲಿಂಗದೇವರನಹಳ್ಳಿ ಅಂತ ಹೇಳ್ತೀರಿ.
ಅದೇ ಹೇಳಿದೆ, ಅದು ಯಶವಂತಪುರ ಹೋಗಿ.
ನಂಬರ್ 2000 ಪ್ರಾಪರ್ಟಿ ನಂಬರೇ ಇಲ್ಲ ಅದ್ರ. ಎರಡು ಲಿಂಗದೇವರನಹಳ್ಳಿ ಅಂತ.
ಹೌದು, ಅದು ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಡಿಸ್ಪ್ಯೂಟೆಡ್. ಇದು BBMP ಕೆಳಗಡೆ ದೇ ಆರ್ ಟೇಕಿಂಗ್ ಪೊಸೆಷನ್ ಆಫ್ ದಿ ಇದು. ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಎ ಕೇಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿಸ್. ದ ಓನ್ಲಿ ಪ್ರಾಪರ್ಟಿ ವಿಚ್ ಇಸ್ ಗಿವನ್ ಟು ದೆಮ್.
ಇದೆಯಲ್ರಿ ಪ್ರಾಪರ್ಟಿ ಅದು?
ಅದೆರಡು
8 and 9 ಇದೆಯಲ್ಲ?
the numbers are not mentioned, my lords.
ನಂಬರ್ ಹಾಕಿಲ್ಲ. ಲಿಂಗದೇವರನಹಳ್ಳಿ ಅಂತ ಮಾತ್ರ ಹೇಳ್ತಾರಷ್ಟೇ. ಅದು ಅಲ್ಲಲ್ರಿ, ಹುಲದೇಗನಹಳ್ಳಿ ಅಂತಿದೆ, ಇದು ದಾಸನಪುರ ಹೋಗ್ಲಿ ಬೆಂಗಳೂರು ಅಂತಿದೆ.
ಅಲ್ಲ, ನಾನು ಪ್ಲೈಂಟ್ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಲಿಂಗದೀರನಹಳ್ಳಿ ಯಶವಂತಪುರ
ಮಾಡಿದಿರಿ.
ಹೌದು.
ಬಟ್ ನೀವ್ ಹೇಳ್ತೀರಾ ಇಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 8 and 9.
ಹೌದು, ಕ್ಲೈಂಟ್ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 8, 9 ಪಾರ್ಟಿಷನ್ ಡೀಡಿನ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ 4th ಐಟಮ್ ತೋರಿಸಿದ್ದಾರೆ. ಅದೇ ಸೇಮ್ ಲಿಂಗದೀರನಹಳ್ಳಿ ಯಶವಂತಪುರ ಹೋಬಳಿ ಬ್ಯಾಂಗ್ಳೂರ್ ನಾರ್ತ್ ತಾಲೂಕು. ಹೌದು, 3252.
In fact, this is the most valuable property that is allotted to item number 4 ಲಿಂಗದೇವರಹಳ್ಳಿ. You lordships may kindly come to the return statement.
ಅಲ್ಲ, ಬೇರೆ ಇದೆ, ಅದು ಊರೇ ಬೇರೆ ಇದೆ. ಹೇಳ್ತಾ ಇರೋದು ಅದೆಲ್ಲ ಅದು. ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಎಲ್ಲಿ ಇದೆ ಹೋಗ್ಲಿ? ಅದ್ರಲ್ಲ ನೋಡೋಣ, ಪಾರ್ಟಿಷನ್ ಏನಾದ್ರು ಗೊತ್ತಾಗ್ತದ ಅಂತ.
Partition deed.
ಪಾರ್ಟಿಷನ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವರು ಹಾಕಿದ್ದಾರೆ. ಮೆಲೋಡ್ ಕೈಂಡ್ಲಿ ಸಿ ಅಟ್ ಪೇಜ್ ನಂಬರ್ 67 ಅಲ್ಲಿ ಆಫ್ ದಿ ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಅದರಲ್ಲಿ ಶೇರ್ ಆಫ್ ಸಿದ್ದನಂಜ ಶೆಟ್ಟಿ ಐಟಮ್ ನಂಬರ್ 1 ಓಲ್ಡ್ ಸರ್ವೆ ನಂಬರ್ 72 ಪ್ರೆಸೆಂಟ್ 72/4 acre 25 ಗುಂಟಾಸ್ ಅಂತ ಇದೆ. ಸೋ ಫಾರ್ ಎಸ್ ಸರೋಜ ಶೆಟ್ಟಿಗೆ ಸೆಕೆಂಡ್, ಈಗ ಇಲ್ಲಿ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ಗೆ 2 ಐಟಮ್ಸ್ ಇದೆ. ಅದರಲ್ಲಿ ಸೈಟ್ ನಂಬರ್ 45, 46 ಅದರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ. ಇಟ್ ಇಸ್ 42 ಸ್ಕ್ವೇರ್ ಏನೋ ಇರುವಂತ ಒಂದು RCC ರೂಫ್ ಹೌಸ್ ಇದೆ. ವಿಚ್ ಇಸ್ ಆಲ್ ದಿ even the plaintiffs were residing there only. Actually, plaintiff, defendant, everyone. And
share of ಸಿದ್ದನಂಜ ಶೆಟ್ಟಿ.
ಹೌದು,
ಅವರಿಗೆ OS ಏನು ಓಲ್ಡ್ ಸರ್ವೆ ನಂಬರ್ 72, ಪ್ರೆಸೆಂಟ್ ಸರ್ವೆ ನಂಬರ್ 2, 4 acres 25 ಗುಂಟಾಸ್.
ಹೌದು,
ಲ್ಯಾಂಡ್.
ಹೌದು. ಶೇರ್ ಆಫ್ ಸರೋಜ ಶೆಟ್ಟಿ ಮತ್ತೆ
ದೀಪಕ್ ಸೆಕೆಂಡ್ ಸನ್.
ಅವರಿಗೆ 5 ಐಟಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ. 5 ಐಟಮ್ಸ್.
Partition deed ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? You have the partition deed. Partition deed you have.
ಇದೆ ನನ್ನ ಹತ್ರ ಇದೆ.
the mother ಗೆ ಕೊಟ್ಟಿರೋದು next ಇದರಲ್ಲಿ only 2 items.
Whether all these properties are self-accord properties of the.
Yes, they themselves say that.
Again, too.
I don't say, they say in the plaint.
They say that Saroja, in the name of Saroja Shetty, the properties were purchased, the written statement alle ಹೇಳ್ತಾರೆ, it was purchased. Siddhananda Shetty purchased properties
Even assuming that.
in his name and his wife's name ಅಂತ ಹೇಳ್ತಾರೆ.
ಆಯ್ತ್ರಿ, even.
ನಾವು ಹೇಳ್ತೇವೆ that it was purchased by Siddhananda Shetty only. Whether it is purchased in the name of Saroja Shetty.
Sorry, now how you can contend that is an inequitable partition? It is left to the discretion of the person who had purchased the property.
And
It is
who was a partition, who was a party to the
self-accord
partition.
property of Siddhananda Shetty. That is his will. He can give the property to anybody else. How you are entitled for a share?
But in that first item, my lord.
During his lifetime only, he had
Yes, then
partitioned
He's
the
a party to
property.
that partition.
He had partitioned the property during his lifetime only. And all the properties are exclusively belongs to the Siddhananda Shetty. However, he made the provision during his lifetime.
Yes.
Yeah, it is not your case that ancestral property, they have given the share inequitable partition on Talva. First of all, suit time not maintainable.
ಅಲ್ಲ ಫಸ್ಟ್ ಐಟಮ್ ಅಲ್ಲಿ ಇದೆ ಈಗ. ಫಸ್ಟ್ ಐಟಮ್ ಆಫ್ಟರ್ ಹಿಸ್ ಡೆತ್ ಮೈ ಲಾರ್ಡ್ ದೀಸ್ ಪ್ಲೈಂಟಿಫ್ಸ್ ವಿಲ್ ಆಲ್ ಗೆಟ್ ದಿ ಶೇರ್.
ಅದ್ ನೋಡ್ಬೇಕು.
ಫಸ್ಟ್ ಐಟಮ್ ಅಲ್ಲಿ that ಫಸ್ಟ್ ಐಟಮ್ ವಿ ಹ್ಯಾವ್.
Let the trial court decide.
In fact, para 5 ಅಲ್ಲಿ, para 5 of the plaint, they themselves pay para 5 of the plaint. It is submitted that all the properties mentioned above was acquired by Siddhananda Shetty during his lifetime with his independent income. And some properties were purchased in the name of his wife and
Heard the
children.
appellant counsel and also the counsel appearing for the respondent. And a suit is filed for the relief of partition, claiming that the share given in favor of the plaintiff mother in the registered partition dated 21/8/2014 is inequitable. And plaintiff is entitled for a share. Plaintiff is entitled for a share of, plaintiffs are entitled for a share, equitable share in the property belongs to the Siddhananda Shetty. And hence prayed the court not to alienate the property. For contra, the counsel appearing for the respondent would contend that already there was a partition during the lifetime of Siddhananda Shetty, and the same was registered on 21/8/2014. And he also passed away on 26/10/2019. And also brought to notice of this court that equitable partition was made during his lifetime itself, and plaintiff is not entitled for any, plaintiffs are not entitled for any share. And also they kept quiet from 2014 to 2022. And only the mother of the plaintiffs got set up these two plaintiffs filing this suit. ಇಲ್ಲ ರೀ, ಅವ್ರ ಮಕ್ಕಳೆಲ್ಲ ಬದುಕಿದ್ರು ಅವಾಗ್ಲೇನೆ. 2014
ಒಬ್ರು ಬದುಕಿರ್ಲಿಲ್ಲ.
ಇದ್ರು
ಇಲ್ಲ, ಒಬ್ರು ತೀರೋಗ್ಬಿಟ್ಟಿದ್ರು. That is the reason, my lords.
ಅಲ್ಲ, ಇವಳು ಫಸ್ಟ್ ಪ್ಲೇಂಟಿಫ್ ನಿಹಾರಿಕಾ ಜೈನ್ ವಾಸ್ ಬಾರ್ನ್.
They were born.
ಇಬ್ರು ಅಲೈವ್ ಅವಾಗ ಇದ್ರು, ಬದುಕಿದ್ರು.
Of course they were born.
ನಂತರದಲ್ಲೇನು ಹುಟ್ಟಿಲ್ಲ, ಅವ್ರು ಆಗ್ಲೇ ಹುಟ್ಟಿದ್ರು.
Oh, they were born.
ಏನಾಯ್ತು ಮೇಡಮ್? Set up these plaintiffs for filing this suit and filed frivolous suit. The trial court having taken note of the pleadings of the parties, particularly in paragraph number 13, made an observation that the plaintiffs themselves have produced the partition deed dated 21/8/2014. And also taken note of the fact that the said Siddhananjappa also died on 26/10/2019. And also taken note of the fact that partition was effected much prior to the death of the said Siddhananda Shetty. And also contend that defendant number 1 is his wife. Out of the said wedlock, Siddhananda Shetty and his wife or two children have begotten, namely B.S. Chetan and B.S. Deepak, who is defendant number 2. The plaintiffs are the children of deceased B.S. Chetan. The trial court also taken note of the fact that during the lifetime of Siddhananda Shetty, he has allotted the share in favor of the mother of the plaintiffs. And also, an observation is made that if at all the plaintiffs are entitled to the share in the suit scheduled property, that is out of the share that would have been fallen to the share of B.S. Chetan. The parties have not disputed the registered partition deed dated 21/8/2014. There are many properties in the schedule, and some of the properties have been purchased by the family members of the deceased Siddhananda Shetty. And also trial court comes to the conclusion that whether the plaintiff will succeed in the suit is immaterial at this stage. The suit is also filed after nearly 8 years from the date of the registered partition. Hence comes to the conclusion that referring the judgment of the Apex Court 1995 within bracket 5 SEC 545 in the case of Messrs. Gujarat Bottling Company Limited and others versus Coca-Cola, and wherein an observation is made that factors to be considered in exercise of discretion. The injunction being an equitable relief cannot conduct parties seeking. The injunction has to be looked into and dismissed the application in coming to the conclusion that plaintiff has not made out any prima facie case for granting the order of injunction. Being agreed by the said order, present appeal is filed. The counsel appearing to the appellant also would vehemently contend that trial court committed an error in taking into note of the fact that the father of the plaintiff died prior to the partition and taking the advantage of their mother under distress on account of death of their father. Partition was made in the year 2014 within a span of 1 year of the death of the plaintiff's father, that is on 21/8/2014. The counsel also brought to notice of this court that there is an inequitable partition and only 2 properties are given at the time of partition, and even contend that even 5 properties are given to the other son, and hence matter requires the interference of this court. Per contra, the counsel appearing to the respondent would contend that in the plaint itself, they have specifically stated that the property belongs to the Enta Shetty or no?
Siddhananda Shetty.
Siddhananda Shetty. And also specific pleading is made that the properties are purchased by the said Siddhananda Shetty. And he had already partitioned the property during the lifetime, and partition was also taken place in 2014, and after lapse of 8 years, suit was filed. And trial court has assigned the reason while dismissing the application. And nothing requires for consideration. Having heard the appellant counsel and also the counsel appearing for the respondent, admittedly, there is a registered partition dated 21/8/2014 and suit is filed in 2022. And also material discloses that plaintiff's father died prior to 2014, and subsequent to the partition also not challenged the same and only challenged in 2022 after 8 years. The counsel appearing to the respondent would contend that after the partition also some of the properties are sold by the plaintiff, and the same has been disputed by the counsel appearing to the appellant that no such sale was made. The only ground urged before the court is that there is an inequitable partition. Whether there is an inequitable partition or not, the matter once again it requires full-fledged trial, and court has to take note of the validity. The court has to take note of the value of the properties allotted and not the number of the property. And also the matter has to be decided whether plaintiffs are entitled for a share in the property. And specific pleading is also made that the properties exclusively belongs to the said Siddhananda Shetty, and when the Siddhananda Shetty has made the provision during his lifetime making the allotment of share in favor of legal heirs of one of the son, that is the plaintiffs, as well as another son. And also the court has to take note of whether the share allotted in favor of the Siddhananda Shetty, whether he has made any testamentary document before his death, also to be taken note of by the trial court while considering the matter on merits. And hence, I do not find any error committed by the trial court in rejecting the application, taking into note of the specific registration of the partition deed in the year 2014, and also the suit is filed after lapse of 8 years. And hence, not made out any ground to interfere with the findings of the trial court. In view of the discussions made above, I pass the following order. Appeal is dismissed. However, directed the trial court to dispose of the matter within a time-bound period of 1 year. And both the opponent and respondent counsel assist the trial court in disposal of the suit within the time-bound period.
Maybe, my lord, item number 1, because of the death of Siddhananda Shetty, now these plaintiffs will get a share.
Let them carry out necessary amendments. my lords.
ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಾ ಅಂತ ನೋಡೋಣ ಅಷ್ಟೇ. ನೀವು ನೋಡ್ಕೊಳ್ಳಿ, ಅದನ್ನು ಅಬ್ಸರ್ವ್ ಮಾಡಿದಿಲ್ಲ. ವೆದರ್ ಎನಿ ಟೆಸ್ಟಮೆಂಟರಿ ಡಾಕ್ಯುಮೆಂಟ್ ಇಸ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಅಂತ ಟೈಮ್ ಆಗಿದೆ, ನನಗೆ ಗೊತ್ತಾಗಿಲ್ಲ.
34 my lord. Both three my lord, maybe tomorrow my lord, small.
ಯಾವುದು
44, connected matter 3.
ಇದೆಯಾ? ಇನ್ನೊಂದು ಇದೆಯಾ?
3 matters, connected 3 matters.
ಹೇಳಿ ಏನಾಗುತ್ತೆ?
Tomorrow.
ಟುಮಾರೋಗೆಲ್ಲ ಡೇಟ್ ಇಲ್ಲ. ಇವತ್ತೇನಾರು ಇದ್ರೆ ಕೇಳ್ತೀನಿ. ನಾನು ಓದ್ಕೊ ಬಂದಿರ್ತೀನಿ, ಅಸಿಸ್ಟ್ ಮಾಡಿ. 1 and 2 ಆರ್ ರಿಜೆಕ್ಟೆಡ್ ಆನ್ ಕಾಸ್ಟ್ ಆಫ್ ₹5,000. ಅದರ್ ಸೈಡ್ ಯಾರು ಇದಾರಾ? ಏನು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ? ಇಲ್ಲ, ತಗೊಳ್ಳಿ. ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್. ನಾಳೆಗ್ ಡೇಟ್ ಇಲ್ಲ. ನಾಳೆಗ್ ನಾವೆಲ್ಲ ತುಂಬಾ ಕೊಟ್ಬಿಟ್ಟಿರ್ತೀವಿ, ಯಾವ್ದು ಇರಲ್ಲ ನಾಳೆಗೆ. ಏನಾದ್ರು ಆಫ್ಟರ್ 10 days ಯಾವ್ದಾರು ಇದ್ರೆ ಕೊಡಿ. ಇಲ್ಲಾಂದ್ರೆ ಇವತ್ತು ಹಿಯರ್ ಮಾಡೋಣ ಇರಿ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳ್ರಿ? ನಾಳೆಗ್ ನೀವು ಬಂದ್ರು ಆಗೋದಿಲ್ಲ ಅದು, ಅದಕ್ಕೆ ಹೇಳಿದ್ದು.
Next week any day.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ, 3ನೇ ತಾರೀಕು 4ನೇ ತಾರೀಕು. Appellant counsel 6 time and counsel for the other side also present. List this matter on 412.
Serial number 41.
41 ಏನಾಗ್ಬೇಕು ಹೇಳ್ರಿ?
For tomorrow.
41 ಯಾರೋ ಬೆಳಗ್ಗೆ ಏನೋ ಕೇಳಿದ್ರಲ್ಲ?
My lord, it's me only, my lord. For tomorrow, my lord. But senior is not
tomorrow ಡೇಟ್ ಇಲ್ಲ.
My lord, my lord.
Not 12
Let the IA kindly post it for 16th, my lord. 16th.
16th ಎಲ್ಲ ಡೇಟ್ ಇಲ್ರಿ. 16th ರಜಾ, ನೀವ್ ಒಬ್ರೇ ಬರ್ಬೇಕು. ಸಾಟರ್ಡೆ.
My lord, 23rd, my lord. 23rd.
ಇಲ್ಲ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಡಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಲೆಟ್ ದಿ
My lord, senior.
time limit.
ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡ್ಲಿ ಮೆರಿಟ್ಸ್ ಮೇಲೆ. ಈಗ ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಕೊಟ್ಟರದೇ ನಾಟ್ ಏಲಿನೇಟ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಇಬ್ರಿಗೂ ಬೋತ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಕರೆಕ್ಟ್, ಇಬ್ರಿಗೂ ಕೊಟ್ಟರು.
ನಾನು ನೋಡಿದ್ದೀನಿ ಆರ್ಡರ್ನ. both alienation restrained.
In fact, technically, ಅದು maintainable
ಡಿಸೈಡ್ ಮಾಡಿ. ಲೆಟ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ವಾ?
ಟೈಮ್ ಲಿಮಿಟ್ ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡಿ. all the
1 month ಒಳಗೆ ಡಿಸೈಡ್ ಮಾಡಿ ಅಂತ ಹೇಳೋಣ. ಈ ಬ್ಲೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ?
ಗೊತ್ತಿಲ್ಲ.
ಬ್ಲೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗಿದೇನ್ರಿ?
ಇಲ್ಲ,
ನಿಮಗೂ ಗೊತ್ತಿಲ್ಲ. ಆಯ್ತು ಇರಿ, ನೋಡಿ ಮಧ್ಯಾಹ್ನ ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
62 please.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ
23rd.
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಹಾಕಿದ್ರೆ ನೋಡ್ಕೊಳ್ಳಿ. ವಿತ್ ಡೈರೆಕ್ಷನ್ ಆಫ್ ಡಿಸ್ಪೋಸಲ್ ವಿತ್ ಇನ್ 1 month ಮಾಡೋಣ.
Even objection ಹಾಕದೇ ಇದ್ರು not filed ಅಂತ ತಾಂಡ್ it can be disposed.
Your lordship, one humble mention in serial number 58, your lordship.
58.
Your lordship, I seek 2 weeks time, your lordship, in this matter.
Did you inform the other side?
Yes, the other side is also informed in this matter, your lordship.
Already informed?
Already informed, your lordship.
58 2007 matter, madam.
Please, your lordship, ಏನಾಗಿದೆ ಅಂದ್ರೆ your lordship, ಇದರಲ್ಲಿ ನಾವು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡಿದೀವಿ. ಅವ್ರದ್ದು ಇವತ್ತು ಇನ್ಅವೈಲಬಿಲಿಟಿ ಇದೆ, your lordship.
Appellant, you are appearing for whom?
Appellant, your lordship.
Appellant counsel seeks time and counsel also submits that already informed. Counsel for respondent. ಯಾರು ಇದ್ರ ಬೇರೆ ಇದಾರಲ್ಲ, ಚರಾಟಿ ಇದ್ದಾರೆ, ಶ್ರೀನಿವಾಸ್ ಇದ್ದಾರೆ, ಯಾರು ಇದ್ದೀರಿ?
ಚರಾಟಿ ಅವ್ರದ್ದು, he is no longer the counsel. He was only called in for one specific clarification, your lordship. ಇಬ್ರು ಕೌನ್ಸಿಲ್ ಇದ್ದಾರೆ, R1, R2. ಅವ್ರಿಗೆ ಇಬ್ರು
informed the counsel for the respondent and hence list this matter on 412.
Grateful.
Madam, thank you. Madam, ಎರಡು ಬರೆದಿರಲ್ಲ.
ಮಧ್ಯಾಹ್ನ 2:30 ತಗೊಳ್ತೀರಾ ಅಥವಾ ಕಂಟಿನ್ಯೂನೇ?
2:30ಗೆ 2:30 ಮಾಡ್ತಿದ್ದೆ. ಅದಾದ್ಮೇಲೆ 39 4:12ಗೆ. ಅದು 4:12. ಅಷ್ಟೇ ನಾನೇ ಕೊಟ್ಟಿದ್ದೀನಿ, ಯಾಕಂದ್ರೆ ಕೊಟ್ಟ ಮೇಲೆ ಅದು ಇಲ್ಲೇ ಇರ್ಬೇಕು. Hearing files. Hearing files ಅಲ್ಲಿದ್ಯಾ ಅಂದೆ. ಅಲ್ಲೇ ಜೋಡಿಸಿದ್ದೀರಾ? ಯಾವ್ದ್ರಲ್ಲಿ ಹೀಗೂ ಬರ್ತಿಲ್ಲ. ಏನು? ಇವಾಗ ಮಾಡಿದ್ದೀರಾ? ಮೆಮೋ ಆಫ್ ಅಥಾರಿಟೀಸ್ ಬೇಗ ಬರೀ. ನಾನು ಆಮೇಲೆ ನೋಡ್ತೀನಿ ಬಿಡಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಇಲ್ಲ ಇದಾದ್ಮೇಲೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಬರ್ತಾ ಇದ್ದಾರೆ. ಹೌದು ತಗೊಳ್ಳಿ ಹೇಳಿ.
ಮೇಡಮ್ ಧಾರವಾಡ ಬೆಂಚ್ ತಗೋತಿರಲ್ಲ ಮ್ಯಾಟ್ರ್?
ಧಾರವಾಡ
ಬೆಂಚ್ ಮ್ಯಾಟ್ರ್ ತಗೋತಿರಲ್ಲ ಇವಾಗ?
ಹೌದು.
ಓಕೆ.
ಏನ್ ಬೇಕು? ಅರ್ಜನ್ ಆಗಿಲ್ಲ. 58 412ಗೆ. ಯಾರಿಗೂ ಬೇಕಿಲ್ಲ. ಅಲ್ಲ ಫಸ್ಟ್ ಧಾರವಾಡ ಆಮೇಲೆ ಕಲ್ಬುರ್ಗಿ.
My lords, may I make a mention? May I make a mention, my lord? Serial number 73, I appear for the petitioners. My lords, there is some inconvenience. There is a division bench NIA matter. Senior is held up. Your lordships may kindly have it next week, my lords.
Serial number?
73.
Please. You are appearing for whom?
I appear for respondent.
Respondent.
Respondent local.
You ready, Idra?
Please move.
Third. Appellant petitioner counsel seeks time and counsel for respondent is present. Is this matter, madam?
Next Wednesday.
Next Wednesday, earliest of
27th.
27,
Please, ma'am.
7.
Mobilizing.
Matter pertains to Dharwad bench. Serial number 1, SC Bhuti.
Extension of time.
Here for respondents.
Hmm.
Here per times.
Hmm?
Here per times and serial number. Dharwad.
Dharwad bench.
Dharwad bench. Why you are seeking time? It is for extension of time. Extension of time filed by respondent ಅಂತಿದೆ ನೋಡಿ ಏನ್ respondent? Why you want 60 days time? Earlier already this court directed to pay the amount within 60 days.
Problem is this one.
First, the trial court is directed to pass appropriate orders after considering the objection statement filed by as per annexed G. The respondent is directed to pay the amount of rupees 6,000 per month as ordered by this court and pay arrears of maintenance from 29/4/2014. 2014 ಇಂದ ದುಡ್ಡೇ ಕೊಟ್ಟಿಲ್ವಾ? Huh? Why you want time?
Health issue ಇದೆ advocate.
ಏನ್ ಇಶ್ಯೂ ಇದೆ?
Health issue ಇದೆ.
ಯಾರಿಗೆ? Advocate. Advocate ಅಲ್ಲ ಕೊಟ್ಬೇಕಾರೆ ದುಡ್ಡು ಯಾರು ಕೊಡ್ಬೇಕು? Respondent is directed to pay the amount of rupees 6,000 per month as ordered by this court and pay arrears of maintenance. Maintenance ಕೊಡ್ಬೇಕು. 2014 ಒಂದ್ ಪೈಸಾ ಕೊಟ್ಟಿಲ್ಲ. What happened to the respondent? ಏನಾಯ್ತ್ರಿ? 2013 ಮೇಂಟೆನೆನ್ಸ್ ದುಡ್ಡೇ ಕೊಟ್ಟಿಲ್ಲ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ರೀಸನ್ ಏನ್ ಹೇಳಿ? ಶಾರ್ಟ್ ಡೇಟ್ ಎಲ್ಲ ಇಲ್ಲ. ರೀಸನ್ ಏನ್ ಹೇಳಿ ದುಡ್ಡು ಕೊಡಕ್ಕೆ? My father reported to be dead. ಯಾವಾಗ? Perused AN number 1 of 24, wherein prayer is sought extension of time and reason assigned that his father passed away and hence could not pay the arrears of maintenance amount. And this court wide ordered 27th day of August 2024. Order was passed to pay the amount within a period of 1 month from today. And the 1 month already expired on 27th of September 2024. And even after completion of 2.5 months, not paid the amount and reason assigned is also very bald. And death of the father cannot be a ground for extension of time, and order is also passed to pay the maintenance, and petition was filed in 2014. And almost a decade has been elapsed. And hence, and also application is not filed within the period of 1 month, and this application is also filed after 2.5 months. And question of granting further time of 60 days doesn't arise. No ground is made out to extension of time. Hence, IA is rejected.
Serial number 2, Mrityunjay Tata Bangi.
Please appear for petitioner, my lord.
Time filed by the advocate for petitioner.
Please, my lord. My lords have passed an order, my lord. Allowed the writ petition. And to file affidavit within 1 week, my lords.
Yes.
My lords, the party could not contact my lords.
This order was passed on 24th day of September 2024. ಹೇಳಿ.
Please, my lords. I have filed
1 week ಹೋಗಿ ಈಗಾಗಲೇ ಎಷ್ಟು ವೀಕ್ ಆಯ್ತು ಹೇಳಿ?
vacation on ಬಂತ ಅಷ್ಟರಲ್ಲಿ.
Vacation ಗೆ ಅದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
Party could not contact my lords. The
ಏನ್
ಇವಾಗ ಹಾಕಿದೀವಿ.
terms of the earlier order, it is made clear that if the respondent authorities are not satisfied that the petitioner was abiding by the undertaken, they would be at liberty to initiate press proceedings for cancellation of allotment. Accordingly, this writ petition is disposed of. He shall comply with the terms of lease cum sale agreement within a period of 6 months from today. If he files the same within 1 week from today, affidavit ಹಾಕಿಲ್ವಾ within 6 weeks ಗೆ?
ಇಲ್ಲ ಹಾಕಿದೀವಿ my lords.
ಯಾವಾಗ
ಅದು ಸೇಮ್ ಡೇಟ್ ಗೆ ಹಾಕಿದ್ವಿ 21/10/2024.
ಆಯ್ತು.
ಅದು ಬಂದಿದೆ ಇವತ್ತ ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಆಯ್ತು.
1 week ಅಂತ ಅಂದಿದ್ರಲ್ಲ.
Period of 6 weeks ಅಲ್ಲಿ ಯಾಕೆ ಮಾಡಿಲ್ಲ ಅಂತ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದಿರಲ್ಲ?
Please my lords.
Comply with the terms of lease cum sale agreement within a period of 6 months from today and also undertaken to file an affidavit within 1 week.
1 week ಅಂತ ಇತ್ತು ಅದು. ಅಷ್ಟರಲ್ಲೇ ಆಗಿದ್ದೆ. ಅಷ್ಟರಲ್ಲೇ ಹಾಕಿಲ್ಲ.
ಹಾಕಿದ್ರಿ but why you have not complied it? ಏನ್ ರೀಸನ್ ಏನ್ ಹೇಳಿ? ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್.
Second petitioner my lords, the admit the hospital my lords, the old age. ಕೌಂಟರ್ ಪಾರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಗೆ ಹೇಳಿದ್ವಿ, ಅವರು ಲೇಟ್ ಆಗಿ ತಿಳಿಸಿದ್ದಾರೆ. ಸೊ
Sharmila M. Patil for R124, Prakash
Please.
Kola L. Hatti for R4. Undertaking affidavit within 1 week ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಬೇಕು ಅಂತ ಇತ್ತು. ಕೌನ್ಸಿಲ್, why you have not filed for a period of more than 6 weeks?
Party could not contact my lords, the
Even compliance is also given 6 weeks. That is also expired now.
2 weeks my lords, I will comply the
The petitioner has filed an application on section 151 of CPC praying this court to extend the time for filing an undertaking affidavit. And on perusal of the order, while quashing the proceedings, this court granted 6 weeks time subject to an undertaking of the petitioner that he shall comply with the terms of lease cum sale agreement within a period of 6 months. 6 months from today, and if he files the same within 1 week from today, the same will be taken on record. But undertaking affidavit is not filed, and also made it clear that if the respondent authorities are not satisfied that the petitioner was abiding by the said undertaking, they would be at liberty to initiate fresh proceedings for cancellation of allotment. And in spite of it, the affidavit is not filed within time. However, for the reasons stated in the accompanying application and affidavit, another 1 week time granted from today.
2 weeks my lord.
And if fails to file such an affidavit, already liberty is given to the respondents to proceed against in terms of the order passed by this court.
2 weeks my lord.
ಒಂದೇ ವಾರ ಕೊಡೋದು. 1 ವಾರ ಟೈಮ್ ಕೊಟ್ರೆ 6 ವಾರದ ಮೇಲೆ ಬಂದಿದ್ದೀರಿ. 24th of September, ಈ 24th ಬಂದ್ರೆ ಮತ್ತೆ 1 ವಾರ ಅಲ್ಲ 1 ಮಂತ್ 2 ಮಂತ್ ಆಯ್ತು.
Matter pertains to Kalburgi bench.
Please,
Serial
oblige.
number 1.
Kalburgi ಐತಿ ಏನ್ರಿ?
ಹೌದು. Mahantesh Patil.
My lords, I appear for the petitioner.
Yes.
The present petition, lords, is filed by the accused number 1. Lords, in respect of the accused number
Is there any earlier order? Is there any earlier order, counsel?
No, but your lordship have not rejected, my lords,
Whether any order passed by this
in
court.
the earlier in respect of accused number 3.
Moli Pasha.
In respect of accused number 3.
Counsel, very same petitioner earlier filed petition. Criminal petition number 2,07,003 of 22.
200.
Yes.
How those? Accused number 3, your lordships have allowed the petition.
Accused number?
3, my lords. 201651 of 2021.
Produce ಮಾಡಿದಿರ ಕಾಪಿ ಆಫ್ ದಿ ಆರ್ಡರ್?
ಇಲ್ಲ, ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ
ಮಾಡ್ಬೇಕಲ್ಲ.
ಇಲ್ಲ, ಅದು ಎಲ್ಲ ವಸ್ತು ಒಂದ್ಸಲ ಹಾಕ್ಬಿಡ್ತೀವಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಇಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು ಸ್ವಾಮಿ. ಅವ್ರ ಗವರ್ಮೆಂಟ್ ನವ್ರು ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಅಡ್ಜರ್ನ್ ಆಯ್ತು.
ಟೇಕ್ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಆಯ್ತು, ಅದೇನು ಆರ್ಡರ್ ಅಲೋ ಮಾಡಿದೀವಿ ಅಂತಿರಲ್ಲ,
ಅದನ್ನ ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ. ಅದನ್ನು ಪ್ಲಸ್ ಎಂಟೈರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಎಂಟೈರ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ, ಹಾಕಿಲ್ಲ.
The counsel for the petitioner seeks time to file entire charge sheet and also the order passed. Number?
In respect of accused number 3.
3 ಯಾವ್ದು ನಂಬರ್ ಇದೆ ಏನ್ರಿ ಪಿಟಿಷನ್ ನಂಬರು? ಆಯ್ತು.
2015-1651.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗುತ್ತಾ? 20th ಅಥವಾ ನೆಕ್ಸ್ಟ್ 27th?
2021.
2011.
I will produce all those.
Second matter ನಿಮ್ದೇನೆ?
ಹಾ ಸ್ವಾಮಿ. Your lordships petition was
counsel, I am unable to hear you properly.
By appointing.
Make use of other device. If you are having any other device, I am unable to hear you.
20165.
My lords, I am audible.
Submission ಮಾಡಿ ನೋಡ್.
My lords, in this writ petition, the earlier, your lordships have, my lords, passed an order, allowed the writ petition, and directed to hold the investigation, further investigation, conduct a further investigation by appointing a fresh investigative officer, my lords, which is at Annexure G, page number 42, my lords. Thereafter, the investigation officer was appointed and further investigation was held, my lords, and there is a recovery of further gas cylinders. The only, my lords, the thing which your lordships may kindly see that along with memo, I have produced the additional charge sheet. At page number 15, along with memo, my lords, in the additional charge sheet, there is a one witness statement was recorded, namely Sharanappa son of Pompanna, at page number 15, my lords. That in the 4th para, my lords, Sadari Rajshekara Gaudana, may I read?
Yes.
Sadari Rajshekara Gaudana ಫಿರ್ಯಾದಿ ದೂರಿನಂತೆ ಇವರ ಗುಮಾಸ್ತರು ಮಣಿಕಂಠ ಸತೀಶ್ ರವರು ತಮ್ಮ ಮಹೀಂದ್ರ 407ರಲ್ಲಿ 70 ಖಾಲಿ ಸಿಲಿಂಡರ್ಗಳನ್ನು ಲೋಡ್ ಮಾಡಿಕೊಂಡು ನಮ್ಮ ಅಂಬಾದೇವಿ ಭಾರತ ಗ್ಯಾಸ್ ಏಜೆನ್ಸಿ ಕೊಟ್ಟು ಬಂದಿರುವುದಾಗಿ ತಿಳಿಸಿದಿರುತ್ತದೆ. ನಾನು ಸದರಿ ಅವರ ಗುಮಾಸ್ತರಿಂದ ಯಾವುದೇ ಖಾಲಿ ಸಿಲಿಂಡರ್ಗಳನ್ನು ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. ಈ ಬಗ್ಗೆ ಇಂದು ದಿನಾಂಕ 11/2/2022 ನನ್ನ ಗೋಡನ್ದಲ್ಲಿ ಭಾರತ್ ಕಂಪನಿಯ ಖಾಲಿ ಮತ್ತು ತುಂಬಿದ ಗ್ಯಾಸ್ ಸಿಲಿಂಡರ್ಗಳ ದೈನಂದಿನ ಸ್ಟಾಕ್ ಇರುವ ಬಗ್ಗೆ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದು, ನನ್ನ ಸ್ಟಾಕ್ ರಿಪೋರ್ಟ್ ಅನ್ವಯ ನನ್ನ ಗೋಡನ್ ಪರಿಶೀಲನೆ ಮಾಡುವ ಕಾಲಕ್ಕೆ ನಾನು ಹಾಜರಿದ್ದು ಎಲ್ಲಾ ಸಿಲಿಂಡರ್ಗಳನ್ನು ನಾನು ಖುದ್ದಾಗಿ ತೋರಿಸಿದ್ದು ಇರುತ್ತದೆ. This, my lords, in respect of this aspect, wherein in the statement of the accused, they have stated that there was a 70 empty gas cylinders were given to the Ambadevi, but there is no further any investigation is carried out. Only the recovery was made for the additional gas cylinders. From the accused number 1 to 3, wherein they have stated and they have shown that it was given to some third parties, and they have recorded further gas cylinders. And the state is till today not filed the objections for explaining any other thing. Why these cylinders are not recovered by the investigation officer, and there is no any investigation is and the manner in which the investigation is carried out. In view of the if the state is not filed the objections and stated that there is the investigation has been completed and there was a proper investigation, then I can ask. There are suspicious circumstances, my lords, even from the statement of the witnesses itself, that there were some cylinders were given to the Amba Devi. That was there is no further investigation forthcoming from the investigation officer. Therefore,
This is the only additional report is filed. Any other statements?
no, no, there is no. I have produced along with memo. That is only the statement.
Only additional charge sheet you have produced along with
Adande Swami, adu bitre yavadu hakilla.
Annexure H, except Annexure H, nothing.
No, ma'am.
Yes, HCGP. HCGP. Heard the petitioner counsel and HCGP is absent, and one more opportunity is given to the HCGP. If HCGP fails to appear in the next date of hearing, it will be taken as matter will be considered in the absence of the submission of HCGP. List this matter on 2011.
But it may be adjourned on 27th. Another matter is adjourned by your
No
lordship.
counsel, only criminal day, only on Wednesday, 20th. Other matter also I posted now 20th only. Other matter also, first matter also 20th only.
List 1. Matters of 230. Non-compliance of first time 65.
Okay.
And nothing.
Condonation of delay file ಮಾಡ್ಬೇಕಾಗಿ ರೈಸ್ ಮಾಡಿ ಫೈಲ್ ಇಟ್ಟಿಲ್ಲ ಟೋಟಲ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ
ಯಾವಾಗ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳಿ
1 week
and counsel seeks 1 week time to comply with office objections and hence list this matter after compliance. Please.
66.
My lordship, I appear for the petitioner, my lordship. Kindly 1 week time may be given for
Petitioner counsel
complaints.
seeks 1 week time to comply with office objection and hence post the matter after compliance.
Obliged.
67.
Yes, counsel.
My lord, serial number 4 of the office objection may be overruled, my lord. Previously,
Serial number 4?
it's for the certified copy of the reject order, my lord. It's a successive bail.
Certified copy of the
Reject order, my lord. Bail order.
Order to be furnished ಅಂತ
but bail ಹಾಕ್ಬೇಕಲ್ಲ ರಿಜೆಕ್ಷನ್ ಆರ್ಡರ್ ನಾ
My lord, it
ಅದನ್ನ
was
dispense
previously filed, my lord.
ಯಾವಾಗ ರಿಜೆಕ್ಷನ್ ಆಗಿರೋದು
My lord, it's in criminal petition, it's 2 months back, my lord.
ಅದನ್ನ ತೆಗೆದು ಹಾಕೋಕೇನು ಕಾಪಿ ಹಾಕೋಕೇನ್ರಿ ಅದನ್ನ
Please, man.
ತಗೊಳ್ಳಿ. Counsel for the petitioner submit that certified copy of bail
May be
rejected
overruled,
order may be dispensed. And the said submission is not accepted and directed to produce the certified copy of the order. ಎಷ್ಟು ದಿವಸ ಬೇಕು?
Within a week, we will be.
Next list this matter on 2011.
Great.
ಬೇರೆದು ಇದೆಯಾ? ಬೇರೆ ಆಫೀಸ್ objections ಇದೆಯಾ? And also directed to comply with other office objection in the meanwhile.
Please, man.
68.
Anil Kumar CD. Ilva? Petitioner counsel is absent, 1 week time granted to comply with office objection. 1 week time granted, petitioner counsel is absent, post the matter only after compliance.
Second time non-compliance.
Second
69.
time, Sayyid
Sayyid
Umar.
Umar.
Appearing for petitioner, this time senior is met with an accident.
How much time?
Any convenient date can be given. Next week time.
Petitioner counsel seeks time, granted 1 week time, list this matter after compliance.
Orders matter 70.
Sirajuddin Ahmad.
Sirajuddin Ahmad.
Petitioner counsel absent, additional SPP present, list this matter on 27/11.
71. Balakrishnan Yamma.
Balakrishna MR, Unikrishnan.
in this matter, my lord.
Filing the statement of objections. Respondent counsel filed statement of objections. Copy serve madira?
Yes, I have received the
Copy is
copy.
also served on the other side.
Yes, I am ready, my lord.
Successive bail petition.
Yes, my lord. This is the,
Go to the earlier order for reasoning for rejection.
the first bail application filed by the petitioner rejected on merits, my lord. That's on,
5974.
that is the 2561/2022, dated 24/6/2022, my lord.
ಹಾಕಿದಿರೋದು
Page number 240.
page number
240.
240.
Yes.
Ramakrishna.
Yes. Now the second bail order, that is on 24/8/2023, page number 262, my lord. I sought the bail on medical grounds. This court rejected the prayer of the petitioner and directed the jail authorities to shift the petition to the Jayadeva Hospital. Then third bail order, that is on 28/8/2024, my lord. Criminal petition number 7242/2024. I've already placed on record. What is the that petition came to be withdrawn by the petitioner, enabling him to file fresh petition before the trial court. And this court has granted liberty to the petitioner to approach this court if the bail petition is rejected.
Where is that order?
Yes, that is I filed on 7/11/2024 along with the memo. I have placed on record. You'll have to kindly see the operative portion of the order. That bail application filed on the ground of delay in trial. Learned counsel for the petition submits that he may be permitted to withdraw the petition on the ground that he has filed fresh petition before the trial court. Hence, the petition is permitted to withdraw this petition with the liberty to approach the court if the same is rejected. Now, this petition filed under section 439 of the CRPC, read with section 479 subclass 1 of the BNSS 2023, which is the beneficial provision and corresponding to section 436A of the Code of Criminal Procedure, wherein the petitioner is the first time offender and he has undergone 1/3 of the maximum punishment contemplated under the PML Act. And that application, this petition filed in consonance with the apex court judgment in the case of inhuman prisons, 1385, wherein the apex court has held that section 479 operates retrospectively. Pursuant to the dictum of Honorable Apex Court, I had approached the trial court and sought for bail. My prayer came to be rejected. I did not, I'm not on merits, my lord. My first and foremost ground is that I'm entitled for benefit under the first proviso to subsection 1 of 479 of the BNSS 2023. And my alternative submission is that, my lord, I'm seeking for bail on the ground that there is an inordinate delay in concluding a trial. On these two grounds, these grounds are subsequent developments and changed circumstances. And I'm not on merits of the case, my lord.
Yes.
On these two grounds, I'm seeking for bail. Now, your lordship kindly see section 5 of the PML Act. Section 4 of the PML Act, my lord. Punishment for money laundering. Whoever commits the offense of money laundering shall be punishable with rigorous imprisonment for a term which shall not be less than 3 years, but which may extend to 7 years and shall also be liable to fine. Now here in the case, my lord, upon conviction, the trial court has got several options between 3 years and 7 years. The court can impose 3 years or 3.5 years or 4 years. It may extend to 7 years, my lord. Here in the case, my lord, this petitioner, he was arrested on 14/2/2022, my lord. 14/2/2022. And he has undergone 2 years, 7 months detention as on the date of filing the present petition, my lord. And he is a first-time offender. Therefore, under the first proviso to subsection 479, subsection 1 of 479 of the BNS 223 is applicable to the petitioner. Therefore, he is entitled for bail. Now, your lordship, kindly see the section 479 BNS 2023. I may be permitted to read the entire provision since it is a new provision.
Hmm.
479 BNSS 2023. Maximum period for which under trial prisoner can be detained. Where a person has, during the period of investigation, inquiry or trial under this sannita of an offense under any law, not being an offense for which the punishment of death or life imprisonment has been specified as one of the punishments under the law, undergone detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offense under that law, he shall be released by the court. Here it is 1/2 of the maximum period of imprisonment, my lord. Then there's a first proviso, provided that where such person is a first-time offender who has never been convicted of any offense in the past, he shall be released on bond by the court if he has undergone detention for a period extending up to 1/3 of the maximum period of imprisonment specified for such offense under that law. This provision is applicable to the case of the petitioner. Here in the case, my lord, he is the first-time offender and he has already undergone more than 1/3 of the maximum punishment. As on the date of filing this petition, he has undergone 2 years, 7 months imprisonment, my lord. Then your lordship kindly see the next proviso. Provided further that the court may, after hearing the public prosecutor and for reason to be recorded by it in writing, order the continued detention of such person for a period longer than 1/2 of the said period or release him on bail, bond instead of his bond. This proviso is continuation of section 479 subclass 1, my lord. This proviso is applicable to the habitual offenders, not to the first-time offenders. Then your lordship kindly see, provided also that no such person shall in any case be detained during the period of investigation, inquiry or trial for more than the maximum period of imprisonment provided for the said offense under that law. In computing the period of detention under this section for granting bail, the period of detention passed due to delay in proceeding caused by the accused shall be excluded. Notwithstanding anything in subsection 1 and subject to the third proviso thereof, where an investigation, inquiry or trial in more than one offense or in multiple cases are pending against the person, he shall not be released on bail by the court. The superintendent of jail, where accused person is detained on completion of 1/2 or 1/3 of the period mentioned in subsection 1, as the case may be, shall forthwith make an application in writing to the court to proceed under subsection 1 for the release of such person on bail. Pursuant to first proviso to subsection 1 of 479, of the BNS 2023, and in consonance with the dictum of Apex Court, the latest dictum of Apex Court, wherein Apex Court has held that this provision operate retrospectively, I approach the trial court. The trial court rejected my prayer on the ground that the petitioner is facing multiple cases. Now, your lordship, kindly see my bail application, which I have placed on record, which I have filed before the trial court.
Page number?
Bail application dated 7/11/2024, my lord.
Page number.
No,
Page number.
this application filed before the trial court. This I have produced along with the memo. ಹೌದು, memo ಹಾಕಿದೆ.
ಈಗ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು, 7/11. Got it, my lord?
Copy of the bail application.
ಅದೇ 7/11. This is a bail application filed by the petitioner before the trial court. In consonance with the Apex Court judgment as well as section 479 subclass 1 of the BNS 2023.
Yes.
I did not touch the merit of the case, my lord. I restricted prayer only on the ground of 479 subclass 1 and a dictum of the Apex Court, my lord.
Yes.
Then my application resisted by the ED. ED has filed detailed objections. So your lordship, kindly turn to page 210. In the statement of objections filed by the ED, ED has narrated the facts of the case and touched the merits of the case. And ED never refuted or disputed or rebutted my contention before the trial court, my lord.
Yes.
Your lordship, kindly see the entire objections from page number 210 to 220, 281. They never whispered anything about my contention before the trial court. They have not rebutted. Indirectly, the ED has conceded my prayer before the trial court, my lord. And now your lordship, kindly see the findings given by the Honorable Trial Court, that is in page number 202. Page number 202. The order passed by the Honorable Trial Court, my lord.
Yes.
Here I may be permitted to read the reasons. Page number 204, my lord. Point number 1. This is a successive bail application filed by
Reasoning, finding ಹೋಗ್ಬಿಡಿ. Resection finding ಹೋಗ್ಬಿಡಿ.
ಅಲ್ಲ reasons ಓದ್ತೇನೆ.
ಅದು ಓದೋದ್ ಬೇಡ, ಅದಕ್ಕೆ ಫೈಂಡಿಂಗ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಹೋಗಿ ಹಿಂದೆ. These are all the grounds which you have urged.
ಅಲ್ಲ ಒಂದು ಎರಡು ಮೂರು ಮಾತ್ರ ಪ್ಯಾರಾ I may be permitted to read. That's only relevant for my case, my lord. First,
ಸೇಮ್ ಈಗ ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿರೋ ಅದನ್ನ ಅಲ್ಲಿ ಹೇಳಿದಿರ, ಅದನ್ನೇ ಅವ್ರು ಹೇಳಿದಾರೆ ಅಷ್ಟೇನೆ. ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 6 ಅಲ್ಲಿ 7 ಅಲ್ಲಿ.
Yes.
ಮತ್ತೆ ರಿಪಿಟೇಷನ್ ಅಂತ ಹೇಳಿದೆ. Para 8 ಹೋಗಿ.
Para 8. First of all, this is a case registered for the offense of money laundering as defined under section 3 of PML Act and punishable under section 4 of PML Act. As such, the question of granting bail in the case is governed by the section 45 of PML Act. The said provision cast bar on granting bail to an accused for an offense under section PML Act unless he complies with the requirement thereunder, notwithstanding anything contained in the Code of Criminal Procedure which is not replaced by BNS. That is not my case before the trial court, my lord. That's not my case before the trial court. And the section 45 of the PML Act cannot be replaced by BNSS 2023. PML Act is special enactment. It's a complete code. Yes. Next, your lordship, kindly turn to page 206, para 9. Added to the above, reading of section 479 of the BNSS makes it clear that benefit of first proviso to section 479 subclass 1 is subject to section 479 2 of BNSS. The said provision mandates that notwithstanding anything in subsection 1 and subject to third proviso thereof, where an investigation, enquiry or trial in more than one offense or in multiple cases are pending against a person, he shall not be released on bail by the court. Further, second proviso to section 479 subclass 1 of BNSS empowers the court to order the continued detention of a person for a period longer than one half of the period for the reasons to be recorded in writing. Thereby, it becomes clear that the benefit extended to the accused under first proviso to section 479 of BNSS is subject to all other relevant aspects. That's a very strange observations made by the Honorable Trial Court. The first proviso is applicable to my case. The petition is a first time offender. Previously, he was not convicted for any of the offenses, and he has already undergone 1/3 of the maximum punishment contemplated under the PML Act. The Honorable Trial Court wrongly interpreted the section 479 subclass 1 of the BNSS 2023. Next, your Lordship, kindly see page number 208, para 12. Para 12. Undisputedly, this case came to be investigated based on one more case registered against accused persons in crime number 69/2020 of Banswadi Police Station for the offences punishable under sections 406, 420, 409, 120B, read with section 34 IPC and section 9 of KPDFE Act. The investigating agency therein has completed its investigation and laid a charge sheet before the court, which is pending for trial. Thereby, it becomes clear that the case on hand is not the only case registered against the accused person. For the foregoing reasons, this court holds that accused number 4 has not made out valid ground to seek bail in the case of invoking first proviso to section 479 of the BNSS. Hence, the application filed by the accused number 4 petitioner is rejected. Now, your Lordship, kindly see this crime number 69/2020 is pertain to predicate offences or the scheduled offences. This ED case is a part and parcel of section crime number 69/2020, my lord. And both the cases are arising out of the same cause of action. Therefore, the Honorable Trial Court ought not to have held that section crime number 69/2020 comes under the purview of multiple cases. The ED case is part and parcel of crime number 69/2020. If tomorrow, if the accused is acquitted, or if the accused is discharged, or a case against the accused is quashed in crime number 69/2020, automatically this ED case also will go in view of the latest Supreme Court judgment, my lord. Therefore, the observation of the Honorable Trial Court is not correct. The trial court ought not to hold that this is a multiple case. This is not a multiple case. Both are inseparable. So, therefore, the first proviso to subsection 1 of 479 of BNSS 2023 is squarely applicable to the case on hand. Therefore, the petition is entitled for bail on this ground. Now, my alternative submission is that, my lord, that is right from the celebrated judgment of Honorable Appellate Court in the case of Husainara Khatun versus Home Secretary, State of Bihar, reported in 1981 SCC at page number 81. The Appellate Court consistently has held that speedy trial is a fundamental right guaranteed under Article 21 of the Constitution of India. Undue delay in trial cannot be said to be fettered by section 45 of the PML Act, my lord. This section 45 PML Act is at pari materia with section 37 of the NDPS Act as well as 43 DF UPA, my lord. And the constitutional mandate, Article 21 of the Constitution of India, would supersede statutory conditions stipulated under section 45 of the PML Act, as held by the Honorable Appellate Court, my lord. Now, in the case of the latest judgment of Honorable Appellate Court in the case of Manish Sisodia versus ED, wherein the Appellate Court has held that Article 21 of the Constitution of India is applicable to all the offences, irrespective of nature of offence, and long incarceration is a ground for bail. That's what the Appellate Court has held in the case of Manish Sisodia case. It's a Delhi liquor policy case, my lord. And in the case of Muhammad Muslim alias Muslim Hussain versus State of NCT of Delhi, your lordship is well aware of this judgment, wherein the Appellate Court has held that the constitutional courts have got unfettered power to grant bail on the ground of violation of fundamental rights. And the statutory restrictions, the constitutional rights would supersede the statutory restrictions under section 45 of the PML Act. And in the case of Vijay Madanlal versus Union of India, the Appellate Court has held that where there is a statutory restrictions,
Referring the judgments. without
yes,
placing
and
the same-
conditions are there. The trial of such cases gets precedence, and the trial should be concluded within reasonable time. Now, in the case on hand, your lordship kindly see, initially, there are 16 accused. Then 2 more accused have been added by the ED. Then again, 3 more accused have added. And on 11/9/2024, my lord, supplementary charge sheet, supplementary complaint has been filed by the ED by adding 9 accused. Now there are 30 accused are there. 30 accused are there. And on the previous occasion, the trial court has issued summons to accused number 22 to 30. Accused number for their appearance before the trial court. And most of the accused are on bail. The present accused and accused number, the petitioner is accused number 4 and accused number 19, they are in custody now. And warrant is pending against the accused number 8. Accused number 8, my lord. And now the summons has been issued to the accused number 22 to 30 for their appearance before the court. And there are 15 witnesses are there, my lord, in the final complaint filed by the ED. And documents that are in 18 volumes, running more than 7,500 pages, my lord. More than 7,500 pages. And charges yet to be framed. The case is still at its initial stage. The delay is not caused by the petitioner at all. So therefore, my alternative submission before your lordship is that petitioner is entitled for bail on the ground of delay in trial. That's the only alternative submission. And in support of my case, I have placed on record few decisions of Honorable Appellate Court. Along with the memo, I have already placed on record.
Yes.
The first judgment, memo of the address, my lord, filed on 4/11/2024. That's first judgment. That's the latest judgment of Honorable Appellate Court in re inhuman conditions in 1382 prisons.
Yes.
Here I may be permitted to read relevant para, page number 7, marked with the highlighter. Today, Mrs. Aishwarya Bhatti, learned Additional Solicitor General, submits that pursuant to the aforesaid order, instructions have been obtained from the department to the effect that the aforesaid provision under the BNSS shall apply to all trials in pending cases, irrespective of whether the case was registered against them before 1/7/2024, the date when the newly minted legislation has come into effect. In that view of the matter, it is deemed appropriate to direct immediate implementation of section 479 of the BNSS by calling upon superintendents of jails across the country wherever accused persons are detained as under trials to process their applications to the concerned courts upon their completion of 1/2 or 1/3, as the case may be, of the period mentioned in subsection 1 of the said provision for the release on bail. So Apex Court has held that section 479 subclass 1 of the BNSS operates retrospectively. And all the cases. It is applicable to PMLA, it is applicable to NDPS, it is applicable to UPA also. That's what the Supreme Court has held. Then your lordship kindly turn to page 9. Page 9. In this judgment, page number 14, your lordship kindly see the page number 14. Page number 14. This court's order dated 23/8/2024.
Section 531, there is a saving clause.
Which one?
In BNSS, there is a saving clause.
I will come to that point.
Section 531.
ಅಲ್ಲ ಅದು ಎಲ್ಲ ಕವರ್ ಆಗಿದೆ, ಎಲ್ಲ ಡಿಸಿಷನ್ಸ್ ಎಲ್ಲ ಕವರ್ ಆಗಿದೆ, ಲೇಟೆಸ್ಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ಕವರ್ ಆಗಿದೆ. ನಾನು ಅದನ್ನು ಓದಿ
First
ಆದ್ಮೇಲೆ
you read the statute,
yes,
then Supreme Court judgment you refer.
yes 531 BNSS.
531.
Yes, the Code of Criminal Procedure 1973 is here.
Repeal and savings, ಇದೆ ನೋಡಿ clear ಆಗಿ.
Yes, notwithstanding such a repeal, if immediately before the date on which this Sannita comes into force, there any appeal, application, trial, inquiry or investigation pending, then such application, trial, inquiry or investigation shall be disposed of, continued, held or made as the case may be in accordance with the provisions of the Code of Criminal Procedure 1973, as in force immediately before such commencement hereward code, as if this Sannita had not come into force. But here in the case, this Apex Court has held.
Apex Court has held as against the statute.
ಅಲ್ಲ ಹಾಗಲ್ಲ ಇದು 479.
Whether the court can interpret against the statute, maybe in High Court or Supreme Court.
ಅಲ್ಲ
Unless statute is declared as ultra vires.
No, that has been discussed by the Apex Court.
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಎಲ್ಲಿ ಡಿಸ್ಕಷನ್
ಅಲ್ಲ, ನಾನು
ನೀವೇನ್ ರೆಫರ್ ಮಾಡ್ತಾರೆ, ಅದು only a submission.
Yes.
Submission of the council.
ಅಲ್ಲ, next your second judgment, your lordship kindly see the second judgment.
First we have to see the statute, then judgment. The courts cannot interpret against the statute. There is a saving clause. There is a saving clause. 531(2) is very clear. Even pending investigation also. That's what I observed in the earlier order.
ಅಲ್ಲ, your lordship kindly see the page number 14.
This is only a submission made by
next judgment.
Victoria body.
No, the next judgment, continuation of the previous judgment of the Apex Court, page number 9. Page number, you will kindly see the page number 9. Page number 9 is that's the very same judge, continuation of the previous judgment. Here, page number 14, para 6, your lordship kindly see the para 6. This court's order dated 23/8/2024 indicated that the aforesaid provision of BNSS shall apply to all under trials in pending cases, irrespective of whether the case was registered.
Where is the discussion of saving clause? Where is the discussion of saving clause in the orders?
You have to go by.
Is there any discussion in any of the judgments of saving clause?
Case was registered against.
ಯಾರು ಹೇಳಿದ್ದನ್ನು ತಗೊಂಡು ಬರೆಯಕ್ಕಾಗಲ್ಲ. You have to see the act. That's what. In paragraph number 3, advocate canvassed. Today, Mrs. Aishwarya Bhatti, learned additional counsel, so submits that whether the case was registered against them before 1st of July 24, the date when the newly minted legislation has come into effect. That is the submission.
No, in the next judgment, your lordship kindly see. Just now I'm reading that judgment.
There is also the.
It's not like that. It's not like that.
The earlier judgment.
ಇಲ್ಲ.
Where is the discussion about the saving clause?
No.
In none of the orders.
Yes, this court, I may permit to read I have marked with the highlighter, para 6. This court's order dated 23/8/2024 indicated that the aforesaid provision of BNS shall apply to all under trials in pending cases, irrespective of whether the case was registered against them prior to 1/7/2004. The date on new legislation has come into effect. Therefore, specific direction was given by the court for implementation of section 479 of the BNSS by calling upon the superintendents of jails across the country and also to ensure processing of their applications through the concerned court upon their completion of 1/2 or 1/3 of the sentence, as the case may be, as per section 479 of the BNSS.
In this judgment also nowhere discussed the saving clause.
But we have to accept.
Section 531.
But we have to accept the apex court judgment.
Apex court.
The rule of.
If it is in
Of the-
in consonance with the statute.
But it is the law of the land.
Law of the land maybe. It should be in consonance with the statute.
Then your lordship kindly see the page number 17, para 13.
If any orders passed by the court against the statute, it amounts to a stare decisis.
Page number 17.
Whether
Pa-
High Court or Supreme Court.
Page number 17, para 13. An under trial who is entitled to be released under section 479 of the BNSS deserves effective consideration under the beneficial provision of law. Then your lordship kindly, that's a very important judgment, latest judgment of the apex court, page number 19. Badshah Majid Malik versus Director of Enforcement, my lord. Latest judgment. Identical case. The apex court has granted the bail. It has been observed that in the case of Vijay Madan Lal Chowdhury versus Union of India 2022 SCC online SC 926, that the beneficial provision of section 436A of the Code of Criminal Procedure 1973 may apply to prosecution under the Prevention of Money Laundering Act 2002, as section 436 has come on statute book subsequent to enactment of the PMLA. Therefore, a corresponding provisions of section 479 subclause 1 of Bharatiya Nagarik Suraksha Sanhita 2023 will apply to prosecution under the PMLA. And next, your lordship kindly turn to page 20, marked with the highlighter, bottom 4 lines. In the facts of the case, it is not disputed that the appellant has not been convicted for any offense in the past. Therefore, the first proviso to subsection 1 of section 479 of the BNSS will apply to this case, as admittedly the appellant has undergone detention for a period of more than 1/3 of maximum period of imprisonment provided for the offense alleged against him. Learned counsel appearing for the respondent number 1, that is the ED, my lord, praised that second proviso to subsection 1 of section 479 of the BNSS must be no-code and the first proviso should not be applied. He pointed out that the allegation against the appellant in the schedule offenses of indulging in smuggling of red sanders. Then on facts, this is not a case where this court should exercise powers under second proviso to subsection 1 of the section 479 of the BNSS and deny the benefit of the first proviso. This ratio is squarely applicable to the facts and circumstances of the present case. The apex court never said that second proviso to subsection 1 of 479 BNS 2023 is applicable. The red sanders, that is a predicate offenses.
Yes.
Identical case. And next, your lordship kindly turn to page 23. That's the latest judgment of apex court. This is the Manish Sisodia Delhi liquor policy case. Page number 38, my lord. 38. We find that on account of a long period of incarceration running for around 17 months and the trial even not having been commenced, the appellant has been deprived of the right to speedy trial. Here in the case, my lord, the Manish Sisodia, former Delhi chief minister, has undergone 17 months. Apex court has held is deprived of his right to speedy trial. As observed by this court, the right to speedy trial and the right to liberty are sacrosanct rights. On denial of these rights, the trial court as well as the high court ought to have given due weightage to this factor. Then, if the state or any prosecuting agency, including the court concerned, has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial, as enshrined under Article 21 of the Constitution, then the state or any other prosecuting agency should not oppose the plea for bail on the ground that crime committed is serious. Article 21 of the Constitution applies irrespective of the nature of the crime. Then, my lord, in the bottom, the court further observed that over a period of time, the trial courts and the high courts have forgotten a very well settled principle of law that bail is not be withheld as a punishment. From our experience, we can say that it appears that the trial courts and the high courts attempt to play safe in matters of grant of bail. The principle that the bail is a rule and refusal is an exception is at times followed in breach. On account of non-grant of bail, even in straightforward open and shut cases, this court is flooded with a huge number of bail petitions, thereby adding to the huge pendency. It is high time that the trial courts and high courts should recognize the principle that bail, the rule, the jail is an exception. The ratio laid down by the Appellate Court in the Manish Sisodia case also squarely applicable to the facts and circumstances of the present case. The 17 months long incarceration. He was deprived of speedy trial. So in my case also, he has undergone 2 years, 7 months as on the date of filing this petition. And documents running around more than 7,500 and charge not at framed. Case is still it is in initial stage. Summons, issuance of summons to the accused number 22 to 30. And next judgment, your lordship kindly see, Muhammad Muslim alias Hussein, the page number 42, my lord. Here in relevant page number 47. The court concluded that statutory restrictions like section 43D, 5 of UPA cannot fetter a constitutional court's ability to grant bail on ground of violation of fundamental rights. Even in a judgment reported as Vijay Madanlal Chaudhary versus Union of India, this court, while considering bail conditions under the Prevention of Money Laundering Act 2002, held that if the Parliament legislature provides for stringent provision of no bail, unless the stringent conditions are fulfilled, it is the bounden duty of the state to ensure that such trials get precedent and are concluded within a reasonable time, at least before the accused undergoes detention for a period extending up to 1/2 of the maximum period of imprisonment specified for the concerned offence by law. So herein also, the Appellate Court has held that violation of fundamental rights is a ground for granting bail, and even if there is a stringent conditions are there, if the violation of fundamental rights, the accused is entitled for bail. And next judgment, your lordship kindly see, the most celebrated judgment of this country, that is the Husainara cartoon was the state of Home Secretary, state of BR, reported in 1981, SEC at page number 81, wherein the Appellate Court has held that the right to speedy trial is a fundamental right guaranteed under Article 21 of the Constitution of India. Herein, there is an inordinate delay on the part of the ED. It's a constitutional duty. It's a bounden duty of the trial court as well as state government to ensure that cases of this nature should be concluded within a reasonable period. Trial gets precedence. So therefore, this is my only alternative submission. Therefore, my humble submission before your lordship is kindly allow the petition filed by the petitioner under section 439 read with the 479 subclass 1 of the BNSS 2023. And I am producing the online copy of the latest status of the case, my lord. Last.
Yes.
So last page, my lord. Page number 12. Page number 12 ಅಲ್ಲಿ ಇದೆ.
To hear on discharge application.
ಅಲ್ಲ, page number 12 ಅಲ್ಲಿ special case 780/2000
ಕೊನೆಗಿದೆ to hear on discharge application
and
A19 objections to the application of competent authority reissue NBW against A8.
summons to A22 to A30, readable 22/11. And trial will not be concluded in near future, my lord. And there are documents running more than 7,500. And number of witnesses are there. And case is still its initial stage, summons stage.
Yes, counsel.
Therefore, the petition is entered for bail, ma'am.
My lord, though I would not want to touch much on the merits of the case, but my lord, this honorable court on 2 occasions, my lord, has rejected the bail petition considering the gravity of the offence. My lord, on 24/6/2022, this honorable court, while dismissing the application, squarely held that he was a kingpin of a large scam which has cheated many people crores of rupees, and it was his bail petition was rejected. He preferred an appeal before, he preferred SLP before the Honorable Supreme Court. In fact, my lord, the Honorable Supreme Court has passed a specific order at 261, wherein, my lord, not only upholding the order of this Honorable Court, and also said this, my lord, looking to the seriousness and gravity of the offence, the High Court has rightly refused to release the petition of bail. We are in complete agreement with the same. So entire reasoning of this Honorable Court, my lord, had gone in extenso. 261, my lord.
261.
They are not on the merits, my lord.
Well, no, I know, my lord, but I want to bring it to the notice of this honorable court, my lord. The seriousness of the issue is involved. As far as those judgments which my learned friend relied, probably would apply only to those facts. Wherein, my lord, it was very, very, very ahead, and it was in pre-trial stage. Of course, the trial has started here. And my lord, they were considering some bail applications, and my lord, some considerations were there that probably those people were entitled to bail. Now, then, my lord, he would file another application to circumvent this order of this honorable court and the Honorable Supreme Court. Yet again, my lord, this honorable court would reject his application on merits and also say that, look, even if you are seeking for a bail on medical grounds, you can still avail it. Now, my lord, for the third time on a different tangent, my lord, to circumvent these 2 orders, including the order of the Honorable Supreme Court, this application is filed. My lord, my first submission would be that as far as Section 479 is concerned, my lord, it clearly says this, my lord. Let us assume for a moment, my lord, that this new BNSS is applicable as far as the petitioner is concerned. Even then, my lord, where a person has during the period of investigation, inquiry, or trial under this act of an offence under any law. So, my lord, it is mandatory, my lord, that he should be facing trial under the provision of this. But, my lord, as far as his petition is concerned, he is still facing trial under the provisions which is fixed by Section 45 of the PML Act, wherein, my lord, the general procedure of a sessions court is followed. So, my lord, this particular enactment not be applicable. Even otherwise, my lord, if my lord were to kindly see Section 479 subclause 2, it says, notwithstanding anything in subsection 1, that is first time offender, etc., and subject to the third proviso thereof, where an investigation, inquiry, or trial in more than one offence or in multiple cases are pending against a person, he shall not be released on bail by the court. My lord, in fact, though of course, my lord, this particular PMLA proceeding is a fallout or a continuation or a trigger of a predicate offence, but my lord, the offences before as far as those offences are concerned, are completely different. He's under 420, then under the various other offences, 420, cheating, forgery, etc., my lord, and it is pending before the learned magistrate. It's a totally separate, different trial. As far as PMLA is concerned, my lord, it is before a special court. They're separate offences, separate accused. There might be some common accused, but the trial, my lord, is completely different, and the proceedings under the PMLA Act is independent of one another. That is exactly what the scheme of the PMLA Act. My lord, it might have a bearing probably if he is acquitted in that case. But as of today, my lord, for my lord's consideration, those are 2 separate cases, and he cannot take the benefit under this provision.
Any other case other than?
That these are all the cases wherein
other than any other case?
Other cases, crime 69 for offence under 406, 420, 409, 120, 34, and 9 of the Karnataka KPID, my lord, which is pending before the magistrate, my lord, registered by the Basangudi police. That is, in that case, my lord, the trial is begun. That is what I gather, my lord. Here, my lord, the charges are yet to be framed. Because our investigation is completely different, my lord. We have more witnesses and more accused are being roped in. Because these are all not accused persons in the predicate offence. So, my lord, the proceedings are completely independent of one another. That is exactly what even the Act says. So, my lord, it would definitely come under the sweep of 479 subclause 2, wherein, my lord, if there are other cases and trials pending, he cannot have the benefit under Section 479. Then, my lord, as my lord also pointed out, my lord, that the saving clause also would also come into my aid, that he cannot be entitled. And as far as speedy thing is concerned, my lord, The accused, my lord, probably not this particular accused, but he too is part of this delay because he has filed application for bail, then he got it rejected. He filed one more application for on medical grounds, now one more application for discharge, then now this application for, my lord, under 479. Like him, other accused. So, my lord, totality, my lord, all the accused in hand in glove with one another, and my lord, have causing the delay. And so thus, my lord, this petition is liable.
Sir, he filed.
My lord, he has filed four applications. Allah, not discharge, I'm sorry. Discharge is done by others. Discharge is not his. He has not filed discharge.
Bail petitions.
Bail petitions.
Successive bail petitions.
My lord, I'm not saying it is not.
number
No,
of
no.
petitions.
What I mean to say, my lord, is that once a bail application is filed, objections will have to be filed. It will have to be heard. So what I mean to say is the delay. I'm not saying that he has no right. Definitely he can file. But the cause of the delay is not attributed to the prosecution, is my submission.
Heard reserved.
And one submission, my lord. Now, upon conviction, if tomorrow the trial court convicts the accused and impose the sentence of 3 years, where would I stand, my lord? Because I have already, as on today, I already undergone 2 years, almost 8 months detention.
That you have already canvassed.
Yes, sir. That's the court has to take pragmatic view.
According to you, 1/3 already.
Yes, crossed.
Crossed.
Yes.
Even maximum punishment of 7 years. That is
7
your-
years, yes, sir.
That is your argument.
Yes.
Minimum 3 years. It
Yes,
can be
it
extendable.
it may extend to 7
Be
years.
extendable up to 7 years.
Yes,
Even if it is taken 7 years also, 1/3 you have already completed. That is your argument.
yes.
Yes,
I have crossed 1/3.
yes. Good. Next,
72.
Ganesha K. Unnikrishnan.
72.
I'm filing my.
Airline statement of objection, sir.
Same case, I do.
Statement of objection. Same case, sir.
Same.
Same case, so accused bearer.
Accused number 19, your lordship.
He's come on medical ground.
Common medical ground.
Cannot be come together.
Alla, hangalla. Alla, same case andre same complaint.
They are different than the present accused, my lord.
He said arising out of
Same
same
case, case. Same case ಅಷ್ಟೇ ಹೇಳಿದ್ರು.
Your
lordship,
number?
Accused number 19, your lordship.
19.
Yes.
Nimdrali accused number?
Accused number 4.
Houdu. Yes, 4.
Both are interested.
Yes.
Only these two accused are in custody, your lordship.
Hmm.
Accused number 5 to 18 have been enrolled on bail, your lordship.
Ah.
The medical report I produced at page number 263, your lordship. Kindly go to page number 263.
263.
When this petitioner was in JC, he was taken to referred to the Jaydev hospital, your lordship. And there when angiogram was done on a petitioner, he has been diagnosed with the following health problem, your lordship.
263 na?
263, your lordship.
Ah.
A4 angina, diabetes mellitus, hypertension, CAD, that is coronary artery disease, DVD, degenerative wall disease, coronary angiogram was done and so on so. On 13/12/2023, he was admitted at Victoria Hospital so and so from so and so and was diagnosed type 2 diabetic mellitus. HBC was at 13.8%, your lordship. And he was also diagnosed with ischemic heart disease 51%. Next page, your lordship. Eruptive lichen planus, that's a medical term that has been used here. Impression. Patient is suffering from uncontrolled diabetic mellitus, hypertension, ischemic heart disease, coronary artery disease, degenerative wall disease or on medication. Coronary angiogram was done at Jayadeva Hospital on 17/7/2023 and has been advised surgery. This is important, your lordship. Has been advised surgery, 2 valve angioplast, so on, PTCA, LAD and RCA, fractional flow reserve, Zinc, Zegpir stent, if not controlled by medicine, your lordship.
Yes.
The estimation is given at page number 279, your lordship. Kindly, your lordship, kindly refer to page number 279. There already the Jayadeva Hospital has been provided with an estimation bill, your lordship, at page number 279.
279.
Yes, your lordship. Estimation. Estimation letter on the
For surgery.
surgery, yes, your lordship.
When he went to jail?
On 12/2/2023, your lordship. More than 21 months is in JC, your lordship. 21/2/2023.
21?
Sorry, 22nd
2023. From that time, he's in JC, your lordship.
23.
Yes, your lord, please. More than 21 months he is in, and as for accused number 17 is concerned, he has been enlarged on bail by this corner bench.
ಈ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ಸ್ ಎಲ್ಲ ಯಾವಾಗಿಂದು?
JCL ಇರಾಕರ್ನೆ ಕೋರ್ಟ್ ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಬಂದು ಏನು ಆರ್ಡರ್ ಕೊಟ್ಟು ಆನಂತರ ಬಂದಿದ್ದು
ಹೋಗಿದ್ದು.
ಪ್ಲೀಸ್ your lordship.
ಮೊದ್ಲು ಯಾವ್ದು ಇರ್ಲಿಲ್ಲ?
ಇಲ್ಲ ಮೊದ್ಲು ಯಾವ್ದು ಇಲ್ಲ, ಕೋರ್ಟ್ ಇಂದಾನೆ ಕಾಲ್ ಫಾರ್ ಮಾಡಿರೋದು ಸ್ವಾಮಿ.
ಹಾ.
And as far accused number 17 is concerned, he also stands on the same footing as that of accused number 19, your lordship. He was enlarged on bail.
ಏನ್ ಎಸ್ಟಿಮೇಶನ್ ಎಷ್ಟಂತೆ?
2,06,000 ಏನೋ ಕೊಟ್ಟಿದೆ. Your lordship may kindly, for a moment, your lordship may go to page number 204.
Let him undergo for surgery. You will give direction to the concerned.
ಇದರಲ್ಲಿ only one
Subject him for surgery under the supervision of the under trial prison, that's all.
only two para I will refer you. Your lordship may kindly go to page number 204.
You want surgery?
Yes, please, your lord.
Make him to undergo for
In
surgery.
fact, my lord, in the earlier petition, my lord.
ಅವ್ರನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಆಮೇಲೆ ನೀವು ಹೇಳಿರುತ್ತೆ.
Accused number 17 also stands same footing as
Let him
that
go
of.
for surgery under the supervision of the police, that's all.
ಒಂದೇ ಒಂದು 204 ಒಂದೇ ಒಂದು ಪೇಜ್ ಒಂದೇ ಒಂದು ಲೈನ್ ಸ್ವಾಮಿ, ನಾನು ಜಾಸ್ತಿ ಹೋಗಕ್ ಹೋಗಲ್ಲ. 204
4
ಪೇಜ್ ನಂಬರ್ 204.
ಏನಾಯ್ತು?
ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಬರ್ಬೋದು ಸ್ವಾಮಿ.
204.
ಎಸ್ ಹೇಳಿ.
ಸೀರಿಯಲ್
ನಂಬರ್ 6.
ಹೇಳಿ.
The petitioner has the while principal amount ಅಂತ ಇದೆ 20 crores. Rajesh 20 crores and interest 20 crores. Total loan amount is 40 crore 40 lakhs. That's all, your lordship. The only allegation against this accused is that he being an secured loan, he has obtained loan of 20 crores. The interest and payable was principal was into 40 crore 40 lakhs, your lordship. Your lordship may kindly come to page number 227. ಅದು 2016 also. 16 ಅಲ್ಲಿ he has already paid 18.5 lakhs. Your lordship may kindly come to page number
18.5 lakhs.
Allala, sorry, 18.5 crores, sorry. For a moment, your lordship may come to page number 227, your lordship. 227. ಅಲ್ಲಿ ಫೋರ್ತ್ ಪ್ಯಾರಾ ಸ್ವಾಮಿ.
ಇದ್ಯಾವ್ದೋ ಬ್ಯಾಂಕ್ ಹಗರಣ?
ಬ್ಯಾಂಕ್ ಸ್ವಾಮಿ ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ಇದು ಕಂಟಿನ್ಯೂಷನ್. ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ
ಗುರು ರಾಘವೇಂದ್ರ.
ಫಾರ್ ಎ ಫೋರ್ತ್ ಪ್ಯಾರಾ ಸ್ವಾಮಿ, ಆಸ್ ಪರ್ ದ RBI ರಿಪೋರ್ಟ್ ಇಂಟರ್ನಲ್ ಸಿಗ್ತಾವ ಸ್ವಾಮಿ, ಪೇಜ್ ನಂಬರ್ 227 ಫೋರ್ತ್ ಪ್ಯಾರಾ. Report of Masses Guru Raghavendra Bank so Sri Rajesh so is one of the 24 major beneficiaries who has availed loan of 20 crores from Guru Raghavendra Bank, and current outstanding include interest is 40 crore 40 lakhs. Sorry, 40 crore 40 lakhs. Next para, your lordship. Basungudi Police Station has filed 2 charge sheet in crime number 37 of Banshankari Police Station and alleged that VR Rajesh has failed to repay the loan outstanding of approximately 19 crore 64 lakhs, and the investigation is still pending on. The only allegation against this petitioner accused is that he has availed loan of rupees 20 crore and he has already paid of the loan amount. Only outstanding amount is 19 crore 64 lakhs, your lordship. I produced the certified copy of the bail order of accused number 17. Whereas he has availed loan of 105 crores and outstanding amount was 139 crore. The lordship may kindly refer that judgment for a while.
ಈ ಬ್ಯಾಂಕ್ ನವರು ಯಾರು ಅಕ್ಯೂಸ್ ಮಾಡಿಲ್ವ ಇದ್ರಲ್ಲಿ?
Yeah, 1 in the 16 ಅವರು ಅವರೈದಾರೆ.
Bank accused number 4 is bank ಅವರೇ.
One
ಏನವರು?
Vice President.
Your lordship, the accused number 17 stems as that of this accused, whereas this accused has availed loan of 20 crore and remaining outstanding amount he has to pay to the bank is 19 crore 64 lakhs. Whereas accused number 17, he has availed loan of 105 crores, your lordship, and outstanding was 139 crore, and he had also health problem. He was enlarged on bail by imposing condition, your lordship. He stands same footing as that of this petitioner, your lordship. Whereas his outstanding was 139 crore, he has been enlarged on bail. Only allegation against me is that I availed 20 crore and repaid more than 50%. Only I had to repay 19 crore 64 lakhs. That's all the allegation against me.
ಆರ್ಡರ್ ಕೊಡಿ ನೋಡೋಣ.
Please, your ಕೊಟ್ಟಿದ್ದೀನಿ some certified copy ಕೊಟ್ಟಿದ್ದೀನಿ.
ಎಲ್ಲಿದೆ?
ಈಗ ತಾನೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಈಗ ಕೊಟ್ರಾ?
Kindly go to the page number 3, your lordship. Ali last 7th line. The police arrested the petitioner alleging that he has availed loan of 105 crores from the aforesaid bank and 139 crores is the outstanding balance with interest payable to the bank. The A17 summit. Lordship may kindly go to the page number 9, your lordship, page number 9. The entire allegation goes against the bank directors who had lent the loan and they are not able to collect the amount to the tune of 1,500 crores. The petitioner is only borrower. In this case also, this petitioner is only borrower. He has availed loan of 20 crores, paid 50%, only outstanding is principal interest is 19 crores, 64 lakhs. In this case, he has availed loan of 105 crores, outstanding was 139 crores. He was enlarged on bail. I stand on similar footing as that of this petitioner. Accused number 17. That apart, the petitioner is said to be suffering from various ailments, including heart disease and other disease, as the medical report submitted by the learned counsel for the petitioner. The petitioner is continuously under treatment from the year 2020 onwards at Aster RV Medical and Victoria Hospital from Jaydev Hospital. So he has been enlarged on bail, your lordship. Whereas his loan is 105 crore. My loan is only 20 crore. He was enlarged on bail. Accused number. The allegation is only against the accused number 1 to 16, who are the bank officials. Whereas this petitioner is concerned, he is only a secured loan, your lordship. He has only borrowed loan from the bank, your lordship.
You are A19.
A19, your lordship. Only 20 crores I paid. I paid the, I'm producing the bank statement wherein for clearing the amount. That only I cleared the amount. Even for assuming for the.
How much you paid?
21 crores I paid, your lordship. Only 19 crores 65 is balance. As per the charge sheet of the police itself, that is Basmuni police state, it reveals that I had to only repay 19 crores 64 lakhs.
What is your avocation?
Avocation, I am doing business, your lordship.
Business.
Business.
What business?
Business ಒಂದು ರೈಸ್ ಕಾರ್ನರ್ ಇದೆ, ಒಂದು ಇದಿದೆ ಸ್ವಾಮಿ, ಒಂದು ರೈಸ್ ಕಾರ್ನರ್ ಇಟ್ಕೊಂಡಿದ್ರಿ, ಜ್ಯುವೆಲ್ರಿ ಶಾಪ್ ಇತ್ತು.
ಅದಕ್ಕೆ ಯಾಕೆ 20 ಕೋಟಿ ತಗೊಂಡ್ರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ತಗೊಂಡಿದ್ದೆ ಯಾಕಂದ್ರೆ ರಿನೋವೇಷನ್ ಮತ್ತೆ ಬಿಸ್ನೆಸ್ ಇಂಪ್ರೂವ್ಮೆಂಟ್ ಗೆ ಎಲ್ಲ ತಗೊಂಡಿದ್ದೆ ಸ್ವಾಮಿ. 20 ಕೋಟಿ ತಗೊಂಡಿದ್ದೀರಿ. 19
ಏನ್ ಬಿಸ್ನೆಸ್ ఉంది? ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾರೆ.
ಇನ್ಫ್ಯಾಕ್ಟ್ ಅವರು though he I should appreciate that.
ಅಲ್ಲ, ಇನ್ನೊಂದು ಇದೆ ಸ್ವಾಮಿ. Kindly go to page number 102, your lordship. 102.
Page number
102.
102.
ಅದ್ರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಸ್ವಾಮಿ.
Now you are seeking only on medical ground.
ಅಲ್ಲ, ಅದು ಜೊತೆಗೆ ಇದು ಇದೆ, ಯಾಕಂದ್ರೆ ನಮ್ದು 20 ಕೋಟಿ ಲೋನ್ ತಗೊಂಡಿದ್ದೀನಿ. More than 50% ಕಟ್ಟಿದ್ದೀನಿ. ಅಲ್ಲ, ಅವ್ರು ತಗೊಳ್ಳೋ ಲೋನ್ ತಗೊಳೋದೇ ಕ್ರೈಮ್
ಮೆರಿಟ್ಸ್ ಆಲ್ಸೋ ಏನ್ರಿ? ಅರ್ಲಿಯರ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ ನಿಮ್ಮ ಆರ್ಡರ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ?
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಅದು ಒಂದು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಒಂದ್ಸಲ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು, ಅದನ್ನ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದೀವಿ.
ಅವಾಗ ಆಗಿಲ್ಲ?
ಆಗಿಲ್ಲ.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಗಿಲ್ಲ. 102 ಏನ್ ಹೇಳಿ?
102 ಸ್ವಾಮಿ. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಸ್ವಾಮಿ. Forensic audit of the bank has been completed for the year 2009-10, 10-11. Only in respect of the loans advised by the bank, the said audit for the remaining part of the years up to 31/3/2020 needs to be done. However, it could not be completed as the money trail from the source of the ultimate beneficiary is difficult to trace through digital area, as the previous bank management under the leadership and of K. Ramakrishna, who is accused number 4, has created a complex webs of transaction and accounts to mask the fund flow, which requires human intervention at each stage. During the internal investigation conducted so far, it is also revealed that evergreening so-and-so of loan account of bank internal of the loan accounts were perished from 2003 onwards. The auditing was done only for the 2 years, your lordship, 2009 and 10 and 11. So under what presumption they have come to the conclusion that petitioner, the only allegation against this petitioner is that I, along with other 23 associates, misappropriate 234 crores. As per the complaint filed by the respondent, it reveals that I have taken only loan of 20 crores, paid more than 50%, outstanding is 19 crores 64 lakhs.
Yes.
That's all, your lordship. On health ground, the petitioner will be enlarged on bail, because the doctors, the cardiologist who have done angiogram on the petitioner has advised that to immediately insert 2 stents, your lordship, and estimation is also given, your lordship.
Yes.
Please do.
Only stunt.
Add stunt ಹಾಕ್ಬೇಕಂತ ಬಯಸ್ತೀನಿ.
My lord, he had filed 2 bail petitions earlier.
Stunt and ಬೆಳಗ್ಗೆ ಹಾಕಿ ಸಂಜೆ ಕಳಿಸ್ಕೊಟ್ಟು.
ಅಡ್ವೈಸ್ ಆಗಿನೇ ಸುಮಾರು ದಿವಸ ಆಗಿದೆ ಸರ್.
ಇಲ್ವಾ?
Even he has other health problems, ಸ್ವಾಮಿ. ಸುಮಾರು ಹೆಲ್ತ್ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇದೆ. Not only insertion of 2 stunts.
ಹಾಕ್ಸ್ಕೊಳಕ್ ಹೋದ್ರೆ ಬೆಳಗ್ಗೆ ಹೋದ್ರೆ ಸಂಜೆ ಒಳಗೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರ ಜೊತೆಗೆ ಇನ್ನು ಬೇರೆ ಹೆಲ್ತ್ ಪ್ರಾಬ್ಲಮ್ is diabetic is 13.8 HB1AC, lordship.
ದೇಶದಲ್ಲಿ ಅರ್ಧ ಜನ ಎಲ್ಲ ಡಯಾಬಿಟಿಕ್.
Hypertension ಇದೆ, ischemic heart disease ಇದೆ.
Even hypertension also.
Hypertension.
My lord, 2 bail applications were filed, my lord. Both were rejected on merits earlier, not before this court, before Sessions Court. Yes, TS file 2.
Sessions court.
Yes, Sessions Court. There, my lord, one was rejected on 13/2/2024. There, my lord, there is not a single whisper of medical ground at all.
Medical ground ಇಲ್ಲ.
Ilve illa. Absolutely no whisper of medical ground at all.
ಯಾವಾಗ ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿದ್ದು?
ಆಗಿರೋದು 13/2/2024.
ಕ್ಲಿಯರ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀನಿ ಸರ್ ನನ್ನ ಪಿಟಿಷನ್.
13/2
2024.
ರಿಜೆಕ್ಷನ್.
ಹೌದು. And all these medical reports, my lord, are the year 2023.
Ground.
Or medical ground. And there's no medical ground at all. Now, my lord, if you speaking.
advice ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ.
ಇರ್ಬೋದು.
ಅಲ್ಲೇನ್ರಿ?
ಹೌದು ಸ್ವಾಮಿ, ಕ್ಲಿಯರ್ ಆಗಿ 8ನೇ ಪರ ನಾನು ಏನ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀನಿ.
ನಾನು ಹೇಳಿದ್ದು ಅಲ್ಲಿ ಅಡ್ವೈಸ್ ಮಾಡಿಲ್ಲ, ಇಲ್ಲಿ ಅಡ್ವೈಸ್ ಮಾಡಿದಿರಿ ಅಂತ. ಆಯ್ತು.
And my lord, it is not just 20 crores which he has borrowed. My learned friend was honest enough to say that he's into rice business and gold business, etc. My lord, he has availed 80 crores, 20,229,000, my lord, and he has not repaid.
80 crores.
80 crores, which are specifically told in paragraph number 229, table number 11 ali. Rajesh in his individual capacity 42 lakhs, Dharani Enterprises, that is his firm, 13 crores.
Different names.
ಹೌದು. ಲಕ್ಷ್ಮಿ ರೈಸ್ ಕಾರ್ನರ್ ಅದಲ್ಲಿ
names. He is also one of the partner.
Yes, he is a partner. Yes, I've said though. The loans availed by Rajesh in his name and the names of his accused concerns are mentioned below. So Vaibhav, he said he's into gold business. Adallu 12 ಕೋಟಿ ತಗೊಂಡಿದ್ದಾರೆ. Lakshmi rice corner, he has taken 100 crores. So the 10 crores. My lord, on the whole, my lord, 80 odd crores. My lord, he's part of that syndicate.
80 crores, 20 lakhs, 29.
What they do, my lord, is that they create fake concerns, take the money, and then, my lord, use for some other purposes. Money of various investors. My lord, that is how, my lord, you see, he is part of that entire gang. Around 24-25 people were part of it, my lord. He is not just an innocent borrower who's now all of a sudden in 2023 trying to repay. He is now giving back the money which he has used, rotated and giving back. He is not repaying. So, my lord, that is on the merits of the case. As far as medical ground is concerned, my lord, for the first time it is stated here. So hence, my lord, he can still, my lord, go and avail treatment at Jayadeva, my lord.
Application was rejected on 13/2/24.
Please, dear lord.
Now you have relied upon the medical records of 2023.
That was not called for in the earlier two bail petitions, your lordship, and the medical ground was not urged in that two.
Here,
Please, dear lord.
you have relied upon the documents of medical records of 2023.
Please, dear lordship.
Why you have not relied upon these documents before the Sessions Court in 2024?
No, your lordship, I filed in the to a year 2024.
ಕೆಲವು ಕೇಸಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗ್ಬಿಡುತ್ತೆ ಬೇಲ್. ಇಲ್ಲಿ ಬರೋದ್ರಲ್ಲಿ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ರೆಡಿ
ಇಲ್ಲ ಸ್ವಾಮಿ, ಜೈಲಲ್ಲಿ ಇರಾಕರೇ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂತಾ ಇದ್ದೀವಿ ಸ್ವಾಮಿ. Jail authorities only have submitted records to the special judge, your lordship. Only after the special court has called for the medical record.
ರೀಸೆಂಟ್ ಕೇಸ್.
Recent ಇಲ್ಲ ಸ್ವಾಮಿ, 15/7/2000.
ರೀಸೆಂಟ್ ಕೇಸ್ ಹೇಳ್ತಾ ಇದೀನಿ ನಾನು.
Please, dear lordship.
ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ನೋ ಪೀಸ್ ಆಫ್ ಮೆಡಿಕಲ್ records before the trial court.
Even for the sake of argument,
Court ಬಂದ ತಕ್ಷಣ medical records.
Whereas accused number 17, he has availed loan of 105 crores.
ತಿರ್ಗಾಡಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ರು.
105 crores. So none, even assuming for the sake of argument, if the other side learned counsel for the respondent is upset, I have a loan of 80 crores. Even then also that amount is much lesser than also.
Stunt haksana bidi under the care of police. You need the bail only on the ground of medical ground. Stunt haksana bidi.
My lord, this honorable court in criminal petition 5974 of accused number 4 has said so, my lord. He has also come 5974/2023. My lord, at page 262 in the earlier petition.
Earlier petition.
Other accused number 4, he had also come on same issues. A heart problem. My lord had said that he can.
ನೀವು ಅದನ್ನ ಇಲ್ಲಿ ಮಿಕ್ಸ್ ಮಾಡಂಗಿಲ್ಲ.
ಅಲ್ಲ what
ಈ ಕೇಸಿಗೆ ಮಾತ್ರ ಹೇಳ್ಬೇಕು ನೀವು.
He can avail from the Jayadeva Institute, my lord, which is premier institution, my lord.
And this accused is totally different, your lordship. He is the president of the bank, whereas he is only borrower of the loan. Accused number 17 has availed 105 crore. Even assuming for the sake of argument, if I borrowed 80 crore, I am liable.
ಕುಳ್ತಾರ ಅವ್ರ ಬಗ್ಗೆ ನೀವೇನು ಹೇಳಂಗಿಲ್ಲ. ನಿಮ್ ಕೇಸ್ ಮಾತ್ರ ನೀವು ಕ್ಯಾನ್ವಾಸ್ ಮಾಡಿ.
Please, dear lordship.
ಮಾತ್ರ ಗ್ರೌಂಡ್ ಏನಿದ್ರೆ ಹೇಳಿ.
Even on the ground of parity also I am.
ಅವ್ರು ಬೇಜಾರು ಮಾಡ್ಕೋತಾರೆ, ನಮ್ ಕೇಸ್ ಮೇಲೆ ಹಿಂಗೆ ಹೇಳ್ತಾವ್ರ ಅವ್ರು. ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ.
ಆರ್ಡರ್ ರಿಸರ್ವ್ ಎರಡೂನು. ಎರಡು ಒಂದೇ ದಿವಸ ಕೊಟ್ರಿ ಆರ್ಡರ್ಸ್ಗೆ. ಒಟ್ಟಿಗೆ ಕಳಿಸಿ ಎರಡು ಡಿಕ್ಟೇಷನ್.
Adjourn 74. Prasanna DP.
70? The order passed under section 204. Registering the case against the petitioner for various offences mentioned in the complaint is under challenge. Where is that impugned order? My lord, impugned order is at page 45. Page number 19? My lord? Page number 19? Impugned order. 45. My lord, earlier, the trial court had rejected the complaint, dismissed the complaint. A revision was filed before the sessions. The order of the trial court was reversed. And magistrate was asked to reconsider the matter based on the records. That was challenged before this court. And this court has in page number 213. 213. Upheld the order of the session judge. Therefore, the session judge order remained. Magistrate had to reconsider. May I read 217? Para 7. Yes. Having heard the arguments of the learned counsel for the petition and also perusal of the record, specifically the complaint in para 4, the respondent made an allegation with regard to the relationship between the parties. So also in para 5, a specific allegation is made that the accused himself has forged her signature and has applied for kata and in connivance with the revenue officials for the BDMB got the kata which is contrary to the sale deed by misrepresentation. Then the magistrate, while passing the order, came to the conclusion that there are no sufficient material to issue process. It was also observed that the complaint is challenging the sale deeds dated 21/1/13, 17/10/13 and 3/5/13. And the very observation made by the learned magistrate is erroneous. The complaint allegation is that the signature of the complainant is forged and in connivance with the revenue officials got kata in respect to the sale deeds of the complainant. The revisional court, while reversing the finding of the magistrate, had assigned the reason that the complainant has filed a civil suit to pursue her remedy in respect to the civil right. A specific allegation in the complaint is that signature of the complainant was forged and the same is punishable under section 465. And further made the observation that the accused has fraudulently forged the signature of the complainant and created the document, and the accused, with the dishonest intention, deceived the petitioner, obtained the kata in respect to the property which she has purchased. The criminal act is concerned, the matter has to be investigated by the investigating officer, and the civil dispute pending is not a ground to dismiss the complaint. Your Lordship has conferred it. Middle of next page. I do not find any error committed by the revisional court in coming to the conclusion that the charges of forgery is alleged in the complaint, and the same has to be examined and proceeded in accordance with the law. Now, for the limited purpose of issuance of notice, I shall take your Lordship to the none of the photos. You know, your Lordship will get page 127. You see, the relationship of the parties is the complainant and the accused are related in that the accused father is the brother of complainant's wife and complainant's husband. Complainant resides in Hyderabad, accused is in Bangalore. He built a 3-storied building with a sanctioned plan comprising of 2 floors in 3 floors, ground, first and second. She purchases at 3 different intervals, 3 flats. 2 in the first floor, later on 1 in the second floor. Sale deed is not,
There is no fraud alleged so far as the execution of child is concerned. Fraud is alleged in getting the Kata registered. Now, your lordship, see, Kata applications are in page 126, 27. There are 4 applications filed.
Now, what is the status of the case?
The magistrate has registered the case and issued summons.
Summons.
Summons
Charge
for
Charge sheet also filed.
charge sheet illa Swami.
Okay, private complaint.
Private complaint.
Sworn statement was recorded, cognizance was taken.
Taken and summons,
Now
case was
summons-
registered and
Summons has been issued.
summons issued for appearance of the. 126 is in respect of flat F1. 128 is in respect of flat F2, that is first floor 1 and 2. 30 is in respect of flat SF1. 132 is in respect of 4 remaining flats. 2 in the ground floor, 1 in the second floor and 1 in the terrace floor.
Yes.
All these 4 are to be registered in the name of the owner, that is the builder. All these 4 applications are signed by him. There is no question of forgery. He signs in all the 4 applications. Learned magistrate does not look into this aspect. Merely because she says forgery, 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 whose forgery, who has forged? Next aspect is, if it is required, I will take your lordship to other thing. Complaint averments, complaint at page 53.
Let the notice be issued to the complainant also in here and.
57, ಅದಕ್ಕೆ ನಾನು ಹೇಳಿ ನೋಡಿ ಏನೇನು ಅಫೆನ್ಸಸ್ ಹಾಕಿದಾರ 193, 405 and 415 are definition, 419, 420, 460, etc.
After issuing the notice.
ಅದೇ
If no case, we will quash it.
Exactly, I can't.
Government ಅಲ್ವಾ?
ಇಲ್ಲ
State is directed to take notice for
ಇಲ್ಲ
respondent.
ಸ್ಟೇಟ್ ಇಲ್ಲ ಪ್ರೈವೇಟ್
State
ಕಂಪ್ಲೇಂಟ್
is only private complaint.
ಓನ್ಲಿ ಪ್ರೈವೇಟ್.
Issue notice against the respondent.
This is a warrant case. The stage would be recording of complainant's evidence. The moment the accused appears. Complainant evidence before charge. Therefore, there may be a stay of the proceeding still.
ಏನ್ ಶುರುವಾಗಿದೆ ಇಲ್ವಲ್ಲ ಇಲ್ರಿ ಫಸ್ಟ್ ಒನ್ ಅಲ್ವಾ 74 ರೀ ಯಾವ್ದು ಬೇರೆ ನೋಡ್ತಾ ಇದ್ರು 74 ನೋಟಿಸ್ ಓವರ್
Let there be a stay, my lord, she is an item.
list this matter on 412
My lord,
412 412 412
request for an interim. Interim order.
interim order. If you want an order, I will pass an order.
Interim order of stay.
If you want an order, I will pass an order. You have not made out any ground for stay of the further proceedings. That's why. If you want an order, I will pass an order. That's why, without rejecting the application. Notice, I pass an order.
Order.
Notice overlook.
75 PM Venkat Reddy for further hearing Latif B.
Your petition comes. This is a case perhaps your lordship remember. The dischargeal application was.
ಯಾವ್ದು ಇದು ಇದ್ರದ್ದ ಏನಾಯ್ತ್ರಿ ನಿಮ್ದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆ ಕೇಸ್ ಇದು
ಹೌದು
ಹಾ, ಹೇಳಿ ಏನಾಯ್ತು
As many as 25 cases were filed, all together it will list in the High Supreme.
ಇದೊಂದ್ ಕೇಸ್ ಅಲ್ಲಿ 25 ಇದೆ
Similar, these kind of orders were passed on the ground that FIR was registered subsequently after obtaining 17 order. 17 order and the FIRs were simultaneously registered. Immediately on the basing of source report, we will get an 17 order and we'll register the FIR very moment. The ground raised in all the petitions are first on the source report, immediately we have to register an FIR, then we have to take permission under 17. That is on technical grounds, the proceedings, almost all the petitions are allowed. And nearly 20-25 appeals were.
25 ಬೇಡ ಈ ಕೇಸ್ ಮಾತ್ರ ಹೇಳಿ.
Yes.
ಮೂವ್ ಮಾಡಿದ್ರ ಇಲ್ಲ?
ಮೂವ್ ಮಾಡಿದ್ದೀವಿ.
ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿದೆಯಾ ಇಲ್ಲ?
ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿಲ್ಲ.
ಇಲ್ಲ. ಆಯ್ತು. ಹೇಳಿ.
This is a case perhaps, my lord,
I think this court has heard in detail. Only additional documents you have produced. ಅದ್ರ ಬಗ್ಗೆ ಏನಾದ್ರು ಹೇಳಂಗಿದ್ರೆ ಹೇಳಿ.
ಇಲ್ಲಿ ಈಗ ಇಷ್ಟೇ ಸ್ವಾಮಿ. ತಾವು
again notes ಇದೆ ಇದ್ರಲ್ಲಿ already.
Total there are 5 accused persons. Accused number 1 was, the proceedings has been quashed. Main is the main accused. 13-1.
This petitioner is accused number 1.
ಅಲ್ಲ. 4.
A4.
A4. A1 ಅನ್ನೇ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರ ಮೇಲೆ ಇರೋದು ಕೇಸು 30 ಅಂಡರ್ PC ಆಕ್ಟ್ my lord. ತಗೊಳ್ಳಿ 13-1.
PC Act against accused number 4. ಅದ್ಯಾರ ಚಿಕ್ಕಗಿರಿ
accused number 1 ಮೇಲೆ ಒಂದು ನಿಮಿಷ. accused number 1 ಮೇಲೆ PC ಆಕ್ಟ್ ಇರೋದು.
ಅದೇನಾಯ್ತು? ಕ್ಲಾಶ್ ಆಯ್ತಾ?
ಇಲ್ಲಿ ಕೊಡಿ ಆಕ್ಷನ್. ಅದು ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ ಯಾವ್ದಲ್ಲ
ಇದೆ. A3 ಇದು ಡಿಸ್ಮಿಸ್ ರಿಪೋರ್ಟೆಡ್ ಜಜ್ಮೆಂಟ್.
A3 ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
482 ಡಿಸ್ಮಿಸ್ ರಿಪೋರ್ಟೆಡ್ ಜಜ್ಮೆಂಟ್.
A1
ಸ್ವಾಮಿ ನಾನು ಹೇಳ್ತೀನಿ.
ಕೋಆರ್ಡಿನೇಟ್ another
ಸ್ವಾಮಿ 13-1 E and D. ಹೇಳ್ತೀನಿ 13-1 E and D and 13-2 ಅವರ ಮೇಲೆ ನಮ್ಮ ಮೇಲೆ 109 ಮಾತ್ರ.
109.
2 to 5.
109 against you. Only you lent some money to him to pay the money to the some medical college of the daughter of accused number 1. ಹೌದಾ? That I can recollect my memory.
Correct. ಅದ್ರಲ್ಲಿ ED ರೇಡ್ ಮಾಡಿದ್ರು. ED ಕೇಸನ್ನು ಕ್ರಾಶ್ ಆಯ್ತು. ಅದರ ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ. ಈ A1 ಮೇಲೆ
ನಾಟ್ so far as this.
A1 ಮೇಲೆ ಅವ್ರು ಅದೇ ಹೇಳ್ತಾರೆ.
That is
ನೀವು ಮಧ್ಯದಲ್ಲಿ ಮಾತಾಡಿದ್ರೆ ಪ್ರಯೋಜನ ಆಗಲ್ಲ.
ಪ್ಲೀಸ್
ನೀವು ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರಿ. ಅವ್ರು ಹೇಳಿ ಆಮೇಲೆ ಹೇಳಿರಂತೆ.
ED ಮತ್ತೆ ಇವ್ರ ಪ್ರೇಮಿಸಕರ ಲೋಕಾಯುಕ್ತ ಅಲ್ಲ ಯಾವ್ರಿ ಫಸ್ಟ್ ED ಆಯ್ತು. ಮತ್ತೆ ಲೋಕಾಯುಕ್ತವರು ಮತ್ತೆ ರೇಡ್ ಮಾಡಿ ED ಅವ್ರು ಕೊಟ್ಟಿದ್ರಿಂದ ಅವರು ತಗೊಂಡು ಇವ್ರ ಮೇಲೆಲ್ಲ ಹಾಕಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ ವಿ ಆರ್ಗ್ಯೂಡ್ ದ ಕೇಸ್.
ಈಗ ED ಕೇಸು ಲೋಕಾಯುಕ್ತ ಕೇಸು ಎರಡು ಕ್ವಾಶ್ ಆಗಿದೆಯಾ?
ಎರಡು ಕ್ವಾಶ್ ಆಗಿದೆ.
A1 ಮೇಲೆ
ಅದ್ರ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು.
ಆದ್ಮೇಲಿಂದ ಏನಾಯ್ತು ಈಗ ಡ್ಯೂರಿಂಗ್ ದೆನ್ my lord this situation was not there. ಯಾವಾಗ when you argued the case before a trial court
ಅವಾಗ ಇರ್ಲಿಲ್ಲ.
ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡು.
these are all subsequent
development. ಅಲ್ಲಿಂದ we filed an application section 227 my lord that came to be rejected in respect of accused number
discharge.
Discharge ಗೆ
rejected.
ಹೌದು. 2 and 4 was rejected.
2 and 4.
3 and 5 was allowed.
3
and 5
allowed discharge application.
How's sir?
What about accused number 2 now?
He's also, I don't know, because I appear for only accused number 2.
Now it is proceedings is continued against
matter is pending now.
A2.
Now I have filed an application for 397 challenging the order of the refusal for discharge. Now short question is this, my lord. Am I entitled in this situation to be discharged from the charges? Now I can't go there before the trial court and produce the copies. Under law, it is not that totally barred. ಯಾಕಂದ್ರೆ A1 ಅನ್ನೇ ಡಿಸ್ಚಾರ್ಜ್ ಆದ್ಮೇಲೆ what is the case remains tell. Several judgments have.
ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆನೇನೆ ಹೋದ್ಮೇಲೆ ಬಾಲ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತಾ ಇದೀರಿ ಅಂತ.
ಅದೇ ಈಗ ಆ ಪರಿಸ್ಥಿತಿಗೆ ಬಂದು ನಿಂತಿದೆ ಈಗ ಅಲ್ಲಿ. ಬಿಕಾಸ್ ಅದರಲ್ಲಿ ಲಾ ಅಂಡರ್ ಸೆಕ್ಷನ್ 109 is abating to commit the offense. ಆ ಅಬೇಟೆ
last time I asked why you made the payment of rupees 20 lakh to a government employee ಅಂತ ಕೇಳಿದೆ. ನೀವ್ ಯಾಕೆ ಹೇಳಲಿಲ್ಲ?
ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯ್ ಅಂತ ಹೇಳಿ ನಾನು ಬರ್ತಾ ಇಲ್ಲ. known person, friend of mine, he asked me to lend certain.
known friend government employee ಅಲ್ವಾ?
ಸ್ವಾಮಿ ಅಲ್ಲ, ಅವನು
government employee ಅಲ್ವಾ ಅಂದೆ.
ನಾವು I am a private man. I'll just make.
You are a private man. You are a doctor.
ನಾನು ಅವನು ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯ್ ಅಂತ ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅವನಿಗೆ.
ಏನಂತ ಕೊಟ್ರಿ?
He is known to me, friend of mine. I gave him money. Not I don't have concern about his dealing.
You are not concerned about repayment.
His memory, his business and all that I am unconcerned. He wanted his daughter to be admitted. A human considerations. He approached me. I said, all right. I am also doctor. My father is also doctor. We have money, our own contest. That is not that. If that is the case, income tax people will take action. That is a different matter. Now the allegation is that I have paid him money. And 109 ಪ್ರಕಾರ independent ಆಗಿ nothing can be done because if I have abetted, whom did I abet? There is no material at all.
Yes.
What they have sought is Lokayukta that has been now stands out of the proceedings itself.
Yes.
ನಾನು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೆ ಅವನ ಕಡೆಗೆ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟು ದುಡ್ಡು ಕೊಡಿ ಅನ್ನೋದು ವಸೂಲು ಮಾಡ್ಕೊಳ್ತೇನೆ ಕಾನೂನು ಪ್ರಕಾರ ಏನಿದೆ ಅಂತ ನೋಡಿ ಬಿಕಾಸ್ ದರ್ ಇಸ್ ಎ ಪ್ರೂಫ್ ಇಟ್ ಇಸ್ ನಾಟ್ ದಟ್ ಸಪ್ರೆಸ್ ದ ಫ್ಯಾಕ್ಟ್ ಅಂಡ್ ಆಲ್ ದಟ್ ಐ ಹ್ಯಾವ್ ಮೆಟೀರಿಯಲ್ ಟು ಶೋ ಅಂಡ್ ಈ ಡಿಡ್ ನಾಟ್ ಸೇ ದಟ್ ಐ ಡಿಡ್ ನಾಟ್ ಪೇ ದ ಮನಿ ಆಲ್ಸೋ ಅದು ಬಂದ್ರೆ ನಾನು ಫೇಸ್ ಮಾಡ್ತೇನೆ ನಮಗೆ
ನೀವು ಕೊಟ್ಟಿರೋ ದುಡ್ಡು ಯಾವ್ದು ಡೇಟ್ ಅಲ್ಲಿ ಇದು
ಏನು ಸ್ವಾಮಿ
ಡೇಟ್ ಆಫ್ ಪೇಮೆಂಟ್ ಯಾವ್ದು
ಒಂದು ನಿಮಿಷ ಹೇಳ್ತೀನಿ
ಡೇಟ್ ಆಫ್ ಪೇಮೆಂಟ್ ಆಫ್ ₹20 lakh
ಕೊಡ್ತೇನೆ
ಹಾ
ಸ್ವಾಮಿ ಪೇಜ್ ನಂಬರ್ 29 ನಲ್ಲಿ ತೋರ್ಸ್ ಸರ್
22/3/2012 23
28
22/3/2012
ನಾವು
2012
ಹೌದು ಪೇಜ್ ನಂಬರ್ 28 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ ಓದಲ್ಲ ಅಲ್ಲ
ಬೇಡ ಓದೋದು ಬೇಡ ನಾನು ಡೇಟ್ ಮಾತ್ರ ಕೇಳಿದೆ
ಆಯ್ತು
22/3/2012
ಕರೆಕ್ಟ್ ಅದನ್ನೇ
ನೀವು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಡಿಕ್ಲೇರ್ ಮಾಡಿದೀರಾ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಮೇಡ್ ದಿ ಪೇಮೆಂಟ್ ಆಫ್ ₹20 lakh.
This is a question which I say. Should we go beyond unnecessary things which
unnecessary thing ಅಲ್ಲ ನಾನು ಹೇಳ್ತೀನಿ ನಿಮಗೆ unnecessary ನನಗೆ necessary
ಅಲ್ಲ ತಮಗೆ ಹೇಳ್ತಿಲ್ಲ ಸ್ವಾಮಿ you have right to ask that. I'm not showing that you don't have right.
You being a doctor, you
Yes.
made the payment of ₹20 lakh
How?
to a particular person of a government servant. That's why I asked whether you have discussed, declared the same in your income tax returns.
ರಿಟರ್ನ್ಸ್ ಗಳಲ್ಲಿ ಅದನ್ನೆಲ್ಲ ತೋರಿಸಿದ್ದೇವೆ ನಾವು ತೋರಿಸಿದ್ದೇವೆ
ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಬಿಡಿ
ಸಂಜೆಯಲ್ಲಿ ಈಗ
ರಿಟರ್ನ್ಸ್
ಫೈಲ್ ಮಾಡಿದ್ದೇವೆ
ಮಾಡಿದಾಗ ಡಿಕ್ಲೇರ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಮೇಡ್ ದಿ
ಪೇಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ
ಮಾಡಿದ್ರೆ ಕೊಟ್ಬಿಡಿ ಡಾಕ್ಯುಮೆಂಟ್
ತಂದಿದ್ದೀರಾ ನಾನು ಇಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬಿನ್ ಬ್ರಾಟ್ ಬಿಕಾಸ್ it wasn't at that stage, it was not required before a trial court. ಆ ಉದ್ದೇಶ ತರಲಿಲ್ಲ ಆಯ್ತು ರಿಟರ್ನ್ ಫೈಲ್ ಮಾಡಿದ್ದೇನೆ ಒಂದು
ನಾನೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ದೆ ಇದನ್ನ ನಿಮ್ಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಾಗ
ಎಲ್ಲಿಂದ ಇತ್ತು ಅಂತ ಕೇಳಿದ್ರು ನಾವು ಪ್ರೈವೇಟ್ ನಾವೇ ಇದ್ದೇವೆ
ನಿಮ್
ನಾವು
ದುಡ್ಡು ಎಲ್ಲಾರು ಇಲ್ಲಿ ನಂಗೆ ಬೇಡ ನೀವು ಡಿಕ್ಲೇರ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಅಂತ ಕೇಳಿದೆ
ನಮ್ಮ ಕೆಲವು ಪಿಟಿಷನ್ ಅಪ್ಲಿಕೇಶನ್
being a doctor you said that your father is also a doctor.
Yes.
2-3 generation of doctors, not a layman.
ಇದರಲ್ಲೇ ಕೊಟ್ಟಿದ್ದು all these payments are made not by private. There is a page number.
I am not on payment is also concerned. Once you have paid the amount of ₹20 lakh on 22/3/2012, did you declare the same?
The
in
bank
income tax returns filed next year.
ಅದು ಆಟೋಮೆಟಿಕಲಿ ಆಗ್ತದೆ for this reason.
Automatically ಬೇಡ ನೀವು you answer to my question.
ಅದನ್ನ ಹೇಳ್ತೀನಿ
You answer to my question. Automatically ಅವೆಲ್ಲ ನಾವು presumption ಬೇಡ. ಮಾಡಿದಿರಾ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿ.
These payments are made by check through the bank.
ಆಯ್ತು ಆಗ್ಲಿ.
ಆಯ್ತಾ ಸ್ವಾಮಿ ಒಂದು ನಿಮಿಷ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಾಗ ದಿ ರಿಟರ್ನ್ಸ್ ಇಸ್ ಆಟೋಮೆಟಿಕ್ ಅಂತ ಹೇಳಿದ್ರೆ ವಿಚಾರ ತಮ್ಮ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ. ಬ್ಯಾಂಕ್ ಥ್ರೂ ಹೋದಾಗ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ ನಾಟ್ ಓನ್ಲಿ ಒನ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಮೇಲೆ several transaction has been taken place. ಅದಕ್ಕೆ ನಾವು ತಮ್ಗೆ ಹೇಳಿದ್ರೆ ಪೇಜ್ ನಂಬರ್ 180
My question ಆಯ್ತು next
180 ಅಲ್ಲಿ ಅದು ಬರ್ತದೆ. ಒಂದು ಎರಡನೇದು ಎಲ್ಲಾ ವಿಚಾರ ವಿಲ್ ಸಬ್ಸೈಡ್ ಮೈ ಲರ್ನ್ ಫ್ರೆಂಡ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಈವನ್ ಅದರ್ವೈಸ್ ಇಸ್ ದ ಮನಿ ಇಸ್ ಪೇಡ್ ವಾಟ್ ಇಸ್ ಅಫೆನ್ಸ್ ಮೇಡ್ can
offense is abetting the offense
ಅಲ್ಲ can the Lokayukta can take any action against the petitioner? I'm a private man, his official himself is gone, and the law what it says is under section 109 is, and punishment ಕೊಡ್ಬೇಕಾದ್ರೂ ಆ ಮೇನ್ ಕೇಸಿಗೆ ಏನು ಪನಿಷ್ಮೆಂಟ್
ಲೋಕಾಯುಕ್ತ ಆಕ್ಟ್ ಅಲ್ಲಿ ಅಬೇಟ್ಮೆಂಟ್ ಕಮಿಟಿಂಗ್ ಏನ್ ಅಫೆನ್ಸ್ ಇನ್ವೋಕ್ ಮಾಡಿಲ್ವ ಅವರು ಓನ್ಲಿ 109 ಮಾತ್ರ ಇನ್ವೋಕ್ ಮಾಡಿದ್ದಾರೆ.
109 ಮತ್ತು ನಮ್ಮ ಹತ್ರ ಮಾಡಿದ್ದಾರೆ
109 ಮಾತ್ರ.
ಹೌದು.
Even PC Act also there is a provision if any abatement
section 12 independent abatement to do to certain illegal act justified. ತಾವು ಹೇಳುದು ನಿಜ. ಯಾವ್ದು ಇಲ್ಲಿಗಲ್ ಆಕ್ಟ್ ಆ ಆಕ್ಟ್ ಇದ್ಮೇಲೆ ಇದನ್ನೇ ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ನಾನು ಸೆವೆರಲ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ನಾನು ಕೊಟ್ಟಿದ್ದೇನೆ ತಮ್ಮ ಹತ್ರ. ಇವನ್ ಎಕ್ವಿಟ್ ಮಾಡಿದಾಗಲೂ ಇವನ್ ಆಟೋಮೆಟಿಕಲಿ ಇದು ಹೋಗ್ತದೆ ಅಂತ ಹೇಳಿ ಅದನ್ನ in that view of the matter it is not desirable to allow this man alone to contest the case before the trial court has the main accused himself has been discharged from 3 and 5 Akila. 3 and 5 Akila. And secondly is interestingly the other two accused persons who have been discharged they have not challenged. It is not challenged.
ಅವ್ರು ಮಾಡಿಲ್ಲ ಅವರು 3 and 5 ಏನು ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಚಾಲೆಂಜ್ ಇಲ್ಲ. ಅವರು the same situation, what I'm standing the food stand, the same stand, they are also in situation. And should, and ultimately, the court cannot frame a charge saying that you have committed abatement of what? Of what they ಇಲ್ಲ. ಅದೇ ಹೊರಟೋಗ್ಬಿಟ್ಟಿದೆ. ಆ ಕಾರಣದಿಂದ would it be desirable to allow this petitioner to continue as an accused before the trial court? Yes. ನಾನು ಅದಕ್ಕೆ ಎರಡು ಹೇಳಿಕೆ ಹಾಕಿದ್ದೇನೆ. ಒಂದು ಇದು this court has power under 482 to exercise, because it's a constitutional bench, my lord, have power ಅಂತ ಹೇಳಿ several judgments ಅನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ. ಆ ಕಾರಣದಿಂದಾಗಿ
ಅಲ್ದಲ್ಲೇ ಸುಮಾರು ಪೇಪರ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಷ್ಟು ಅಲ್ದಲ್ಲೇನೆ ಲಾಸ್ಟ್ ಟೈಮ್ when I was in ಧಾರವಾಡ ಬೆಂಚ್.
ಅಲ್ಲ ಇಲ್ಲಿದ್ದಾಗಲೇ ಧಾರವಾಡ bench ಅದನ್ನ ತಾವು ಓದಿ ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ ಇಡೀ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನು ಒಂದೊಂದು ಬೇಕಾದ್ರೆ ಓದಿ
ಹೇಳಿ ಅಂತ ನಾನು ಹೇಳಿದ್ ಲಾಸ್ಟ್
ಅದರ ಜಿಸ್ಟ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ ಸ್ವಾಮಿ. ಆ ಜಿಸ್ಟ್ ಅಲ್ಲಿ
ಹಾಕಿದೀರಾ?
ಹಾಕಿದ್ದೇನೆ. ಜಿಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿ ಪ್ಯಾರಾ ನಂಬರ್ ಯಾವ್ದು ರಿಲೆವೆಂಟ್ ಅಂತ ಹೇಳೋದನ್ನ
ಆಲ್ಮೋಸ್ಟ್ 300 pages ಇದೆ.
ಅದೇ ಅಲ್ಲ ಅದರಲ್ಲಿ ಯಾವ್ದು ಪೇಜ್ ಅಲ್ಲಿ ರಿಲೆವೆಂಟ್ ಅಂತ ಹೇಳೋದನ್ನು ಹೇಳಿದ್ದೇನೆ. ಯಾಕಂದ್ರೆ as I said, sorry I am repeating, though because of this honorable High Court is a constitutional bench, it is empowered wherever injustice have been done, or the variations of these things to continue, we can exercise the powers under section 482 ಅಂತ ಹೇಳೋದನ್ನ ನಾನು ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 1 ನಲ್ಲಿ ತಮಗೆ ಹೇಳಿದ್ದೇನೆ. ಅದರ ಎಲ್ಲ ಪೇಜ್ ನಂಬರು ಪ್ಯಾರ ನಂಬರು ಎಲ್ಲ ಬರೆದು ಇಟ್ಟಿದ್ದೇನೆ. ಬಿಕಾಸ್ ರೀಡಿಂಗ್ ಇಟ್ ಶುಡ್ ನಾಟ್ ಬಿಕಮ್ ವಾಲ್ಯೂಮ್ನೆಸ್ ಅಂತ ಹೇಳೋದಕ್ಕೆ 10 ಜಡ್ಜ್ಮೆಂಟ್ಗಳನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ. ಅದ್ರಲ್ಲಿ ಒಂದರಲ್ಲಿ ಮಾತ್ರ ಒಂದು ಪೇಜ್ ನಂಬರ್ ಬಿಟ್ಟು ಹೋಗಿದ್ದೆ, ನಾನು ಈಗ ಬರೆದು ಕೊಡ್ತೇನೆ. ಪ್ಯಾರ ನಂಬರ್ 33 ಪೇಜ್ ನಂಬರ್ 2 ಅಲ್ಲಿ 10th ಸೀಲ್ ನಂಬರ್ 3, 8, 9, 10 ಈ 3ರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ಗಳನ್ನ ಪ್ಯಾರ ನಂಬರ್ಗಳನ್ನ ನಾನು ಈಗ ಬರೆದು ಕೊಡ್ತೇನೆ. ಟು ಬಿಕಮ್ ಹ್ಯಾಂಡಿ, ಅದರ್ವೈಸ್ ಇಟ್ ಬಿಕಮ್ಸ್ ಲ್ಯಾಬೋರಿಯಸ್ ಟು ರೀಡ್ ಅಂಡ್
ಕೊಡಿ ಅದಕ್ಕೆ ಕೇಳಿದ್ ನಾನು. there are lot of citations here.
ಅಲ್ಲಿ ಅದನ್ನೇ ಬರೆದು ಕೊಡ್ತೇನೆ. Because so that need not be a whole thing need not be taken into account. So thereby there is one more judgment of our High Court, my lord, which is
ಇದು ಹಾಕಿದೀವಿ
ಎರಡು ಕಾಪಿ ಕೊಡಿ.
ಇದು ನಮ್ದು.
There was a time, my lord, we have got some papers.
ಇದು ಕೊಟ್ಟಿದ್ದು ಇದು ಮೊನ್ನೆ ಹಾಕಿದ್ವಿ.
ಈಗ ಕೋಟಿ ಇದಕ್ಕೆ ಯಾವ ಪ್ಯಾರ ಇದರಲ್ಲಿ ಸ್ವಾಮಿ ವಿಚ್ ಐ ಆಮ್
ಯಾವ ಪ್ಯಾರ?
ಲಾ SC ನಂಬರ್ 24/4/21 ನಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 15(1)(5) and 25. 25, 26. It is directly covered in this where the court can exercise the powers under 482 when the matters are taken up before the revision issues.
ಇದು ಮೊನ್ನೆ ಹಾಕಿದ್ದು.
ಅದರಲ್ಲಿ ಕೆಲವು ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಆಗಿದೆ, ಕೆಲವು ಕಡೆ ಇದು ಮಾಡಿದ್ದಾರೆ. ಕಾರಣ ಏನಂದ್ರೆ it is brought to the honorable court's attention saying that this is a situation where the parties are unnecessarily has to face as an accused before the court, when even though the commitment was not found on record. So thereby, it's a fit case exercise in section 482 also to discharge the accused person petitioner. I would necessarily laboring on that too much is not required.
ಅಲ್ಲ, ಯಾಕೆಂದ್ರೆ several judgments ನೀವು ಕೋಟ್ ಮಾಡಿದಿರಿ ಇಲ್ಲಿ. ಯಾವುದು ನೀವು now we have not brought to the notice of X. ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಯಾವುದು ಹೇಳಿಲ್ಲ, ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್?
ಮೂರು ಬಿಟ್ಟು 8, 9, 10 ಬಿಟ್ಟು ಬಾಕಿದಲ್ಲಿ ಪ್ಯಾರಾನು
ಹೇಳಿದಿರಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಆಯ್ತು, ನೀವು ಹೇಳಿದ್ರ.
You last time can you see 2009
ಡೇಟ್ ಹೇಳಿ, ಡೇಟ್
ಒಂದು ತಮ್ಮತ್ತಿರುವುದು 19/9/24 ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
2014 ಒಂದು ಕೊಟ್ಟಿದ್ರಿ, ಸ್ಟೇಟ್ ಆಫ್ ತಮಿಳ್ನಾಡು ವರ್ಸಸ್ ಸುರೇಶ್ ರಾಜನ್ ಅಂತ.
ಅಲ್ಲ, ನಾನು ಫೈಲ್ ಮಾಡಿದ್ದು 19/9/24. ಅದರದ್ದು ಬುಕ್ ತಮ್ಮ ಹತ್ರ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ? ಬಂಡ್ಲಿ ದೊಡ್ಡದ
ಇದೆ ಬಂಡ್ಲಿ ಇದೆ. ಈಗ ಮತ್ತೊಂದು ಬಂಡ್ಲ್ ಹಾಕಿದ್ರಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇದೆ ಸುಮಾರು ಸೈಟೇಷನ್.
ಅಲ್ಲ, ಅದರಲ್ಲಿ
ಇದೆ.
ಅದರಲ್ಲಿ ಬರೆದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೇನೆ. 3 ಬಿಟ್ಟು ಆ 3 ಈಗ ಬರೆದು ಕೊಟ್ಬಿಡ್ತೇನೆ.
ಆಯ್ತು, ಹೇಳ್ರಿ.
Sorry, 1 second, sir. I'm sorry. My learned friend produced several judgments.
ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ, ನೀವು ಹಾಕಿದ್ಮೇಲೆ ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ perhaps it is not abatement, there is no discussion at all. ಮೇನ್ ಇಕ್ವಿಸ್ ಮೇಲೆ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡೋದನ್ನ ಆ ರೀತಿ ಮಾಡಬಾರ್ದು ಹಾಗೆ ಹೀಗೆ ಅಂತ 227 ಕೆಳಗಡೆ ಹೇಳ್ಕೊಂಡು ಹೋಗಿ
ಮೇಡಮ್ ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಎಲ್ಲಿದೆ ಕೊಟ್ಟರು ಲತೀಫ್ ಕೊಟ್ಟಿರೋದು
ಕೊಟ್ಟಿದ್ದಾರೆ.
have submitted only,
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ
only 4 judgments.
ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು
ಅದರಲ್ಲಿ ನನ್ ಆಫ್ ದ ಜಡ್ಜ್ಮೆಂಟ್ ಈಸ್ ಪರ್ಟೈನಿಂಗ್ ಟು 109.
109 ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ
ಅಲ್ಲ
ಅಲ್ಲ.
ಬೇರೆ ಮೇನ್ ಕೇಸ್ಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದನ್ನ ಅದು
ಹಿ ರಿಲೈಸ್ ಅಪಾನ್ ಓನ್ಲಿ ಮೇನ್ಲಿ ಸ್ಕೋಪ್ ಆಫ್ ಡಿಸ್ಚಾರ್ಜ್
ಹೌದು ಸರ್.
ಅಲ್ಲೇನ್ರಿ
Scope of discharge and exercising power under section 482. And the trial court has to look into the, whether the prima facie material to frame the charge, not for the case to convict the accused. The first judgment,
Right.
Lord,
Trial court did not see the material for conviction, only for framing of charge. Whether
Please.
sufficient material available
available
to
on,
proceed against him.
yes. The first, Lord, the transaction, for so far as transaction is concerned, Lord, the page number 180 of their petition.
Ah.
The documents they themselves produced indicating, Lord, the 25 lakhs was transferred in the year 2012,
25 or 20?
25 lakhs.
25 lakhs.
Lakhs
Ah.
to the medical college
Ah.
on 22/3/2012.
22/3/2012.
12. Lord, during the investigation, we collected the material, including the income tax returns of this petitioner and accused number 1. The volume number 4, 5, page number 3 is the income tax returns of the petitioner for the year 2012-13.
Volume number?
5, page number 66, Lord, only that page, Lord, I produced along with the memo.
66?
It indicates, Lord, income of the petitioner as 1,83,992.
His income only 1 lakh.
1,83,000.
Ah.
And for the year 2013-14 also we collected. As per that, income tax returns, Lord, is gross total income is 9,62,987.
For 3 years.
Please, Lord.
3 years, 9 lakh.
9,62,987 rupees. Lord, transaction in the year 2012. And both the year 2012 and 13 and 13 and 14, he did not disclose the amount which was lent to the accused number 1 was not disclosed. And even accused number 1 also confessed that he had borrowed the 25 lakhs from this petitioner. From his income tax returns also, this source was not disclosed. And Lord, the judgment which was relied by the learned senior counsel, Lord, in compilation, the first judgment, Lord, which was relied is at paragraph number 20, is no way concerned about the facts of this case. First, Lord, first judgment at page number 8. Paragraph number 20, what referred in the citation list.
Page number ಹೇಳಿ ಅವರು
Page number,
ಬಂಡ್ಲು ಕೊಟ್ಟಿದ್ದಾರೆ ಎಷ್ಟು
ಹೌದು, 8ನೇ page, 8ನೇ page.
8ನೇ ಪೇಜ್
ಹೌದು, ಫಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಅದರಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 20 ಅಂತ ಹೇಳ್ತಾರೆ.
paragraph number 20.
20.
It is in that sense.
In that sense, distinction between mere breach of contract and offense of cheating should be borne in mind. We have regard to the facts and circumstances of the case. Our opinion that the case, no case has been made out against the appellant to hold that he should face the criminal trial. And it is for the offense of 415 and the 482 exercising the power under 482. And ultimately, Lord, the petition was allowed. And how it is applicable to the present case is not there in that judgment. And second judgment, Lord, paragraph abatement is concerned, the page number, paragraph number 10, 17 and 18.
ಯಾವ page ಹೇಳಿ.
Page number 14, Lord. The abatement involves the mental process of instigating a person to aid the person to doing things without positive act on the part of accused, instigate or aid the commit to suicide. Conviction cannot be sustainable. The intention of the legislature and ratio of the case decided by the High Court is clear that in order to convict the person under section 306, there has to be a clear mens rea to commit an offense. It is also required to active act or direct act which lead to deceased to commit suicide. Seeing on no option, this must have been intent to push the deceased at such a situation that is to commit suicide. The 306 offense has been relied and Supreme Court so far as the ingredients of 306 are concerned. And the third judgment plot is again is no way applicable. That is plot third judgment, the paragraph 38. Page number 26. It is very relevant to observation has thereafter has been made by High Court in truthfulness of the statement and circumstance and documents of prosecution is not.
Which para you are reading?
38, page number 26.
38.
Page number 26. It is very relevant observation thereafter has been made by the High Court that truthfulness of the statement and circumstance and documents of the prosecution not questioned by defense, then the High Court has proceeded to consider the scope of 34 of section 34 of IPC as also the scope of section 47(2) of CRPC. The High Court then considered the scope of alternative argument made by the revisional court that the matter should be remanded for aiding new charge under section 111 of IPC, under section 442 of read with 111 and 113 of IPC against R.D. Tyagi and other accused who are discharged. Ultimately, High Court has rejected the argument and in our opinion, rightly so, even section 107 is referred by the High Court. In that, High Court has rightly come to a conclusion that the act of R.D. Tyagi, accused number 2 before the High Court and other respondent did not fall under section 107 IPC, as neither the 3 requirement under section 107 is fulfilled, even 3 Pradhan did not process the point of before us. That is, even again, it is an offense under section 306 and other offenses. And the next judgment, paragraph number 6 at page number 33. That is abatement to commit suicide. There, the court has held accordingly uphold the.
That is with regard to the giving of aid.
Yes.
Or committing an offense.
Here it is the case, my lord. The case was not attained finality. It is went up to Supreme Court so far as A1. And so far as A2 is concerned, my lord, still the matter is pending before the trial court. And other judgments also, my lord, the paragraphs are not mentioned. And 6th judgment is so far as delay is concerned. Delay in trial was held and the so far as other accused trial was not progressed. And on that ground, Lord, paragraph page next judgment is at page number 37. Pankaj Kumar was the state of Maharashtra. Wherein paragraph number 25. They did not mention the paragraph. It is paragraph number 25. It is true that page number 47.
47.
Though it is true that plea with regard to the inordinate delay in investigation trial has been raised before us for the first time, but we feel that at this distant point of time, it would be unfair to the appellant to remit the matter back to the High Court for examination of said plea of the appellant. Apart from the fact that it would be further protract already delayed in trial, no truthful purpose would be served to learn counsel for the state to very fairly stated before us that he has no explanation offer for delay in investigation and the reason why the trial did not commence for 8 long years. Nothing whatsoever could be pointed out for being established now. So delay was very attributable to the appellant.
Yes.
That is the ground, my lord. The other judgments are all, my lord, is not at all applicable. It is 306 offense. And the petition, writ petition copy, that is predicate offense was passed. On that ground, my lord, the PMLA was passed. That petition copy was annexed along with the judgment, writ petition copy. And the other charge sheet documents are also annexed. And the last judgment is, my lord, the coordinate bench has quashed the proceedings against A1. That was under challenge before the apex court. Now, my lord, I have placed the 4 judgments, my lord. The scope of the revision. When the charge sheet was filed, the trial court, while framing the charge, the parameters and while exercising power under 482.
Yes.
That is all the judgment of what I relied, my lord, so far as PC Act is concerned. Paragraph number, first judgment, my lord, I had mentioned it as paragraph number 13 to 17. In that case, my lord, number 10, having considered the reason given by the High Court and the grounds which are weighed by the High Court while discharging the accused, we are of the opinion that High Court exceeded its jurisdiction by exercising revisional jurisdiction and acted beyond the scope of 227, 239. While discharging the accused, High Court has to go into the merits of the case as consider whether on the basis of material on record, accused likely to convict or not. For that aforesaid, the High Court has considered in detail the transcript of conversation between the complainant and the accused. While exercising at this stage to consider the discharge application or framing of charge is not special judge that stage of framing of charge, it has to see that whether or not a prima facie case made out and defense of the accused is not be considered. After considering the material on record, including the transcript of conversation between the complainant and the accused, learned special judge having found that there is a prima facie case of alleged offense under Section 7 of the PC Act, framed the charge against the accused for the said offense. High Court materially erred in negating the exercise of considering the transcript of details and considering whether on the basis of material and record the accused is likely to convict for the offense under Section 7 of PC Act or not. As observed here and above, High Court was required to reconsider whether prima facie. Please, the next judgment plot, here also the Sessions Court has dismissed the discharge application and High Court has reversed at paragraph number 6 at page number 16. Then the Supreme Court has said, starts from Lord page number 19, paragraph number 14. This court, as opposed to judgment, has laid down the principle considered exercising the jurisdiction under Section 397, particularly in the context of prayer of quashing the charges framed under Section 228 of sought as an under, and parameters are held. Paragraph number 27.123. 3 is not High Court should not unduly interfere. No meticulous examination of evidence is needed for considering whether cases would be end for conviction or not at all the stage of framing the charge or quashing the charges. Another very significant caution that court have to observe that it cannot be examining the facts, evidence, material and record to determine whether sufficient material on basis of which the case should be end the conviction. Court is concerned primarily with the allegation taken on whole, whether there is constitute an offense. If so, if it is abuse process of court can lead to injustice. Quashing of charge is an exception rule of continuous prosecution. Whether offense is even broadly satisfied, court should be more inclined to permit the continuation of prosecution rather than the quashing of trial in the initial stage. The court is not expected to marshal of the record with the view of decide the admissibility and reliability of the documents or record, but it is an opinion formed prima facie. The revision court cannot sit like a appellate court, start appreciating the evidence by giving a finding out inconsistency of the statement of witnesses, and it is not legally permissible. The High Court ought to have cognizant to fact of trial court as dealing with
Let's
the,
see, continue on next witness.
and only 2 judgments.
ಎಷ್ಟೊತ್ತಾಗ್ತದೆ?
5 minutes I'll come.
5 minutes ಆದ್ರೆ okay.
Next judgment plot 2014, then is only 2 paragraph plot, page number, paragraph
Paragraphs ಯಾವ್ದು ಹೇಳ್ಬಿಡಿ, ನನಗೆ
20
ಓದಕ್ time ಇದೆ.
29 and 31 plot,
29
and 31, please.
and 31.
31.
ನೀವ್ ಎಲ್ಲೆಲ್ಲಿ ಟಿಕ್ ಹಾಕಿದಿರ ಅದೇನಾ?
ಹೌದು.
ಆಯ್ತು. Instead of reading
Yes.
next statement.
The last is really facts plot, last judgment plot, State of Tamil Nadu versus Sundar Rasu,
ಹಾ.
wherein paragraph 15 is the trial court observation, that is dismissal of the discharge application.
ರಿಪ್ಲೈ ಮಾಡಕೊಂತ ನನಗೊಂದು 10 ನಿಮಿಷ ಬೇಕಾಗಬಹುದು. ಇವತ್ತು ಮಾಡೋ ಈಗ ಐ ಮೀನ್ ಆಲ್ರೆಡಿ ಫ್ಯಾಕ್ಟ್ ಅಂಡ್ ನಾವು ಮತ್ತೆ ಪುನಃ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡೋದು.
ನೀವು ರಿಪ್ಲೈ ಕೊಡಿರಂತ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಹಾ.
Paragraph number 15, Lord.
Ah.
The trial court has rejected the application.
Ah.
Page number 59 alli. 59. That is so far as offense under.
Conclusion ಅಂತಿದೆಯಲ್ಲ ಅದು.
Howd, conclusion, but that is the trial court conclusion. And High Court has held at paragraph number 17. The grounds, the 17, page number 62 alli ಇದೆ.
62. ಹಾ.
Please. That 4.17.1, 2, 3 and 4 are the reasons assigned by the High Court
ಆಯ್ತು.
while discharging the accused. Then Supreme Court has interfered, and then the paragraph number 81. By considering the Sundar Rasu judgment plot, the preliminary inquiry, other things, and the High Court cannot sit.
Paragraph ಯಾವ್ದು ಹೇಳ್ಬಿಡಿ.
81, Lord.
81 ನಲ್ಲೇ ಯಾವ ಪ್ಯಾರಾ?
Page number 93 ಅಲ್ಲಿ, page number
93 ಅಲ್ಲ?
93, page number, paragraph number 81.
91. ಹಾ, paragraph number
81.
81.
Howd.
Ah.
The High Court acted completely beyond this parameters discussed above. The government power, the discharge of accused, the prosecution, High Court could be said to have done the role of chartered accountant. This is clearly exactly what is observed in Vijay Lakshmi case, as completely ignored that it was not the stage of trial, and considering an appeal against the verdict of trial. High Court has required to the material produced by the accused person, compared with the information, compared with the investigation agency, and pronounced the verdict, saying that explanation offered by the accused person deserved to be expected, applying the doctrine of preponderance of probability. The entire exercise has been justified on account of investigation officer as not taking to the consideration of explanation offered by the public.
In respect of scope of the discharge application and 482 scope.
Yes. Yes, Lord.
Yes, ಯಾವಾಗ reply?
Any day, convenient to the honorable court.
20th. Heard further arguments of petitioner counsel and also the counsel for the respondent posted for reply on 20th.
I'll answer it. Another judgment was passed on with today. I'll answer it next date.
ಯಾರು ಅವ್ರು ಕೊಟ್ರಲ್ಲ?
Our own ಕೊಟ್ಟಿದ್ದಾರೆ. That is, erroneously filed a revision petition and converted into 482. That was the observation Supreme Court. By one technicalities, once by mistakenly filed a revision petition and permitted
Conversion
how
for 482.
please.
Next. One next regular list.
List 1, pastor matters, number 2, Adi Narayan.
All the office objections have been complied.
ಏನು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೀನಿ.
PF ಕೊಡ್ಬೇಕಾಯ್ತಾ?
PF ಕೊಟ್ರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
Counsel submits that he has paid the PF fund, hence issue notice against R4. And counsel submits that, R3 application ಹಾಕಿದ್ರಾ?
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ ಸುಮ್ಮನೆ.
ಯಾವಾಗ?
ಇವತ್ತು.
ಎಲ್ಲಿ ಹಾಕಿದಿರಿ?
ಆಫೀಸಲ್ಲಿ.
Registry ಅಲ್ಲ?
Registry.
Counsel submits that he has filed application to paper publication against R3, D and E, and also R5, B and D, and hence registry is directed to put up the same.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀವಿ.
Of the same. ಆಯ್ತು ಬರ್ಲಿ ನೋಡಿ. This matter.
ಇದು ಮೆಮೊ ಆಗ್ತಾ ಇದೆ ಸುಮ್ಮನೆ. R3A
ಹಾ.
died. B to F are the legal heirs already on
The
record.
appellant would submit that R3A is no more and hence filed a memo stating that error.
B to F.
ಯಾವ B to F? R3 B to F.
R3B to F.
For the
Legal heirs, they were already on
layers of
record.
R3A na.
R3A.
But
Mother,
copy respondent ಕೊಟ್ರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಎಲ್ಲಿದೆ ಇದ್ರಲ್ಲಿ? And hence counsel for respondent is directed to submit regarding this memo. ಹೇಳಿ ಅವ್ರ ಇದ್ರ ಮೇಲೆ. This matter on ಒಂದು ವಾರ ಬಿಟ್ಟು ಕೊಡಿ.
2211.
2211.
41.
41.
My lord, I am for the appellant, my lord.
ಚೈತ್ರ ಏನು ಬೆಳಿಗ್ಗೆ ಯಾರೋ ಏನೋ ಮೆನ್ಷನ್ ಮಾಡಿರಲ್ಲ ಇದರಲ್ಲಿ?
Respond in this case.
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲರ್ ನೀವಾ? ಬೆಳಗ್ಗೆ ಏನೋ ಮೆನ್ಷನ್ ಮಾಡಿರೇನೋ ಬೆಳಗ್ಗೆ ಇದು ಅದೇ.
Lord, my
ಹೇಳಿ.
senior was not there, my lord, so I was asking for date.
Appellant counsel seeks time, counsel for respondent submits that already objections also filed on IAS and matter may be disposed of with a direction and hence appellant counsel is directed to submit with regard to the submission of respondent. List this matter on 2211. ನೋಡಿ ಹೇಳಿ ಅಲ್ಲಿ ಹೋಗ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸೈಡ್ ಮಾಡ್ಲಿ on merits. Next
42. HK
42.
For the appellant in this case.
For respondent in this case.
Both IAS are rejected. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
ಒಂದೇ IA ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು.
ಇಲ್ಲ ರೀ IA 1 rejected, IA 2 26 rule 10 of
ಅದು
rejected.
that they are not challenged there.
IA2
Challenge
That was filed by.
IA 1 ಮಾತ್ರನಾ?
ಒಂದು ಮಾತ್ರ ಆರ್ಡರ್ 13 ರೂಲ್ ಉಂಟು.
IA2 filed by me.
Huh?
Defendant filed
IA
IA2.
2 rejected.
ಹೌದು.
ಏನ್ ಚಾಲೆಂಜ್
ಅಪಾರ್ಟ್ಮೆಂಟ್ ಇಲ್ಲ.
ಆಯ್ತು.
Lord, Lord, kindly appreciate. Now, the plaintiff is.
ಯಾವಾಗ ಬೇಕು ಟೈಮ್ ನೋಡಿ 4:50. This urgency ಏನಿದೆಯಾ ಏನು?
Not a sought for injunction.
IA ಏನು?
Not to.
Alienate, not to interfere.
Not to interfere. Lord, kindly appreciate. The earlier suit filed by them.
Was there any earlier interim order in favor of?
No, Lord, in fact, they have filed a suit against me contending that there's a 3 feet passage.
ಈ ಸೂಟ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಏನಾದ್ರು ಇಂಟ್ರಿ ಮಾಡಿರ್ತಾ IA ಮೇಲೆ?
ಇಲ್ಲ ನನಗಿರ್ಲಿಲ್ಲ. ಅವ್ರಿಗಿತ್ತು ಇವನು ಒಂದ್ ಸೂಟ್ ಅಲ್ಲಿ. ಅವರು
ಸೂಟ್ ಬೇಡ ಈ ಸೂಟ್ ನಿಮ್ಗೆ
that was dismissed. Wherein the trial court held that.
ನೀವು ಹಾಕಿದ IA ನಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನಾರು ಇತ್ತೇನ್ರಿ?
ಇಲ್ಲ ಇರ್ಲಿಲ್ಲ.
ಆಯ್ತು ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಆನ್ 212.
212 ಬೇಡ ಸರ್, ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅವ್ರಿಗೆ ಬೇರೆ ರೋಡ್ ಇದೆ. ಡೆಸ್ಪೈಟ್ ದಟ್ ಮಾಡಿದ ಟ್ರೈನ್
ಮುಂದಿನ ಡೇಟ್ ಕೊಡ್ರಿ ನೋಡ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಇವತ್ತು ನಂಗೆ ಆಗುತ್ತೆ ಕೊಡಿ.
ಅರ್ಲಿಯಸ್ಟ್ ಡೇಟ್ 20th
ಮತ್ತೆ ಕ್ರಿಮಿನಲ್ ಡೇ ನಿಮ್ಗೆ ರೀಚ್ ಆಗೋದಿಲ್ಲ. ನೋಡಿದ್ರಲ್ಲ ಈ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಎಲ್ಲ ಬರೀ ಮಧ್ಯಾಹ್ನ ಎಲ್ಲ ಬರೀ ಅದೇನೆ. 27/11 for want of time. 43.
KR Krishnamurthy.
Not maintainable. Approach the concerned court ಅಂತಿದೆ ಇಲ್ವಾ? Appellant counsel absent, list this matter on 412.
44 ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
44 already urgent ಆಗಿದೆ. 45 ಸೋಮಶೇಖರಯ್ಯ ಹೇಳ್ರಿ.
The trial court held that, my lord.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಅದರ್ ಸೈಡ್ ಸರ್ವ್ ಮಾಡ್ಕೊ ಬನ್ನಿ. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
19th ಹಾಕೊಂಬಿಡಿ ಸರ್.
19th. Next Tuesday. ಸರ್ವ್ ಮಾಡ್ಕೊ ಬರ್ತೀರಾ?
ಮಾಡ್ಕೊಂಬರ್ತೀವಿ ಸರ್.
ಆಯ್ತು. Appellant counsel is directed to serve the copy of this appeal memo on the counsel appearing for the respondent before the trial court and list this matter on 1911.
46
Rajesh for appeal.
For respondent 3 to 6 months.
There is an urgency in this matter, my lord.
ಯಾವತ್ ಬೇಕು ಹೇಳಿ?
This week, my lord.
This week ಇಲ್ಲ, next week.
19th, my lord.
My lordship, senior is in Kalburgi, my lord, 19th.
19th ವರೆಗೂ ಇರ್ತಾರಾ?
No, my lordship.
ಮತ್ತೆ
Any other date.
My lord, there is an urgency in this matter, my lord.
20th ಬೇಕಾ?
Again, we need to file objections also for IA.
ಆಯ್ತು ಯಾವತ್ ಬೇಕು ಹೇಳಿ?
20th, my lordship.
20th. ಆಯ್ತು. List this matter on 20th. For one
Whichever
time.
is-
47 settlement. Kantaraja.
GM
Srinivas Reddy. Both counsels are absent. List this matter on 2012 RFL. ಕೊಡಿ settlement. 2911. 48. Rajana Lokesh. Matter ಯಾವ್ದು ಎರಡು one finding ಕೊಟ್ಟಿದ್ದೀವಿ.
ಇಲ್ಲ ಎರಡು ಬಂದಿದೆ. ಎರಡು ಬಂದಿದೆ.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕಮಿಷನರ್ ಮಾತ್ರ ಅಲ್ವಾ?
ಇಲ್ಲ.
ಅದ್ರ ಮೇಲೆ ಕೊಟ್ಟಿದ್ವಿ ಅದಾರ?
ಹೌದೌದು.
ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ಬಂದಿದೆ, ಸಿಗ್ನೇಚರ್ ಎರಡು ಬಂದಿದೆ.
ಹ್ಯಾಂಡ್ expert.
ಹಾ, ಎಕ್ಸ್ಪರ್ಟ್ ಎರಡು
But I have served the copy of the objections to the commissioner.
Objections ಹಾಕಿದೀರಾ?
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಹಾ.
I thought my lords, I'll give it, I'll serve it, file it in the register.
ಇನ್ನು ಕೊಟ್ಟಿಲ್ವಾ ನೀವು?
ಇಲ್ಲ, ಇವತ್ತು ತಂದಿದ್ದೆ.
The counsel for respondent submits that he has served the copy of the statement of copy of the objections to the commissioner report and going to file the same tomorrow in the office and hence list this matter on date ಕೊಡಿ. ನಿಮ್ದೇನ್ ತಕರಾರು ಇಲ್ವಾ ಅದಕ್ಕೆ? Objections ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್
ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಅವ್ರದ್ದು
ಕಮಿಷನರ್ ರಿಪೋರ್ಟಿಂಗ್ ನಿಮ್ದೇನಾರು
ನಮ್ದಿಲ್ಲ sir.
ಇಲ್ಲ.
My side there is no objection.
Submit that no objections to the commissioner report. List this matter
27/11.
on 27/11. 27/11 ಆಯ್ತು. Next
49 urgent 50.
50 ಇವೆಲ್ಲ ಡೇಟ್ಸ್ ಕೊಡಿ ಮೇಡಮ್, ಎಲ್ಲ ಡೇಟ್ಸ್ ಕೊಡಿ. ಯಾರು ಇದಾರೆ ಅರ್ಜೆಂಟ್ ನವ್ರು ಯಾರು? 50 ಯಾವಾಗ ಬೇಕ್ರಿ? ಎನಿ ಡೇಟ್ 4/12. ನೆಕ್ಸ್ಟ್ ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಮೇಡಮ್ ಎಲ್ಲ ಹಾಕೋಬಿಡಿ ಬೋರ್ಡು.
51.
ವಿಶ್ವೇಶ್ವರಯ್ಯ, ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಇಬ್ರು ಇಲ್ವಾ? ಬೋತ್ ಕೌನ್ಸಿಲ್ಸ್ ಆರ್ ಆಬ್ಸೆಂಟ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 4/12 ಆಗುತ್ತಾ ಮೇಡಮ್? ಜಾಸ್ತಿ ಆಗಿದೆಯಾ? ಎಲ್ಲ ಹಾಕೋದು ಅದೇನೆ. 52 ಹಾ 4/12. ವಿವೇಕ್ ಕೊಳ್ಳ 4/12.
Please.
ವಿವೇಕ್ ಕೊಳ್ಳ 4/12. 54 4/12. 55 already urgent. 56 4/12.
57.
4/12.
Appearing for respondents, my lords.
58
8. Sir,
ಕಾಮತ್
urgent
ಯಾರು ಬೆಳಿಗ್ಗೆ ಮೆನ್ಷನ್
urgent
ಮಾಡಿದ್ರು?
ಆಗಿದೆ.
ಆಲ್ರೆಡಿ 4/12. 59
Respondent Reddy.
respondent appellant ಇಲ್ಲ, appellant counsel absent, respondent counsel present. List this matter on 4/12.
60.
Viken Sharma,
I appear for appellant, my lord.
appellant counsel present, counsel for respondent absent. List this matter on 4/12 for want of time.
Respondent.
4/12.
61 appellant counsel present, counsel for respondent absent. List this matter on 4/12 for want of time. 62 Alva Srinivas Murthy, both are absent. List this matter on 4/12.
63.
63 Vardhaman Gunjal, MM Swami, both are absent. List this matter on 4/12.
64.
64 Nagabhushan, appellant counsel present, counsel for respondent absent. List this matter on 4/12. ಅಷ್ಟೇ ಅಲ್ಲ?
Partition, my lord. It is in, it can be disposed of. ಅದು
ಹಾ?
shares ಮಾತ್ರ modify ಮಾಡ್ಬೇಕು. Based
ಹಾ,
on ರೇವಣ ಸಿದ್ದಪ್ಪ ಕೇಸ್ ಪ್ರಕಾರ
4/12 ಇಟ್ಟಿದೀವಲ್ರಿ, ಏನು ಬರ್ಲಿ ಬೇಕಾ?
early
ಬರ್ಲಿ ಡೇಟ್ಸ್ ಇಲ್ರಿ, ಬಂದು ರೀಚ್ ಆಗಲ್ಲ, ಹಿಂಗ ಆಗ್ತದ ನೋಡಿ.
In serial number 70, I am producing the documents, my lord.
ಏನ್ 70?
The FSL report and the
ಈಗೇನ್ ಅದು ಆಲ್ರೆಡಿ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಅಲ್ವಾ?
adjourn agite.
ಏನ್ ಅರ್ಜೆಂಟ್ ಆಯ್ತು?
Again it will be because I was not present.
ಯಾವಾಗ ಅರ್ಜೆಂಟ್ ಆಯ್ತು?
27th, ma'am.
ಆಯ್ತು ಅಷ್ಟೇ ಅವತ್ತು.
Once again.
ಈಗೇನ್ ಮಾಡಕ್ಕಲ್ಲ, ಕೇಸ್ ಕರ್ದಾಗ ಇಲ್ಲ, ನೀವು ಅರ್ಜೆಂಟ್ ಮಾಡಿದೀವಿ, ಫೈಲ್ ಆಗ್ಲೇ ಹೋಗಿದೆ, ಈಗೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
Oblige.
ನಾವ್ ಇಟ್ಕೊಂಡಿರಲ್ಲ ಸರ್ ಯಾವ್ದು ಮೆಮೋನ, ಅವತ್ತಿಂದ ಅವತ್ತೇ ಕಳಿಸ್ಬಿಡ್ತೀವಿ. ಅಲ್ಲ ಹಿಂಗೆ ಆಗಿರೋದು, ಅದೇನೋ ಇದಕ್ಕೋಸ್ಕರ ಹಂಗಾಗ್ತದೆ, ಇಲ್ಲಂದ್ರೆ ಇಷ್ಟು ಲೇಟ್ ಆಗಿ ಹೇಳಲ್ಲ ಸರ್, ನಾನು ಆಧಾರ ಮಾಡಲ್ಲ.